The charges related to the indictment points to Young Thug's rap lyrics as well as social media posts as evidence. Meanwhile, Young Thug's attorney maintains that his rap label is not a street gang. The rapper's attorneys, they have also filed a motion requesting an expeditious hearing for a judge to consider giving the rapper bond. Videos were listed in great detail by Fulton County authorities. Lyrics such as, "I never killed anybody, but I got something to do with that body." The indictment also tied the rapper to the murder of Donovan Thomas. That's the leader of a rival gang, pointing to lyrics which state, "I killed his man in front of his mama."
Okay. This is Demekion Garlington speaking with DeMarco Boyer.
Okay.
I actually think that this call, the strongest reason for its admissibility is a non-hearsay purpose, because they're discussing, we got to take Buddy's name off that. Because if that individual, they're talking about a song where someone's name's in it, and they literally say, if he gets whacked, you know that stuff's going to come down on us. I don't need nobody trying to put a RICO on me. And then references putting their names in the song. And so a big thing of this, not the thing, but a aspect of this case from opening until present day, is the state using social media, using lyrics, using just statements of co-conspirators. And, you know, the state and defense have different theories of what those things mean, but the fact that they're conscious of what they say and put in a song in direct relation to something that can happen in the real world or in the streets, so to speak, is very relevant, because the state's theory is that there is kind of a double entendre, or it's kind of like a line of how far can you push it in terms of street gang members know what you're talking about, but the police can't use it against you.
Now, using lyrics and social media posts could present a challenge for officials, and that's according to 11 Alive's legal expert. But District Attorney Bonnie Willis says her office can indeed use the music as evidence. Take a listen.
And here we go.
I believe in the First Amendment. It's one of our most precious rights. However, the First Amendment does not protect people from prosecutors using it as evidence if it is such.
Keep telling yourself that, dog.
Yo, yeah. I'll try to shoot that rhetoric today. It's a good day. Hey. But I ain't gonna lie, we got the time. We gotta take Buddy's name out of that shit though. We got to. You know, if bus fuck around and get wet, you know that shit come down on us. Yeah. Type shit. Then they already. The nigga Young Bruce so hot on the east side right now to me. They like, I don't know if they trying to build a case against niggas or what. Like, you feel me right now. But they hot as fuck. Like, they jumping out, just laying nigga down about them nigga. That's why they was so hot up and down the script the other day, got on Glenwood the other day. That's why they was been around nigga fast. So they last come 2 days to us. Oh, I ain't need nobody trying to build no RICO on me. Mm-hmm. You know what I mean? So it's like,
able to get a quote on this one? Yeah, like the estimate.
so it's also shit like, I'm just not thinking, Lil Head was even saying the same thing. He was like, shit, but I was gonna tell y'all nigga this shit, bro. That y'all probably say bro name, bro, cause his ass finna be gone. And even if y'all drop the song now, he get gone, gonna look like somebody had something to do with it. We drop the song later. I mean, you know what I mean? Yeah, you damn sure right. We just gonna take the nigga name like this shit. We just gonna take, I ain't even scared, shit still fuck me, nigga. You feel me? Just some smart shit, cause I don't think them niggas will put a song out there without, well, at least we just switch it up. You feel me? Mm-hmm. Even if we say that, like, we don't be Leaky for D, get a Shell, say something different. Like, you feel me? Shell got that, Shell don't want that, or some shit. You know, I don't give a fuck, we say the same thing. I don't give a fuck about saying name. But I don't want to, you know what I mean? Tie shit in. Yeah, they do it. Tell them all. I don't think you're get up and shit anyway.
And Your Honor, you heard they're talking when they say the line has something to do with Shell, and it's the state that they're talking about, Shell Kell, who comes up repeatedly in this case, and is someone that YSL has been trying, there's violence from January of 2015 until this call was made March 29th, 2022. And so Shell Kell's name comes up repeatedly throughout. And some of the social media I'd referenced about disrespect when individuals get murdered, Shell Kell's social media posts are a part of that will come up in Shamel drinks. So that's why the state wanted to play this portion is really for the non-hearsay purpose that they are thinking through, they've discussed the lyrics and how it can impact literally the police because they're like, if he gets killed, it's going to come back on us. They're going to look at us. So we need to take his name out. So that's why the state wanted to introduce that.
Okay. Anything from the defense on this?
Well, if I am not mistaken, it's being offered as non-hearsay. And if it's offered as non-hearsay, it's not offered for the truth of the matter asserted. And therefore there needs to be an instruction saying, you can't consider this conversation for the truth of the matter asserted.
So I am a little puzzled as to that issue.
And Your Honor, I guess I started with there's really two arguments, as sometimes there is, in terms of if they put this individual, it's also a co-conspirator statement in terms of they're strategically trying to make sure that they don't get in trouble for releasing a song when they're trying to kill this individual. So the fact that he's like, you need to probably take his name out, that does move the ball forward in terms of the conspiracy because the conspiracy does not want to get caught. Because if it does, it can't continue as well. And so there's that aspect of this as well in terms of they're strategizing about it's a good line, but it's too, when he gets murdered or if he gets murdered, it's going to create a police involvement with us. And he's trying to get him to not release the public song with his name in it.
That one, there was a violation. Personally, I wouldn't have it.
With the purpose to further the conspiracy by not getting caught. So there is it's not an either or. Sometimes there can be multiple purposes or theories. And I think that's appropriate with this specific call.
Okay.
I think they're saying, let's not commit a crime. I mean,
I think they're saying let's not provide easy evidence to inculpate ourselves. I'm going to admit that under the co-conspirator exception. There's no crime in releasing a song.
Crimes. RICO is a tool that allows a prosecutor's office and law enforcement to tell the whole story. And so we use it as a tool so that they can have all the information they need to make a wise decision.
The DA's office used similar evidence against Young Thug, Gunna, and members of the alleged YSL gang and the May indictment of the rappers and 25 others. Legal experts' opinions differed on whether rap lyrics can be or cannot be used as strong proof of crimes.
I would definitely say it's been a big change since that DA has got in office. You know what I'm saying? But like I say always, man, I feel like us as rappers, man, we really got to watch what we put out there because, I mean, as in lyrics, like you just said, if I'm talking about gang, I mean, shoot 'em up, bang, bang music in my songs, what you think gonna be? Well, what type of crowd do I think gonna be at my shows? Or what type of crowd do I think that I'm gonna, get the attention of? So it's almost like you get attention from everywhere, not just it's gonna come from everywhere. So you just gotta be mindful of what we say, man. And oh yeah, I'm from the hood, but I don't gotta rap about what's going on, and I could just rap about the hood from my perspective of it, and just give stories and just put you on game. Well, I ain't trying to go back there. I don't even but I can still make you feel pain music without having to rap about that. You feel me? I'm just trying to rap about some everyday situations, man. Stuff that you can relate to. Everybody can relate to shooting no gun.
Hit that light for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that light for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that light for deal with Christian.
It was me, Jack Daniels, and my honey Jim Beam. We were kind of blitzed.
Homie.
Thank you, Your Honor.
Now-
Would you like to perform it? Because I know that you're famous on the internet for your rap lyrics.
That's other people pirating me. Okay, so.
I know a good copyright lawyer.
All right.
But here's these drinking songs are not brought up against him. Next, please. This is the last one I'll do. Tim McGraw and Kenny Chesney charged with disorderly conduct, and McGraw is charged with a felony for assaulting a police officer in 2000. And I believe this is a Chesney song that was released before then. It's a great song. It's the simple things in life, like the kids at home and loving wife. I'll just jump to the end. The devil takes your hand and says, no fear, have another shot, just one more beer. Next, please. Last. This is not a song, but it's a statement of frustration from a singer and a songwriter. That's the frustration that I bet all of the defendants in this room feel. David Allan Coe wrote the most racist, offensive country music probably ever recorded. Released them on underground albums. I am a songwriter, you know, and to me, it has always bothered me that actors in the movies can say whatever they want to say, kill people, rape people, and do things that no one ever accuses them personally of being that way. But when you write a song and then all of a sudden you're being accused of something, to me, songwriting is painting a picture, and all you have, this is important, all you have to work with is words. That's all they have to work with, words. It's stereotype stuff, and he's talking about the racist language he uses. It's stereotype stuff that you hear growing up that immediately puts a picture in your head. What Mr. Kendrick is singing about is what he grew up around. What else is he supposed to sing about? He's not going to sing Daydream Believer. He's not going to write that song. He's not going to write about puppies and rainbows and unicorns. This is what he writes about. And now it's being dragged out, and he has to sit in this court and defend. He knows he has to defend these charges, but to have to defend the lyrics that he's writing? Come on. Come on. Gosh, thank you. That's enough. You can turn it off. Anyway, I'll be happy to circulate this later.
If you'll send a copy of that to your colleagues and Ms. Weaver, please.
Absolutely, Your Honor.
That'd be fine, sir.
Okay.
It'll be D1, as I said.
Thank you. Your Honor, in instances where courts have admitted rap lyrics, it's all about the connections, as you've heard today already. Look at Wilson v. State. That is a case that the state has cited. Wilson v. State, 315 Georgia, 728. It's a 2023 case. And in that case, the Supreme Court of Georgia said, sure, you can let in this rap video. That's appropriate. But let's talk about the rap video that was admitted, which you didn't hear about. It was shot 11 days after the robbery and murder at issue in that case. And what's it show 11 days later? The defendant's flashing a gun that could have fired the bullet recovered from the victim's body, and singing about hitting his first lick. In other words, committing a robbery. So the court said, well, given the probative nature of the video and it not being unfairly prejudicial in light of its probative value, then according to Wilson, the video being admitted was proper.
What was it admitted for the purpose of?
I would have to pull up that case.
If you can tell me. If not, I'm going to pull.
I can't tell you right now, Your Honor.
Now anyway, so.
But I believe it was admitted for evidence of guilt, but please let me get back to that. This case is different. Oh, did y'all put up the bodies on bodies line over there? There we go. Hey, how you doing? I'm Yak Gotti. I got bodies on bodies. Okay. When Yak Gotti is rapping that, first of all, he's not rapping about killing people or allegations relating to or the tragic death of Donovan Thomas. He's not rapping about that. What's he rapping about? What is this young guy rapping about? He's rapping about sleeping with a bunch of women at the same time. Or maybe not. Maybe that's not it. Maybe he's rapping about when he was a high school football star over at Grady. And he was laying people out on the field, bodies on bodies. He's not rapping about a murder that happened 11 days before the song was written or performed. He's not flashing guns capable of firing bullets found around Donovan Thomas or bragging about committing his first murder. So it's a different situation. You know what's more analogous is U.S. v. Stevenson's 550 F sub 3rd 1246 from the Middle District of Florida in 2021. The U.S. attempted to introduce 3 rap videos against the defendant charged with possession with intent to distribute marijuana. In rejecting the admission of those videos, the court said there was no evidence as to when the lyrics were written, the songs recorded, or the videos edited. And they concluded that the videos were too remote in time to have much probative value, or were even of dubious probative value in this case. Where's the evidence of when these lyrics were written and recorded with respect in time with respect to these underlying allegations? I don't see it here. I don't think it's been presented to you today, but I will tell you, and I'm going to go through the 6 specific lyrics. I'm not going to take much time, but I'm going to go through the 6 specific lyrics that they want to introduce, or they've said they're going to introduce against Mr. Kendrick. And you'll see that they're too remote in time.
So you're saying that reference is something, 2 other things that potentially Mr. Kendrick was involved in, playing football or getting with ladies. Is that what you're saying?
Here's what I'm saying. That unlike our United States Supreme Court that thinks they're experts in history, I think that courts are experts in law, and that they shouldn't get into the business of musicology and trying to figure out what that rap lyric wrote when Mr. Kendrick wrote it or performed it.
Okay, well, let's go back to Wilson.
Sure.
Wilson, the dope video that's referenced in there, it references the murder weapon. It connects the murder weapon and implicates one of the defendants in the
Absolutely
close in time. So I don't know what this particular thing is going to be tied to, but one of the state's theories is, as mentioned by the state, is that bodies on bodies is that he's been involved with some homicides.
Okay, so I don't know about some homicides, but he's accused of one in here. But the bodies on bodies, let's see when that was released. I'm going to look to that real quick. So I have it here. 2013. That was from Dream, released in 2013. And there's a distinction, by the way, between when something is written, when it's recorded, when it's released. But it's released in 2013. When is the Donovan Thomas murder? 2015. 2 years later. So what does bodies on bodies have to do with the murder of Donovan Thomas? Nothing. Nothing. Why is it here? It's here because it's prejudicial. The state knows this. That's why it's here. That's why rap music is introduced. That's why no other genre is introduced, because rap music is inherently prejudicial. I don't want a special exception for it. I just want you to do the 403 analysis, Your Honor.
So you're saying it doesn't have any linkage? Is that what you're saying?
0. If I could say less than 0, I would. No linkage.
Yeah, sure. Before I move on with that, hold on 1 second. I thought he released Dream. Is that what you're saying this song comes from?
Yes.
And that was,
Well, that's what the state says it's from, yes.
I
think
thought
they're
that was
correct.
released April 17, 2015. That's what I show on the state's page 43 of states 18.
I pulled this 2013 from the state's particularized motion.
Well, it's saying it's released on Apple Music April 17th of 2015. When was Mr. Thomas?
Recorded 2013,
But it was released April the 17th of 2015.
That may be, but if it was
When did the homicide occur?
January 2015. But if it was recorded in 2013, how in 2013, recorded, correct? How when recorded in 2013 did Mr. Kendrick know that Donovan Thomas was going to be murdered in January of 2015? Did he record it, keep it in his back pocket, and wait for the murder to release it? I think that's absurd.
Okay, all right.
You can take.
All right, well, that's one.
Oh, you're on? I'll go through them all.
That's one. Well,
I got time.
okay.
Let's do it. All right. I'll get there in just a moment, though, Your Honor. I'm not going to go State versus Skinner, up through State v. Skinner again. It's been beaten to death. But that's the New Jersey Supreme Court case that we reference in our briefs, where they basically throw out the rap lyrics, identifying with Bob Marley, and et cetera. But again, on the unfair prejudice, let's look at I'm going to give you a quote from Old Chief v. U.S., 519 U.S. 172, Penn site 180. As the Supreme Court has held, the term unfair prejudice as to a criminal defendant speaks to the capacity of some concededly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offense charged. That is exactly the risk, that is the danger of admitting these rap lyrics in this case. And look at Rule 404B. Introducing these rap lyrics, I think the clear intent is to show the character of Mr. Kendrick, and that Mr. Kendrick has a propensity to commit the crimes alleged in the indictment. Look at this evil rapper and listen to his words. They're terrible, horrible. Listen to what he says. What a piece of crap character he is. Who else would sing these songs? Who else would rap this music? Heaven forbid our kids hear that. That's not appropriate use. It's not appropriate use. I'm going to leave the state's other arguments right here to Mr. Steele. But I do want to go over the particular lyrics.
The rest of your lyrics.
Yeah, I'm going to go over the lyrics right now.
All right, let's talk about your lyrics.
Let's talk about lyrics. Let's go. Okay, back. I don't know if we'll just go one by one to make sure I hit them all. We've already talked about bodies on bodies.
Okay.
Okay. But again, what is the probative value of something recorded in 2013 to something that happened in 2015? It's got none. And I will not concede that Yak Gotti and Diamante Kendrick are the same person, just as I would not concede that Ian McKellen is Iago. You know, it's not the same situation. This is a character that he portrays on screen, in videos, in concert, but that's not Diamante Kendrick. Bodies on Bodies has multiple meanings. A convention of rap music, as I've been learning, is the importance of double and triple meaning. Finding double, triple, quadruple meaning is it's a critical skill to the lyricist in rap. And that's what you've got with things like Bodies on Bodies, multiple meanings. Let's assume, go ahead, Go ahead, assume bodies on bodies means dead bodies in the streets. Assume it means that. Whatever. 2013, Mr. Kendrick doesn't have any accusation that there are bodies on bodies there. And it's a convention. It's what his audience is looking for and demands in gangster rap. But it has multiple meanings. No proximity between the time of the recording of that and the unfortunate death of Mr. Thomas. If you let it in, there's a high risk that the jury is going to misinterpret that. And it will unfairly prejudice Mr. Kendrick.
Okay.
All right, next lyric.
On to the next.
I've only got 5 more, Your Honor.
Okay. All right. That's fine.
Next lyric, running from 12, then I jumped through the fences. Again, it's sung by Yak Gotti, his alter ego, you could argue, but it's his stage performance. It's his name on stage. And again, we've got ambiguous, multiple meanings. What is 12? Running from 12. Is it running around his neighborhood at the age of 12? He had a friend named 12 when he was younger. Is it running with his friend named 12? Or is it the police? Or is it all three? Or is it, as good artists do, is it up to the listener to decide what it means? Unfairly prejudicial. Lyric, I rep my life for real, for slimes, you know I kill. Take it to trial. Again, I'm going to argue that that's a lyric sung by Yak Gotti, the character, and not Mr. Kendrick. But regardless, I kill. Now I know I have said I killed it. I pray that when I walk out of here today and someone says, Doug, how'd you do today? I'm like, I killed it. I probably won't say that, but you never know. I kill refers to doing a great job when you're rapping in the studio. I kill refers to making money for the label. Multiple meanings. But the problem is, which one is the jury going to take? Next lyric. Excuse my language. Fuck the police, fuck them in a high speed from Slime Shit, March of 2016. Again, a lyric sung by Yak Gotti. It's a reference. It is a call out, Your Honor, to NWA with their famous song, Fuck the Police. It is social commentary. NWA sang it as social commentary. The character Yak Gotti sings it as social commentary. It's common. It speaks to so much in that community that I'm fortunate enough to not be able to really relate to, but what they deal with on a daily basis. But what is the jury, try as they might, and I know they're going to try hard, going to say when they hear fuck the police? One more, 2 more. Knocking off your big homie bitch, Mob Ties, April of 2020. Again, that has minimal value. And if you watch the video, and I'm sorry, I don't have it to play here today. If you watch the video, when Yak Gotti says, knocking off your big homie bitch, it is a call and response. Someone else says it, and then he repeats it. It's a long tradition in music. I mean, you can go back to Cab Calloway. You can go back. It was imported from Africa. Repeating things is a common trope, a common musical issue. And Cab Calloway, Michael Jackson, Missy Elliott, they all do it. They all repeat things. It doesn't mean he adopts them. He's in the video in a call and response situation. Last, YSL, wipe a nigga nose. Yak Gotti is in the video. He does not sing that. He is just in the video. And appearing in a video and nothing more should not be adoption of a lyric.
Well, do you have a choice to be in the video?
Well, do you? I mean,
I guess that's the question.
we all have jobs.
I guess that's a question that you know that the jury will have to kind of ponder, right? I mean, it's not like somebody's filming and they walk up and they catch you in it where they got to get a release. I mean, but to play it, but or to put you in the video, but you know, if he's standing behind or is one of the background people in that particular video or that song, isn't that something that the jury is going to have to sift out?
You know, I do not think you can go to look at what Kendrick is thinking or what he's adopting based on what someone else is saying in the rap music video that he's in. Yeah, he's there voluntarily. He's not chained there, but that doesn't mean that he adopts that.
Okay.
And I'm just going to go back to this, Your Honor. It is only rap music, and you have to ask, that has to defend this. It's only rap musicians that have to come into court. And don't tell me, anyone else, that it's because only rap musicians get in trouble with the law. That is not the case.
Not relevant for each case has to be taken on its own individual merit.
Exactly. And so when you see all these other cases cited where rap music is admitted, all that I ask you to do is make an independent assessment for this case on a lyric by lyric basis, whether those lyrics are appropriate to be admitted or whether they should be excluded under 403. That's all I ask the court, Your Honor.
All right, sir.
Okay, thank you.
All right. Mr. Steele? Okay, all right. Mr. Short?
Oh, I apologize.
We'll take 5 minutes. Everybody should take 5 minutes. We'll come back, okay?
Yo, hit that like for deal Christian. Yo, for deal Christian, smash that bell for the upsy. Yo, smash it, just smash it. Hit that like for deal Christian. For deal Christian, smash that bell for the upsy. Yo, smash it, just smash it. Hit that like for deal Christian.
They don't know what the lyrics are. These aren't like the old days where you have lyrics written on the label. This is just the listener. This is also not question and answer. When you say, hey, these are admissions, these are co-conspirator statements, these are statement against interest, this is not question and answer. This is somehow just different utterances that come together. It is not a fluid conversation. This is not like words that come because you say to me, answer this question, and I answer the question. Those words you can say, I meant what I said based upon this moment in time. We're talking about this topic. What the state is doing is what Mr. Weinstein said. They are just assuming things. And that is why they are targeting the lyric. It is not proof in and of itself. They are targeting the right to free speech, and that's wrong. And they are hiding it in, well, it's really going to an element.
They prosecute your clients because of the songs they wrote. I mean, they're using some of the songs, or at least attempting to prove other things that your clients may have been involved in, or their criminal for different elements that they're authorized to do. So I don't think that it's an attack on free speech.
How do you take something that is said to the whole world, goes around the world on the internet, and then say, well, it only means this, and we're going to use it, and then you say, dishonorable court, they tell you dishonorable court. That is not an attack on free speech.
Well, I guess
they have to tie it.
Yeah,
they have to tie it.
Okay, and I guess when the gang expert testifies, or that we get some more elucidation in terms of the jury, in terms of those particular things, that's something that the jury will consider.
Well, let me tell you, and it came up the other day with Mr. Matthews and myself, and I just happen to have it. This would go to intent, the mens rea. May I approach now?
Yes.
And Mr. Mr. Matthews and I objected under 24-7-704 A and B when Investigator Viverito was talking about intent. And what the court just said is the expert can talk about what the lyrics mean. That's intent. What the lyrics mean is the person who's speaking's intent.
But Mr. Steele, remember, an expert's testimony does not have to be believed greater than anybody else's. So it's just one factor that the fact finder is going to listen to in terms of that. It's not something that carries the day. As you know, from having tried scores of cases, that the jury usually gets an instruction about how they're to consider lay witness testimony and expert testimony. And they don't give any greater weight to that. It's dependent upon the circumstances. So that's why, unless it's a certain type of case, like when you're dealing with mental or the mental health or those types of challenges, that's why it can embrace the ultimate issue as to whether or not it's proven. But that's a jury question. That jury's going to decide that issue.
But the state can't even get in the evidence for actus reus or mens rea because they can't comment on the intent. And if you look at page 6 of 9 of the case I just gave us on court,
I'm looking at it right now.
It's Purcell, P-E-R-C-E-L-L versus State, 346 Georgia Appeal 219, 816 Southeast 2D 344, 2018. On page 6 and 9 on the left-hand side, almost center, failure to make objections in Division 1. The failure to object to testimony that evidence was consistent with collision being intentional. Purcell argues that trial counsel was ineffective for failing to object to several instances of law enforcement witnesses testifying that the evidence of the collision was consistent with it being intentional because the testimony was improper expert opinion on the ultimate issue. We find no reversible error. The new evidence code eliminates the former ultimate issue rule except as to certain expert witness testimony as set out in 24-7-704B. Under the new evidence code, except as to certain expert testimony, testimony in the form of an opinion or inference otherwise admissible shall not be objectionable because it embraces the ultimate issue decided by jury of fact.
Okay.
And then it says setting forth the lay witness's testimony regarding witness opinions and inferences. Going to the next line. As for
Oh, back up there.
There you go. Oh, I'm sorry. Let me finish
You
that
got to
line.
give Mr. Carlson
Okay.
and his father their due. Okay, so
Leaving out
I mean,
Mr.
since you quoted them, so but yes, that's what the new evidence code.
No, let me finish.
authorizes.
And let's echo it. See also Ronald L. Carlson and Michael Scott Carlson. Carlson on evidence, 6th edition, 2002. The next paragraph. As for expert testimony, OC, and this is what, Your Honor, it's what we were objecting to. OCGA 24-7-74B provides no expert witness testifying with respect to the mental state. That's what we're talking about here. Or condition of an accused in a criminal proceeding shall state an opinion or inference as to whether the accused did or did not have the mental state or condition constituting an element of the crime charged or of a defense thereto. Such
I think
ultimate
that's
issue.
competency. Doesn't that pertain to competency, Mr. Steele?
Let's go just one
Answer
paragraph.
my question. Does it go to competency? Those particular proceedings that go to competency? Yes or no?
No.
Because it's different.
It doesn't. The next paragraph.
I'm going to disagree about that.
Well, let's just read what the appellate court
I
says.
can read it. I can read it, Mr. Steele.
I'm just going to complete it. Contrary to the state's argument, the statute applies to all criminal proceedings, not
In which,
let me finish, not just those in which the defendant's competency is at issue. In criminal proceedings, expert witnesses testifying with respect to the mental state or condition of accused cannot.
okay, I agree with you.
But they can't
testify about whether or not it's an element of the crime. That's the jury's purview. But if it bleeds over into the issues that they're testifying to, they can't testify into a
mental state.
Into the mental state in that respect. But that's a jury question.
But yes, but what has the state been telling you? Our expert will say this is what that means. The court has said twice today, the experts of the state will tell you what it means. They can't do that.
But whether or not, but Mr. We're going to disagree about that. Okay?
They can't do that. That's what that case says. It's not just, as the court just stated and stated last time, that only goes to the mental state of a mental health. That is exactly why I used Purcell.
or a defense thereto, because such ultimate issues are matters for the trier of fact alone.
Because
It
intent,
only applies to expert witnesses.
because intent,
It forbids experts from expressly stating a conclusion that the accused did or did not have the requisite intent. So that has nothing to do with whether or not there's a particularized phrase or element phrase or some other type of issue that the state's attempting to approve. It doesn't. I don't think it applies to the way you're interpreting the mental state.
if we just go slower, the state's experts cannot, if they're qualified, cannot talk about anyone's intent.
They can no, they can't talk. They can't say like Mr. Williams' intent by writing this is blank. They can just say, okay, this song, if you look at it from the standpoint of what's been written, blank.
No.
Yes, they can.
No, that's you can possibly, if you let it in over objection, the jurors can make those determinations.
Yes, they can.
By playing the recording. You can't allow then the expert to say, and let me tell you what they were thinking, what this means.
No, I'm not going to let them do that.
Okay, well, then that knocks out the intent. Everything they've been saying is the expert's going to say.
Well, then how are they going to, I mean, intent's a part, I mean, the element is, they're still going to have to prove it. So,
Right.
I mean, they're going to play it.
That's right.
Or they're going to say, hey, in this particular particular song is being considered for whatever reason that you give it to.
And the jurors listen because anyone can listen to music. You don't have to be some
Expert.
That's right.
Yeah.
So, okay. But thank you, sir. So to continue on that vein, the state has not shown today, and I understand it goes to authenticity. I'm going to go back to First Amendment, but they have not shown who wrote the lyric, whether it was changed, when it was released, when it was recorded. That's another thing. Mr. Weinstein brought up something's 2013, released in 2015. The state hasn't said anything of when these items, any of the items. Mr. Weinstein said when it was written or recorded, but when was it really written? Was it written in 2010? Could you record something in 2013 or released in 2015? They have to prove that. And did Mr. Kendrick really want it to be? Is he under a contract where he has to perform in a music video? Mr. Williams is. He has to perform. He has to go to concerts. He has to sign memorabilia. He has to make himself public to take photographs. He has to do social media. That is all in his contracts. So for the court to get from the state that, hey, we just had this gang expert who I know you said they're not going to be able to say it, but the state thought it until a moment ago, to say what this means, and we'll just determine when it was released, and then we'll just link it up to any crime we believe.
They can't state an opinion or an inference as to whether or not the accused did or did not have a mental state.
No, they can't get into I'm not let somebody telling me why I said something. The jury can determine that. They don't need help. All right. So anyway, Your Honor, as the court probably knows, if it doesn't know, I will give this to you. I'll mark it as Mr. Do you have Exhibit 2 stickers? You have this. You want a copy? Thanks. May I approach, Your Honor?
You may.
I'll do whatever you tell me.
So this would be D2.
And Your Honor, again, we recognize rules of evidence don't apply here. We're just not stipulating the authenticity or veracity of the content of it.
All right.
Your Honor, I'll mark Mr. Williams D2. It is it's fascinating, actually. Race, Lyrics, and Guilt in America, Rap on Trial. It's written by the Honorable Eric, E-R-I-K, Nielsen, N-E-I-L-S-O-N, and Andrea, A-N-D-R-E-A, Dennis, D-E-N-N-I-S. May I approach?
You can. You can give it to Christina. I'll take that.
Your Honor, in this book, you will see, and everything's backed up by peer-reviewed articles. Hip hop is a more than billion dollar industry all over the world. It is the largest economic engine for people who come from depressed minority communities. It is hyperbole. It is filled with untruths. And it changed our world for the better. We now speak differently. We use words all the time like slime and slat. The word N is no longer.
Go ahead, Mr. Steele.
Okay. Fashion has changed based upon hip hop or rap. Gang signs are commonplace. At the Super Bowl, we had a well-known person in the hip hop industry making signs with his hands, signifying the Crips in the past several years. And that's okay because it's America. You can make a gang sign. You just can't commit some sort of criminal street gang activity. And now the state wants to use all of this economic brilliance of Mr. Williams and others in this trial, and the court should stop it. The First Amendment, Your Honor, is the difference in America than most countries. It's really what separates us. The religious freedom. I heard you say it when we started this process on January 4th. You told the jurors they have every right for redress, to say what they want to do. You took it on yourself. You said, be mad at you. Don't hold against anyone else. But you said, but right now, this is what we're doing. We all come here because we have a duty. And there's other people you talked about. It was beautiful. I mean, everybody paid attention. Who gives us that opportunity to be free? Your Honor, there's a number of cases.
Familiar.
May I approach, sir?
You may, sir. You have the ability to freely walk around the courtroom. You don't need to ask me.
Your Honor, the case I just handed to the parties in this honorable court is Rodriguez. I mentioned it earlier. It's RDRIGUEZ versus State.
We've heard of Rodriguez a bunch. So
Yeah,
what is it you want to tell me about
It's a
Rodriguez?
big case, 284 Georgia 803. If you look on page 2 of the copy I've given the parties, it's actually in our statute. It's in Division 1. Our highest court wrote, it's in Division 1, which on the left-hand side. See, 8th line down on the right. Consistent with this principle is the following explicit statement by the legislature regarding its intent. It is not the intent of this act to interfere with the exercise of the constitutionally protected rights of freedom of expression and association. The General Assembly recognizes the constitutional right of every citizen to harbor and express beliefs on any lawful subject whatsoever, to associate lawfully with others who share similar beliefs, to petition lawfully constituted authority for a redress of perceived grievances, and to participate in the electoral process. I am skipping the rest. I mean, I could read it, but I'm skipping to the last page, Your Honor, 7 of 7. It's in Division 4. It's on the left-hand side. Our highest court wrote, contrary to appellant's further contention, OCGA section 16-15-4A, as properly construed, does not directly or indirectly infringe upon the First Amendment right of freedom of association. The act of associating with compatriots in crime is not a protected associational right. To support a conviction, the accused must be shown to have conducted or participated in criminal street gang activity through the commission of an actual criminal act. Mere association is insufficient. OCGA 16-15-4A comports with due process requirements because it punishes conduct, not association. It does not unconstitutionally criminalize membership in an organization because the statute does not impermissibly establish guilt by association alone. Moreover, the right to association does not provide protection to those organizations that commit a felony. Criminal gang activity is not protected activity, even when committed by a group exercising a constitutional right to free association. In this case, Your Honor, what we have here is Mr. Williams' association with others is what the state is saying without committing an act. They are saying because he is singing about it, he is now part of a crime.
No, I don't think so. I
Yes.
think that they're using his particular lyrics for other purposes. They're not, like I said, they're not criminalizing the fact that First Amendment's not on trial.
What
It's
purpose?
not. It's not on trial.
But what purpose are they using for?
They're using it to show the issues that they're allowed to do by statute.
Specifically though?
By 16.
No, specifically. They are using his words to say he is a bad man.
No, they're
who
not.
is
They're
part
using,
of
they're
this.
using his words to show that he's involved in a gang in contravention of count 1 in this particular indictment.
But that's a general statement.
No, look, if it's for a particularized purpose,
If they can show particular, I agree. But they don't do that. They just come out and say, he rented a car that was used in the killing of Donovan Thomas. Do you realize that Mr. Williams is not charged with the crime of murder? It's in the indictment. They didn't charge him as a party to the crime. They separated that. They didn't even allege it as a predicate offense.
remember, Mr. Steele, evidence can be used for different purposes. It's not that they're using this. You're absolutely right. I can't show, you can't show guilt by association. You can be a member of a gang, and certainly, you can certainly say things, have opinions, be, prolific in written speech, acting, dance, and other things because they are protected by the First Amendment, but you can't do things that would be criminal in nature, and then because then they wouldn't be protected speech.
I agree with that,
Acts.
but that's what you have to do. So you have to go lyric by lyric and then link it up. And that's what the state did not do. They're giving you broad statements in the state, and there's others. In 303 Creative LLC versus Lenis, E-L-E-N-I-S.
But I mean, they're telling me how the statement or the particularized, the admission, the relevant portion, and is admissible against. Now, whether or not that is the jury believes that, or whether or not it's admissible under a threshold issue is what I'm asked to being considered today. They've still got to show foundation. They still got to prove, hey, you sang it, wasn't changed, it's attributable to your client, and then it's got to be admitted for a proper purpose. Well, he doesn't necessarily have to write it. He may adopt it, maybe a tacit admission. So it just really depends on the circumstance. So this is a preliminary threshold that they're asking me to look at. It's still going to be subject to, I would say, several objections or potential objections at trial.
Well, the first one is the First Amendment, and then I have a habit to this.
Just you. Why don't I just recess in place? Deputy Ingram? If they eat here, how long will it take? You got it? 8 more. Okay, good. Oh, good. Yeah, I mean, I didn't think it's gonna be bad. Okay, all right. All right. We're waiting on Miss, do you want to come back? Okay. I'm good. No, Coke would be good. Coca-Cola. Yeah, Diet Coke? No, I'll just take it. Take anything, Diet Mountain Dew. That's fine, yeah. It's fine, it's good. Here's Mr. Williams. All right, do we have everybody back, or is anybody missing? All right, Ms. D. Williams, you good?
Yes, sir.
Okay, all right. Okay, Mr. Steele, you can continue with 303 LLC, Creative LLC versus Atlantis.
That's 143 Supreme Court, 2298, 216 Lawyers Edition 2D 1131. It's a 2023 case. It was decided June 30th.
Okay, what's the caution on it?
This year.
Pursuant to the top of the case.
I don't know why.
Caution as of 8 November 2023.
That's when I printed it. I cannot tell you. I'll look at the caution. I mean, it's our highest court, so I'm not so sure.
303 Creative LLC versus Atlantis, ELENIS.
I will answer that question. I didn't even notice that. Thank you.
All right, so what do you want to tell me out of this case? What page?
If you go to the very bottom of page 9 on the right.
All right.
Our highest court wrote, the framers designed the free speech clause of the First Amendment to protect the freedom to think as you will and to speak as you think. They did so because they saw the freedom of speech both as an end and as a means. An end because the freedom to think and speak is among our inalienable human rights. A means because the freedom of thought and speech is indispensable to the discovery and spread of political truth. By allowing all views to flourish, the framers understood we may test and improve our own thinking, both as individuals and as a nation. For these reasons, if there is any fixed star in our constitutional constellation, it is the principle that the government may not interfere with an inhibited marketplace of ideas. If you go to the next page, Your Honor, which is 11 of 46 of the copy I've given this honorable court, and the parties on the left-hand side.
Page what?
11 of 46, next page. The left-hand side, the final paragraph.
This is the website cake matter that.
Yeah.
Okay. All right. It's not a criminal case though.
These are the principles of the First Amendment.
All right. Okay. But what are the principles of the First Amendment do you want to illustrate to me?
That's what I'm just taking their language. As these cases illustrate, the First Amendment protects an individual's right to speak his mind, regardless of whether the government considers his speech sensible, as well as intended or deeply misguided.
Okay, but this is criminal, okay? This is not civil.
No. This is the First Amendment regarding, it transcends criminal and civil case.
No, well, you can't just do anything. You can't just say anything and have the First Amendment protect you.
Well, of course.
So what specifically, I mean, because I don't need an education on the First Amendment, Mr. Steele. I went to law school like you. I've read the First Amendment. I have interpreted the First Amendment. So what specifically do you want to invite my attention to?
Well, this case specifically tells us how important it is what you're doing when you're talking about music. On the next page, which is 12 of 16.
12 of 46, you mean?
Yes.
Okay.
Thank you. On the left-hand side, the first full paragraph, 8 lines down, the last word on the right-hand side, all manner of speech from pictures, films, paintings, drawings, and engravings to oral utterances and the printed word qualify for the First Amendment's protections. No less can hold true when it comes to speech.
Mr. Steele, I don't disagree with any of that. So please, can we move on to something else? You are stating the obvious, okay? So can we move on to something, how this relates to why I should not, or why I should treat this particular series of lyrics under the First Amendment, tied to your client?
You have to do an analysis. The state is asking you on your.
What analysis are you saying I need to make different than Mr. Carlson told me? Let's just get to that.
On states 19, Mr. Carlson said you don't have to do a First Amendment analysis. It's a top bar.
I think it depends upon what type of statements as to whether or not I have to make a First Amendment.
That's what I'm saying. I'm advocating that you have to do a First Amendment analysis.
Depending upon what type of speech it is, correct?
Well, this is
correct, Mr. Steele? Is it dependent upon what type of speech it is?
It depends.
As to what analysis I need to make?
You have to make the analysis to then determine whether the speech is protected or not.
You got to answer my question, because not all speech brings a First Amendment analysis. It just doesn't work that way.
Well,
so tell me why, or tell me how you think that it's different in this particular circumstance. I'm not disagreeing with you, but tell me how you think I need to apply this First Amendment analysis.
You have to do it because we're talking about songs, art, and that's on page 20 or 46. What the court wrote. And that's why I'm saying the Honorable Court needs to go very slowly under the First Amendment first before you can get to any other statutory issues. Because if this is speech that is protected, you don't get anywhere else. So my point is that I disagree with states 19 that there's two lines. It's one line, but it goes through the First Amendment. They're not separate lines. And the state is trying to get you to ignore that you need to do a analysis under the First Amendment. And I'm advocating that you need to go lyric by lyric, video by video, to determine, and the state shouldn't be doing, oh, we'll just tell you some and we'll do others, because we're gonna have to do this during trial. Because these are protected until you say they're not.
No, they may not be protected, period.
But
that's the thing, Mr. Steele.
But how would you know? You make that determination. You're armed with these cases to determine what is protected speech. So you need to do that. Here's two other cases, sir. This is Counterman, Counterman versus Colorado. This was decided 3 days before the last case that we just talked about. 143 Supreme Court, 2106. 216 Lawyers Edition 2D 775, 2023 case.
Okay, and what's Counterman going to tell me? That wasn't always already cited in 303 Creative LLC. What different proposition do you want to tell me? And again, that will have another caution on it.
Yeah.
As of 7 November 2023.
Yeah, well, no, that's when I printed it, but there's a caution there. I don't know why there's a caution. It's the highest court and it was decided 5 months ago. 4 months.
So what is it you want to tell me about this?
So this is a criminal case, to answer your last question, which I don't think it's a difference without a distinction. But this is a criminal case. This is a stalking case, and this broke new law. Because now the U.S. Supreme Court, in a 5-justice majority opinion, said you need a mental state of the speaker. For the first time, and
what page does that show up on?
If you turn to page 4 of 42.
4 of 42?
Yeah.
Okay, all right.
The very top of the page, the last word on the first line, on the left-hand side. The question presented is whether the First Amendment still requires proof that the defendant had some subjective understanding of the threatening nature of his statements. We hold that it does, but that a mental state of recklessness is sufficient. The state must show that the defendant consciously disregarded a substantial risk that his communications would be viewed as threatening violence. The state need not prove any more demanding form of subjective intent to threaten another. And that's a stalking case. So what you have here is now you have to go in the rubric and you need all this information, which the state did not give you. What is going on at the time of the release of all these videos, of all of these songs? Because I'm saying that they're—
Okay, but wouldn't that be a jury? Wouldn't that be an issue that the jury's got to decide whether or not whether or not remember mens rea and actus rea. So did they, there's always intent that has to be proven with anything, and it can be proved by the state by direct or circumstantial evidence or both. So why wouldn't, it states the obvious, Mr. Steele, in terms of still requires that you have some, it says right here, do what you just read. So I don't have any disagreement with that.
But it's immune. It's immunized. That may not be the right word, but it's immunized. It can't come in. It's protected speech. It can't go to a jury until your court says this is not a true threat. And the state is using it for a true threat. They said to you today, these are threats by YSL. They are saying these are true threats. So you—
Well, no. They're using the line of whether or not whether or not it can be, just for the other purposes, if it's 16-14-4, 16-15-4, or any of the other intrinsic evidence statutes that apply to this case.
Yeah, that you have to first go through and say, is this a true threat? They are saying these are threatening words. We are telling people, don't mess with us. Ms. Hilton said, we're telling the world we're YSL. I'm the principal, and you could come in.
But I think that's different because you've got with the case you're giving now in Counterman. You got a stalking statute, right?
It's a stalking.
It's a stalking statute. So the statements that are here, they're saying that related to show his statements were objectively threatening. Also, he was aware of their threatening character. So that's a little different than what the state's trying to do or solicit, whether or not these lyrics are admissible for other purposes.
But they have to state why it's not a true threat. Excuse me, I said that wrong. Why it is a true threat. And I'm saying it is not a true threat case. None of these lyrics are true threats. Therefore, it's protected speech. And if you turn to page 17 of 42 of Counterman, this is the concurring opinion, but this may answer the court's question of why do you have to be the guardian before the jury that then gets to determine. It's on the right-hand side, the last paragraph. And it reads, the burdens of over-criminalization will fall hardest on certain groups. A jury's determination of when angry hyperbole crosses the line will depend on amorphous norms around language, which will vary greatly from one discursive community to another. Juries' decisions will reflect their background knowledge and media consumption. Speakers, going to the next page, whose ideas or views occupy the fringes of our society have more to fear. For their violent and extreme rhetoric, even if intended simply to convey an idea or express displeasure, is more likely to strike a reasonable person as threatening. Members of certain groups, including religious and cultural minorities, can also use language that is more susceptible to being misinterpreted by outsiders. And I stress this. And unfortunately, yet predictably, racial and cultural stereotypes can also influence whether speech is perceived as dangerous. And they cite Dr. Adam Dunbar and Dr. Kubin. Dr. Kubin hasn't been here yet for you, but Dr. Dunbar has. Threatening nature of rap music. So my point, to answer your court's question directly, like, why can't the jurors just do it? The court is telling you why
That's
they
what
can't
they're
do
saying, a jury's determination of it. I mean,
No.
crosses the line, but they still get that privilege of deciding that.
No, the point here is it protected speech? That's what the case, that's what I just read to you. You need to decide whether a jury gets to hear that evidence. And you only do that if it's not protected speech, if it is a true threat, if it is something that the state is saying, or is it just simply
Mr. Steele,
music?
I think it's two tracks. I don't understand your argument, okay? I really don't. It's two tracks. It's either First Amendment or it's not.
And you make that decision.
Okay. All right.
That's what we
Okay,
do.
all right. Okay.
But you have to make that decision.
Okay.
I hope I've answered that. I mean, your question just was right there. And what is a true threat? That's the next case, United States versus Bagdasarian, Bagdasarian. It's 652 F3rd 1113, comes from the 9th Circuit, 2011. And this is horrible. President Obama, Honorable President Obama, was elected president. It's on page 3 of 22. It's on the background on the left-hand side. On October 22, 2008, when Barack Obama's election was looking more and more likely, Bagdasarian, under the username California Radio, joined Yahoo Finance, American International Group message board, on which members of the public posted messages concerning financial matters, AIG, and other topics. At 1:15 a.m. on that day, on the day he joined, Bagdasarian posted the following statement on the message board. Regarding Obama, FKDN, he will have a 50 caliber in his head soon, end quote. About 20 minutes later, he posted another statement on the same message board, quote, shoot the N, country FKD, for another 4 years plus. What N has done anything right? Question mark, question mark, question mark, question mark, long term, 4 question marks. Never in history except Sambos, SAMBOS. This was found to be protected speech. Under the state's theory, they would say, well, that goes to mens rea.
But it's not, it wasn't prosecutable.
They prosecuted him.
Did they prosecute him?
Of course. He was convicted. He was convicted of 18 U.S.C. 87983. He was convicted. Your Honor, they go through the analysis. That's what I'm asking respectfully you to do. You are the person, you're the only person on this earth who can do this. And you need to do it this time because I'm asking the court respectfully. Jeffrey Williams, if you let this in, nobody should ever say anything to anybody else. Because the state of Georgia went through with all their resources and picked out little, they don't give you you have not listened to the whole song of any of these. You don't know the context. You don't know the next line. The words are good as the company they keep. The state is telling you this is mens rea. It doesn't, they can't say whether it's mens rea. The jury makes that determination. What they should be able to say is Jeffrey Williams told KC that he wrote the song about the killing of Mr. Thomas. That is competent evidence. That is the confession. That is the co-conspirator admission. That is the admission. But what they're doing is not that. The state is making the determination. Judge, we have these violent lyrics and we have these violent allegations. So therefore, we want to merge them together and let the jury decide. And that's exactly what the U.S. Supreme Court says cannot be done. Because that's not America.
Okay, and you're right. I have to let it. I have to decide whether to let it in, whether or not it's going to go for a proper purpose. So you're right about that. I don't have any issue with that.
Well, first, is it protected speech? And the state, my point, I sat here intently listening. There's wonderful people and lawyers representing the prosecution. They never gave you the information to be armed with getting it in. They need to bring it. I moved to exclude it as protected speech. I'm not asking for any category of, I don't remember what Mr. Carlson said, but it was far-fetched. I'm not asking for any somehow carve out. I'm saying that I would do it if it's a book writer or if it's a teacher. These are words. And the words in America get to be protected unless, of course, they're not. Now, certain words you don't even need to do First Amendment. If you're in like what you're doing now, and I answer questions directly, that's not a First Amendment. That's not my beliefs. I'm answering your questions. We're having a conversation. I said that. But when you're going into somebody's mental state because they're rhyming words to beats and making people feel good about them because they play them all over the world, that should not be interfered with unless the prosecution meets their burden to show it's not protected. So this is a great case about, is it a threat that Ms. Hilton talked about. The last case I gave you, Your Honor, which was the Counterman case, they have great about incitement. You know, when you're inciting people to do things, go out, I'm going to tell you this, go out and go to January 6th and go to the Capitol. Those are not protected speech. If it's to incite somebody to do a crime, I agree with that. I'm not trying to say that criminality somehow gets immunity because you said it in a rap lyric or you say it in any setting. I'm saying in this setting, in this case, without a connection, I think you called it nexus earlier, maybe not today, but earlier, unless there's some sort of direct connection to show, hey, this is the confession, that's the state's theory. So it should not be used. Your Honor, moving on, there is a trend here. What is going on across America is the trend. It is not fair for you not to be alerted to this. God bless you. In California statute, it's 352.2, admission of creative expressions. They passed a statute.
Mr. Steele, that's not relevant for my analysis. It really isn't. I mean, just because other states are doing whatever, I have to apply Georgia law to these facts and circumstances and the law as it relates to our highest courts that I'm required to do. The fact that another state may have enacted another particular statute is not really my consideration at this point in time.
I'll go fast, and Louisiana did the same. But how about the fact that there's a federal bill pending?
What does that have to do with this case?
You don't want to know that this has been attacked. These rap cases.
This is the case we find ourselves in at this point in time.
But don't you want to know that this is going on across our country and the legislatures got involved to say you need to do this analysis?
But they haven't yet. So I mean, I can't. So I'm not going to consider that because it wouldn't be proper for me to do so, Mr. Steele. I have to apply Georgia law to these particular facts and circumstances and those cases that are directly relevant.
Okay. Well,
so the fact that another state may be enacting laws that prohibit lyrics or the introduction of those is not of consequence for the case that I have right here. Yeah, it's something that other states are doing, but.
And the federal government, it's not done. I don't want to say they did it, but it's legislation.
Okay. All right. So anyways, all right. What else do you have?
Excuse me, I apologize for interrupting, but feed to the 8th floor is no longer there. And I know my client's family is unable to. There's nobody in 8. Well, I think because they came down here trying to get into this courtroom. The feed is up, but I think that should be well.
I think that.
I apologize.
Yeah, in fact, the feed's up right now. I can see it from here.
It just doesn't have it doesn't have the gallery judge.
Okay, all right, continue.
Okay. I'd like you to look at United States, and I'll email you this if you don't have it. I gave it to you, I think, previously, but it's United States versus Williams. It's in the district court, the District of Arizona. It is CR-18-01695 TUC-JAS. The district court adopted the magistrate court's order, so it is the district court's opinion now. And this went through exactly what we're talking about today. And in the discussion section, the court discussed the First Amendment. And then the court said that all courts recognize, I'm quoting, a significant concern with the admission of gangster, it's spelled Gangasta, rap music at trial, is that the lyrics present a serious risk of inflaming the jurors and influencing them to convict a defendant on impermissible grounds. They cite cases from across the country. Courts have also universally recognized that rap music features fictional imagery, metaphors, and exaggerated storylines. As a result, it is difficult to identify the probative value in fictional or other forms of self-expressive endeavors because it cannot be presumed that the author has acted in accordance with the views that he wrote about. Repeatedly, rap music can mislead or confuse the jury because it will become a feature of the trial and overshadow the acts giving rise to the charges. Thus, the risk of inflaming and influencing jurors to the point of compromising a defendant's right to a fair trial is a significant factor to be considered in determining whether to admit rap music. The probative value of rap lyrics is greatly reduced when it is unknown, and these are all the things we've been talking about, Your Honor. 1, who wrote the lyric? 2, when the lyric was written? 3, when the song was actually recorded and perhaps edited, and or when they were uploaded to YouTube or similar social media. In fact, the inability to differentiate between fact and fiction is intensified when the author of the lyric is not known. The government plans to explain ambiguous lyrics and not the individuals who wrote the song.
That goes to foundation. Wouldn't you agree?
Well, it's under 432.
No, but wouldn't it, I mean, if the states, and wouldn't that be subject to objection? I mean,
Yes,
yeah, okay.
I'm objecting.
No, I mean, when the evidence is presented, if they can't show who the person is that wrote, authored the song, and like you said, if it's been edited or changed and the like, and it doesn't fall within some other particular exception, it's foundation, right?
It's
I mean, I'm not. I mean, look.
Yeah.
Anybody worth their salt is not going to say, okay, hey, here's a snippet, and it's admissible. No, they've got to get in there. They've got to get in the other things that would lay the foundation for that.
I thought that's what we're doing today, though. They didn't.
No, this is a preliminary. The state's asking me for. Preliminarily. They've asked me, and if you look at what they've asked, Mr. Steele, they've asked me to apply Georgia's written evidence statutes as written, conditionally admit particularized lyrics, conditionally admit pending lyrics, and deny your defense motions. However, Mr. Carlson did mention earlier that, of course, this is subject to foundation.
But my motion is being heard. I have a motion to exclude. I raised all this.
Okay, yeah, but it pertains more so to the preliminary issue. And it's not that it's not going to be subject to other things. I mean, so, Mr. Steele, you'll still be given, depending on whether or not how I rule in this particular case, I still would believe that you would have some other objections if the state didn't lay an adequate foundation. I may be called to rule upon some, whether or not that's been properly met. But this presupposes that the state, can lay some other foundation as to the things you just aptly pointed out.
And get around the First Amendment.
Of course.
All right, and this, in the same case, Your Honor, from District of Arizona, they talk about, it's in Division 2.
Is this a federal case?
Yeah, Federal District Court from Arizona.
So it's for persuasive authority, correct?
Oh, yeah, it's every case that the state cites you except for Georgia cases.
All right.
And U.S. Supreme Court, yes.
All right.
In Division 2, the court goes through a very detailed analysis, which is what I'd like you to do under 403. We have a tremendous, this is not the case of.
What page is that?
69.
Analysis? Page 69?
Yeah, of 101.
69 what?
Of
101?
Yeah. I'm going to email you this if that's okay, and I'll email it for you.
Why don't you email everybody that, and I can take a look at it right now.
Okay, let me pull it up.
meeting to get this?
No, I'm not waiting, no.
Okay, because it's down. Has to be manually restarted from here by IT. Let's hear. Goes in around 7:20.
Who's upstairs?
All right, let us upstairs.
No, who's upstairs in the courtroom?
Oh, nobody. Ingram pulled it up these first.
You know what, tell Ingram they can just sit in the back of the courtroom. On that side, just let them, just, if they're not like 2 or 3 people or whatever, you got space for them. All right, Mr. Steele, did you email that to me already?
Yeah,
The internet.
yes.
Christina, I emailed you Mr. Weinstein's PowerPoint just now. I emailed you Mr. Weinstein's PowerPoint just now. Okay. 5 seconds. Okay. Do you have a copy of that case, Mr. Steele?
I have a written copy. I emailed it.
Mr. Steele, I'm not getting it right now, but do you have a Westlaw site?
No, I have the original site. You can get it from. But I have the site. Yeah, I have the site. What am I talking about? It's You want Westlaw? I don't see Westlaw in here, but it's 120. Oh, that's wrong. It's 2002. Well, I have a Lexus site. Is that okay?
I don't have,
You don't have Lexus?
I don't have a Lexus.
Okay. But the email should come through. And I sent it to Mr. Kern separately because I left him out in the first one. Did you get yours?
What is the,
Okay.
is that 543? Just give me the
Yeah.
citation, Mr. Steele. You said 5 what? 5?
No, he was talking about something else. It is, I have the Lexus site. They don't give on my copy, they don't give
All right, never mind, it came.
Okay.
What page, sir? What page is this analysis you're telling me that I need to apply? What page of 62 does it apply on?
Let me see, because it's a different format, but hold on one second.
Your Honor, there are 2 cases from a similar time period there under Williams from that same federal magistrate. I just want to make sure that the state is aware of which date case.
The one, yeah, there's.
It's the one you have.
The one that's undecided on December 9th, 2022, filed CR 18-01695-TUC-JAS parens EJM close parens. You're welcome, sir. What page, Mr. Steele, of 62?
I'm getting it right now, sir.
Mr. Steele, I think you cited this when one of your experts was testifying. So
I did. I think I gave you the case,
you
actually.
did give me the case. So yeah, I seem to recall it now.
It's on page, if you want to know, it's on page 37 of 62.
All right.
On the right-hand side.
I'm scrolling to that now. All right, I have it.
And that's what I discussed with the Honorable Court. And then what I was just discussing when you asked for the the case.
Where in this, where does the analysis or that you're referencing to that are you suggesting that I take it into account?
Everything, but it's under discussion, which is what I just cited you.
On what page, sir?
37 of 62.
I get it. Okay, I got it. Okay.
And then I skipped to the next analysis, which is just a couple of pages later, which if you look at, I discussed this on page 39 of 62, the very bottom right, the danger of unfair prejudice. And then what I was just discussing when we stopped is on page 43 of 62. And that's exactly where you wanted to hear about what I said, that I'd like you to specifically look at this. And that's when you said, show me the case.
Yeah, I've taken a look at Williams before because when your expert testified, you gave this to me already. And I think that the issue in Williams was whether or not there's some different facts, and your expert, was testifying to this particular agent's experience or lack thereof in interpreting rap lyrics. So that's part of it. And the other thing is the lyrics are heard differently based on the listener. I do remember that. The lyrics do not mirror or exhibit an unmistakable factual connection to the charged crime. So that's something that when I mentioned that nexus or other things that the state has to be able to prove. So it's
Email it to everyone else. Did you email it around to everybody? Can you email the two cases to the judge and everybody? Me too? Can you send me one? Send me both. Thank you.
Okay, the magistrate judge that wrote this opinion, it was adopted. I think part of the challenge was that the author of these lyrics was not known. Government wanted to use the lyrics as the defendant's confessions of the charged crime.
That's,
Lyrics were so highly inflammatory that there's great risk that the jury would convict the defendants for impermissible reasons and thoroughly missed the rap songs and videos. And then they used Agent Parkinson and Professor Nielsen. Had the potential to become a feature of the trial and overshadow the acts that give rise to the charges. And so they didn't think that this particular testimony was helpful to the jury. They thought it was going to be the judge wrote confusing and misleading to the jury.
that's 403. That's what I'm saying. And what the state said in their proffer, Your Honor, if you think it through, and it's in Division 2 of the page I just gave us on recording the parties, they said that they have they have recordings where Mr. Eppinger is calling people to ask whether Mr. Williams approves the killing of Mr. Bennett. They have recordings of Mr., and I forget his name right now, about killing Mr. Bennett, Mr. Myrick, about killing Mr. Bennett and asking Mr. Williams for permission. They have 191 overt acts. They have 191 overt acts. Do we really need to spend all this time on these videos and lyrics? And that is under Division 2 of the case, United States versus Williams, that we're discussing. And it's on page 43 of 62, and the court excluded the lyrics and the rap songs and the videos. And that's what I asked you to do. So it's 403, not only the prejudicial value substantially outweighs any probative value. We have the same issues that are lined up in Mr. Williams' case. And when I say that, not Mr. Jeffrey Williams, the case in Arizona, where we don't know the author, when it was written, the lyric, and what it applies to. And it's generic. These lyrics are generic. They're not specific, going back to the Second Circuit case of United States versus Carpenter that we discussed earlier that the state cited. And then, Your Honor, this will add great delay. When we have a trial introduced, these are a lot of lyrics. That means a lot of songs. The jury's going to hear all those songs. We have two experts on this. If to add to a trial that's going to take, my opinion, not going to be 3 months. It's going to be a year. That is going to be a substantial part of the year. So I ask you to evaluate it. If it even comes in, if it even gets through First Amendment protection, please look at it under 403 for that analysis as well. And that's what they did in the Williams case. That's why I gave it to you. And that was decided, as you said, December 9th, 2022, and then adopted by the district court. The next one, Your Honor, and it was emailed to you, I believe, by the Honorable Doug Weinstein. I asked him to, and I thank him. And that's Commonwealth of Massachusetts versus Gray, G-R-A-Y, I apologize. And that is 978 Northeast 2D 543, 2012 case from the Supreme Judicial Court of Massachusetts. And what the court held in that case, and you should have it on your email, is
I do.
Okay. And this is in Division.
What page of 17 you asked me to look at?
Let me get the exact page from the email, because the email is going to be different than. Okay. This will be, it's Division 3, and that should be on page, let's see.
Is that the rap video?
Exactly.
On page 14, bottom of the page.
Thank you, sir. And what the court said, if you turn, well, let me see here. To the paragraph that begins with, even if the video had contained direct statements. So let me find the page. Okay, it should be on page 15.
Yeah, I think in this case, there was no issue as to gang affiliation. In fact, the defendant was willing to stipulate to it.
Well, what they wrote.
Willing to stipulate to it, and the court, said, it shouldn't have been admitted because it was minimally, if at all, probative and highly prejudicial.
And
basically it said here that Evidence that poses a risk of unfair prejudice need not always be admitted simply because the defendant has opened the door as to his admission. The judge still needs to weigh the probative value and risk of unfair prejudice in terms of balance favors admission. So that's consistent with our law.
Okay, and then on page 16, with the state saying about their gang expert, it is,
That's a police officer
yep,
who's qualified as the expert without more.
yep.
Okay, so
Cannot without more be deemed an expert qualified to interpret the meaning of rap music lyrics. So that's why, again, I don't believe that the state's proffer is well-founded. And then the last case for now I'd like you to see, and this is also recent, this was decided October 20th, 2023. It was emailed to you. I ask the Honorable Doug Weinstein, God bless you. It's United States versus Donald, D-O-N-A-L-D. And that is,
I have it, sir.
2023 Westlaw 6958797. And this is the Western District of Connecticut. It was just decided. And I have to find out where in the email, but it's in Division 6 rap, music, lyrics, and video. And let me just find that. It's on page 20 of 32. It's Division 6 rap, music, lyrics, and video.
I got it.
And then on the 1, 2, 3, 4, 5, 6, 7th, it's actually on the next page. 7th, it's on the next page, the third paragraph. So it's on page 21 of 32. It starts with the issue of prejudice.
It doesn't tell me anything that Georgia doesn't tell me.
Well, I think it answered your question earlier. You said, what's the prejudice? The issue of prejudice with respect to the.
No, I didn't say that, Mr. Steele.
So you said that.
I did not say that. Okay.
Okay, no.
I understand what I need to do in terms of the prejudice prong. Okay. Under 403. I get it.
Okay.
I don't need any other cases from any other jurisdictions. We have plenty in the state of Georgia, which give me a lot of information on how I'm supposed to interpret that in terms of legal relevance.
Okay, I just like to highlight this.
Mr. Steele, please, let's move on to something else, okay? I don't need to cover 403, all right?
But I think yes, but under 403, that's what I'm trying to say. It is so prejudicial. It's just so,
You told me that at least 10 times already, okay? I get it.
Okay.
That, so tell me something else that I can use in order to determine whether or not it's a threshold issue, I'm gonna allow this.
All right. So next, if you don't mind, and it was emailed to you as well, you should see, and it was emailed to the state earlier today. You should see, it's entitled State of Georgia versus Mr. Jeffrey Williams. And what I did was go through what the state gave me. So I took the indictment and their motion. And what they said was the relevant information that they wanted to get in from the lyrics or videos. And I marked it. It's the same thing I emailed to you. Mr. Williams, number 3. May I approach you, Honor?
So I gave you permission to move out of the courtroom.
I'm not moving for the admission, number 3. It's a thumb drive, but it's what I sent to everybody. I sent it to prosecutors earlier today and the court just now. And
I'll consider, it'll be considered under 104 analysis.
So the first lyric, and you could read this yourself, but this is pretty spelled out. And With the court's permission, Ms.
You got four, it's a, for lack of a better word, just a chart. It's got the lyrics and the reference, a song and an album, the artist, and the video clip YouTube timestamp on it, and a link to thereof. Going from references from capo to big dog assist to wed rings and red bottoms to snitches, kill you, shoot up, clean kills, switches on our blocks, smoke you like a blunt, hose setup, drug reference, bodies on bodies, murderous wet blood, pistol gun, red bandana, head honcho, FN's Chapas, and that's Charlie Hotel, Oscar Papa Alpha Sierra, King Cobra, I'm the principal, boss, perfect leader, Sir Codeine, shoot you, anti-police, mixed red and green, syrup reference, not gang reference, run from police, killing cops, mob ties, red like Elmo, wipe a nigga nose, never killed anybody, but I got something to do with that body. I'm a general, shoot 100 rounds, shot his mommy, give the lawyer $2 million, throw your setup.
Okay, so these are the lyrics that are at issue. So I spelled them out for you and the parties. I took them from the state's motion and indictment. And the first one is from the motion, and it's number 1. And the lyric is, I was a capo in the hood way before a plaque or a mention. And we gave you, as you said, you could just click on it, the YouTube site for the video so you can see it yourself. But then I gave you how common these words are, this theme is. And if with Ms. Edwards' permission, if she can share the screen, Your Honor? Okay, the Zoom link ended. But Your Honor, if you just take some time and look at it, which I know you do. But the next one, underneath where I have the first one of Jeffrey Williams, and I quoted the lyric that the state wants, is Capo. It's El Capo album, Jim Jones. And if you click on it, you will see that other artist says similar things. The next one I quoted, feeling like Jim Jones, and I'm Capo, Money Man, did that. Next one, my other capo is in big A blank S conglomerate called Death Row Snoop Mother blank Dog. That's Toss It by Tupac. The next one is Capo Head Honcho on the song and the album Phoenix by A$AP Rocky.
Okay, but what does that have to do with, the state's not going to show me all these, or it's not going to hopefully show the jury, and hopefully you're not, these other particular songs, so they're not really relevant for the matter in question.
Aren't they?
Say again?
Aren't they though?
They're not.
The state is saying, Your Honor, these words are so particularized that they go to this crime.
No, they don't. You have to look at them in context, and they're also looking at it from the sense of whether or not Jeffrey Williams authored this, or and the other circumstances that go along with it.
Don't you think it's relevant that calling yourself a capo, that the state stood up here earlier today and said, I was a capo in the hood way before a plaque or a mention, and that means that it's organized crime. You heard all that.
Well, capo common meaning, they could certainly can mean the head or leader. And that depends on what a jury decides to give it in terms of meaning.
But if it's so prevalent in this industry, that's what I'm showing you. I'm showing you that it's sung about the same type of topic.
But the state's trying to say that it may go to Mr. Williams either being a leader of this particular entity. And if he's singing or rapping that I'm a capo in the hood, that might be something that a jury might find relevant to show whether or not he's actually the leader or not. They don't have to, but it's relevant for that particular purpose.
Well, then I'm going to show that every single other person who sings about that is commonplace.
But they're not charged with in the indictment. So it wouldn't be relevant for that.
Not particular. These are not like, oh my gosh, you nailed I'm just using Donovan Thomas. You nailed the shooting. He was shot from a drive-by on Saturday, the 10th day of January, 2015, on a near Northside Drive in Atlanta. That's particular.
Okay, but capo may be a word that if Mr. Williams is artist, okay, or that he uses in this particular song. And whether or not it has the meaning that would be relevant for admissible purposes in this case, is a separate issue.
But doesn't it mean something under the First Amendment analysis that a lot of people sing about that topic? In the
No,
same.
he's using a word. I mean,
All these people are using the word.
he's using a word,
All these people that I told you are using the same word.
but they're not charged in indictment in count one.
Exactly. That's the point.
But that's not that's not the point. The point is whether or not it's useful to show membership or leadership.
It's useful to show.
And you're taking it out of context. You're taking it out of context.
How's that?
Because you're pulling one word in a particular sentence that has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 words in that sentence.
That's what the state did. They
No,
picked out the word.
They're putting the sentence in terms of context. You're pulling out the word capo and you're saying, well, everybody else is rapping about capo or singing about capo. So that's protected speech.
None of those other words matter.
Okay.
I was a capo in the hood way before a black or a mention. They're using it because I'm saying I'm a leader.
Mr. Steele, I will give you that other people may utilize words that you or somebody that somebody else may also use in those songs. I'll give you that. But whether or not they're admissible or whether or not they go to a particular purpose, that's another thing. So that's for the jury to, if it's admissible as a threshold matter, the jury's going to have to decide whether or not, like in the first one, capo, whether or not that is attributable to your client being the leader or, leadership position or singing about that, hey, I am the head of this particular entity.
But Your Honor, I go back.
So that's definitely relevant in terms of what now, whether or not the jury decides that is another thing.
I don't want it to go to the jury.
Well, I know you don't want it to, but it may. I mean, it might.
I want you to exclude it because
I'm probably not going to exclude that one. I'm just going to tell you that because that goes to, for a number of reasons, it can go to show whether or not, as Ms. Hilton pointed out earlier about 4 hours ago, whether or not your client actually is the leader of this particular gang. Now, that's assuming also that we have attribution, authorship, and a foundation can be laid.
How about the First Amendment, though?
I don't believe the First Amendment is going to cover that one.
It's so unparticularized, and that's the whole point.
Okay, Mr. Steele, again, they got to be able to lay the foundation. If they lay the foundation, I'm telling you that particular one would be admissible.
Well, I don't know how it gets through the First Amendment when all these other people are singing about it, but I respect this honorable court. But that's what all this is. All of this, Your Honor, and D3 is for my consideration. But but in each one of those categories that the court read off, and that you have listed other songs about that or other references, like I said, I'm not saying that other people haven't rapped or sang or written about those particular lyrics, and and those particular individuals, they're not charged or referenced in this particular indictment. But their lyrics shouldn't be used against them.
Well, it depends on the purpose. Again,
you just have a lyric, a common everyday lyric.
Again, they're not punishing or seeking to punish or seeking to introduce and criminalize your clients, if it is your clients, artistic product under the First Amendment. They're not trying to do that.
I think they are.
And that has been the assertion by several folks that's what's going on. I'll admit or exclude this particular evidence based on the rules of evidence, not because it's going to be, First Amendment's on trial. If it does fall within the First Amendment, then I'll apply a particular analysis. If it doesn't, then I will look at whether or not it falls under the actus reus, mens reus, logical relevance, other offenses, 402, any of the 24-8, 801D2A, 801D2B, 801D2E, 24-8-804B3, and the intrinsic and the other statutes under 1615.3, 1615.9. And the last thing I will do is determine under 24-4-403 the legal relevance. And if it meets all those gates or the gates that are applicable to that particular statement, I will admit it. If it fails, I will exclude it.
All right. Well, I'm just going to then stop in place because I hear you clearly. I'd like you to look at one note, if you don't mind, on that same email. If you could just turn to page.
What page of D3, sir?
Should be 18. It's number 21, boss.
All right, hold on. 18 of 23, page 18?
It says 18 on the bottom of my copy.
Yes, sir. 20, and it's 20, it's the 21st reference to boss.
And the lyric that the prosecution wants to put in is, quote, "I'm a boss. I call the shots." If
Okay.
you allow that in, and Rick Ross on the song Boss said, "I'm the biggest boss that you've seen thus far." Meek Mill on "I'm a Boss" said, "I'm a boss." Bodak Yellow, Cardi B, the artist, said, "I'm a boss, you a worker." This goes on and on. What I'm trying to.
Okay, but again, they're not charged with anything in this particular indictment.
So is it that the First Amendment steps aside when a person's charged?
No, but it's contextual and it's fact specific, and it depends upon what they're trying to link it to. We're not bringing Rick Ross, Cardi B, Young M.A., Meek Mill, formerly Drake, or Post Malone in here to talk about any of those things, or they're not charged in this particular indictment. They sang about being a boss. If the state is trying to assert the reference, "I'm a boss, I call the shots," goes to a leadership issue, or "I'm the leader of the gang," well, then that might be relevant. But whether or not the jury decides to take that for the assertion and argument that they're making, that the state is making, is another thing. I am sure that you will probably examine or also make reference to these other particular artists, and whether or not they being the jury, finds that this is relevant for that particular purpose. Remember, we're not just saying, "Hey, Jeffrey Williams wrote about being a boss. That's not what the state's doing. They're saying that they're introducing this particular lyric for the assertion that Jeffrey Williams is the leader of this particular entity. Now, whether or not they being the fact finder, the jury decides that they wish to make that conclusion, they'll make that conclusion only after, if I admit the testimony and then I give them an instruction on how they're to consider the facts and the evidence they determine them to be, and they decide that, yeah, based on that, as part of the totality of everything that they've heard, beyond a reasonable doubt, then certainly they can come to that conclusion. They may decide, hey, no, he's not the boss. Just wrote a song about it. But the state's going to present other evidence, and whether or not that individual collectively shows that your client is the potential leader of this particular entity, that's for the jury to decide.
Well, under that analysis, then if Rick Ross is charged with being a leader of a criminal street gang, then his lyric comes in.
Well, no, not necessarily. It only if it's for a particularized purpose.
If the prosecution said he's the leader of the gang and that's what he said, then it's
well. If he says also, it might be an admission saying, "Hey, I'm the boss of this gang." They can consider it in terms of. They could consider it in terms of that. But
if you think that through what you just said, and I respect it, Your Honor, but then everybody who in this realm is performing music and saying those words can be used in a criminal case.
I don't think. You're going to have your opinion on that, Mr. Steele. I'm bound by what's been presented in this case. I certainly can't give you my personal opinions on it, but in terms of the states, I'm laughing because we're being timed out on a lot of stuff that my computer just decided to want to restart. So, so what I'm saying is that as much as you think that they're trying to criminalize or they're trying to admit statements that would be otherwise that may be classified as free speech, it's the analysis has to be one or the other. So
if assuming that that's it, then the jury will consider that for whatever reason that it's introduced. I'm just not going to let them introduce something just for shucks and giggles on that, just because your client wrote a song about that particular issue. It has to go to a particular purpose. My gatekeeping function is I'm required to do this. They're going to have to present the foundation as to it, and it has to go to an issue that they issue a proof that they have to at trial. They're not. I don't believe they're trying to say that because your clients wrote this song that he's a bad person or anything like that. I wouldn't allow them to introduce that evidence if that were the case. But sometimes, as you know, being an advocate, I do have to balance the 403 and legal relevance over prejudice, and that's one of the harder things I end up having to do as a jurist, but I got to do it. So, but the chart's helpful. It is.
And then finally, Your Honor, I'll move for the admission of Mr. Williams, number 4, dated today. It's a declaration of Adam Dunbar, PhD. And you've heard from him before. And that's his declaration. I already served it on the prosecution on November 3rd of 2023. Your Honor, if I did not move for the admission for purposes of this hearing of any of my exhibits,
I've already considered D1, I should say D1, which is Mr. Weinstein's, and you have D2 and this is D. Yeah, D2 is the book, and D3 is the chart on the thumb drive. This would be D4.
Your Honor, I have more, but I hear the tenor. I understand the court's statements, and I believe you understand my issues. So I will be objecting, and I don't believe the state met any of its burden that it did have to introduce these lyrics. I asked them all to be excluded.
All right. Mr. Carlson, Mr.
Fair to assume that Mr. Steele's arguments regarding 403, we kind of segmented this. Are they adopted by Mr. Steele?
Unless you want to be excluded, there I'm going to include them for everybody who they may be applicable to.
Hit that like for Deal Christian. Yo, for Deal Christian, smash that bell. For DWC, yo, smash it, just smash it. Hit that like for Deal Christian. For Deal Christian, smash that bell. For DWC, yo, smash it, just smash it. Hit that like for Deal Christian.
In 2015 for the murder of Donovan Thomas, based on the testimony of an individual who lied about his name to the police while giving my client's name. He was arrested with 3 other people. The state dismissed charges against 3 other people and now say those 3 other people are wholly innocent.
Well, Mr. Farley's still a co-defendant.
Mr. Farley's not charged in that murder, and he never was. But they dismissed the charges against the 3 other people that he was arrested with and realized they had no case against Mr. Stillwell either, which was the subject of my motion for speedy trial, constitutional speedy trial. So he was released on bond. He didn't beat the murder rap. He was wrongfully arrested and released on bond. And they admitted that they completely arrested the wrong people.
State's saying that particular admission is relevant for the following purposes: actus reus to show enterprise and gang affiliation, and then under the mens rea prong, state of mind, intent, motive, or knowledge.
He didn't say I killed someone and got away with it. He said he beat a murder rap. Paid my lawyer $30 for that.
They're saying that as it pertains to your client, it's a party admission.
So Your Honor, so I guess if I'm wrongfully arrested for a crime and then I write a book about it, I'm somehow admitting to committing that crime? That makes no sense.
Well, if you write a book about it and tell on people, tell on yourself.
He didn't do any of that.
State comes back and says, oh, by the way, he wrote a book about it, and we're going to introduce it against him. And we're going to let a jury decide whether or not it's a confession.
And if he said, beat a murder rap that I did with Johnny, Steve, and Billy, then I would tend to agree with you, Your Honor. He said I beat a murder rap, paid a lawyer for 30. That means he went to court, he got released. How that is an admission is beyond me. He's telling that he went to court. And it's,
Well, I mean, it's context as well, and it may be relevant to, and I think that's for a jury's consideration. The threshold issue is whether or not it meets either actus reus or mens rea, and under 24-4-401, it's logically relevant to some particular offense or element.
And
So-
it's not logically. It's
Okay,
distasteful. I think.
Okay, we're gonna have to. Okay, that's your opinion, and you're entitled to it. Okay.
Your Honor, going to court has nothing to do with committing a crime. Being falsely accused of a crime has nothing to do with committing a crime. He's merely saying he went to court, he's been released, he paid a lawyer for that. Now, again, I'm not going to ignore the fact that jurors might find this distasteful.
Because remember as well, it's relevant to also to show or potentially in count one. So
YSL has a history of being released on crimes that the state doesn't have any evidence of them committing.
The state's going to make their argument whether or not that a jury will buy that particular argument is totally up to them. Remember, they sift and weight the evidence. I give them the law that they'll apply the evidence as they determine it to be, and then they render a decision. And so we'll have to kind of wait on that.
Your Honor, I appreciate that, but you are a very important person in this process too. And I know I don't need to remind you of that. And I give you the utmost deference in that respect. You are the one that has to determine what the jury hears and doesn't hear. And putting a lyric that I wholly admit, if Mr. Stillwell said, Max, I got to consult you before I rap about this, I would say, hey man, that's a little distasteful.
But
People might not like that.
Distasteful is one thing, but rapping about something that might be a statement against interest, an admission, a confession, or some other thing that might get you cross purposes with a prosecution for a crime that may or may not have occurred. Well, that's another thing.
Your Honor, I just beat a murder rap is in no way an admission. It's in no way a confession to any crime. That's my whole point.
But it might be a declaration against interest, and
it's no way a declaration against
and it might be a party admission on behalf of your client.
Saying you went to court.
Okay, you said that 3 times now.
Okay.
So is there any other additional argument as to that?
Well, and then, Your Honor, the state also added that they wanted to bring in other things that my client allegedly said. And this goes back into what Mr. Weinstein was saying about his client and the timing. They say they want to use, I keep a stick, avoiding no smoke on that slime that they always talk about. And they said, well, the stick, that's relevant. He's in this video with Mr. Comarvius Nichols, and in 2022, he's accused of committing a murder of Mr. Shamal Drinks with Mr. Nichols, as well as Mr. Farley and Mr. Garlington. This as an admission has the same problem that Mr. Weinstein was talking about with Mr. Kendrick. This was recorded in 2009. My client is constrained by the laws of time like the rest of us. He cannot confess in 2019 for an alleged crime that was committed in 2022. That is an impossibility. To say that his mens rea is the same for 3 consecutive years is to truly treat the aspiring rapper SB.
So when did he make this song?
The state in their recitation of facts said 2019. I take them at their word.
Okay.
And I don't believe that to be false.
When did this particular incident occur?
March 14th of 2022.
Okay. All right.
So that would be So
That was the homicide,
2
the
to 3
purported
years.
homicide of
Shamal Drinks.
Jamel Drinks.
So again, to say that it's clearly not an admission. So, and to say it's his mens rea that's just static for 3 years because he's a rapper, I find is singling out. I'm very hesitant to just make these broad proclamations that rap music is singled out. But if we are treating rappers who are actually performing under stage names, if we're pretending that they are different than the rest of us humans and they have the same mens rea for 3 years and it never changes and we can always hold them to that, to things that we thought they were thinking several years before and apply that to a crime 3 years later, I think we are treating them different. And for those reasons, Your Honor, I believe that those are the only lyrics that directly affect my client. I do believe that, the state, I will yield to Mr. Steele to ably argue on behalf of his client, but I would ask that you rule that those lyrics that I discussed as performed by SB in 2019 as inadmissible. Thank you, Your Honor.
Yes, sir. All right.
Yo, hit that like for deal with Christian. Yo, for deal with Christian, smash that bell. For the up, see, yo, smash it, just smash it. Hit that like for deal with Christian. For deal with Christian, smash that bell. For the up, see, yo, smash it, just smash it. Hit that like for deal with Christian.
Mr. Stillwell is associating himself with being a slime, being a part of Young Slime Life, that gang, and I'll Wipe Your Nose, which is one of the signs that this gang shows their affiliation with this gang in Enterprise.
All right. Okay, we have other guests, I think, this afternoon. Mr. Steele, who do you have with you?
Your Honor, good afternoon. I have the pleasure of working with a young lady, Mr. Kendrick, Mr. Adams, Maggie, and Mr. Courtney, C-O-R-T-N-Y Edwards. We've been working together for years. She's part of the part of Mr.
All right, thank you. All right. Ms. Westmoreland, who do you have with you?
Good afternoon, Your Honor. We have Mr. Alaraki. He is attending Florida State University. He's in his third year.
All right, welcome. To the two of you, don't touch anything, okay? That's the only thing I'm gonna tell you. Just don't touch nothing, all right? Okay, all right. With that, we'll go ahead and get started for the afternoon. Okay, matter of housekeeping. Ms. Westmoreland, have you all finished your motion to particularize as of yet? I'm just inquiring about it. I'm not taking it up because I know I'm gonna take it up next week, but.
Absolutely, Your Honor.
Okay, all right, good. Thank you very much.
Thank you.
All right, if you would be so kind to send Mr. Kearns a copy of that so we can prepare if you haven't done so already. Okay, there you go. All right. So right now, I believe for at least for the majority of the afternoon, have a lyrics motion. And it comes in the vehicle of several things. There's a state's motion limited to admit evidence of lyrics. And there's a supplemental motion by the state of the same kind. And then there's an amended particularized motion limiting to admit evidence of lyrics at trial. And then there is filed by Mr. Kendrick an opposition to the state's second supplemental motion, second supplemental, and motion limited to admit lyrics at trial. So, Mr. Carlson, I understand you are arguing or going to pursue this motion. And then Mr. Weinstein, are you also going to be arguing that motion?
Yeah, Mr. Steele and I will be arguing.
Okay, all right.
Judge Van Look, can I be heard?
Yes, sir.
In actuality, Your Honor, we are going to divide some duties on this to make sure that the hearing is handled as expeditiously as possible. So with the court's permission, I will handle the initial argument, go through some of the areas of law, followed by case specifics with Deputy District Attorney Hilton. And then Mr. Floyd is going to handle some of the more specific racketeering aspects of this matter.
Okay.
So we, with the court's permission, will proceed in that fashion. Also, we do have a PowerPoint and some other visuals for this, Your Honor. We have got the PowerPoint being printed off. I'm looking to my left to see if it is here yet. There's a little bit of problem getting printed. We plan on providing courtesy copies to the defense. We plan on providing courtesy copies to the court, Mr. Kearns, and also tendering that as well, Your Honor, to make sure there's a record of exactly what was presented here.
All right, sir. Mr. Steele?
Your Honor, just for completeness, Mr. Williams filed a motion limiting number 2, motion to strike, and that deals with, it was filed on November 29, 2022 at 3:35 in the afternoon, and that deals with excluding social media, hip hop videos, song lyrics under the first 14th Amendment, corresponding section, Georgia Constitution, as well as listed GA section 24-4, 401, 402, 403, 404A. So that.
I think we can take that up in the same vein, okay? All right, okay.
Your Honor, just for the record, I need to formally go with Mr. Weinstein and Mr. Steele's motion.
I thought that we had the Harvey rule.
Specifically, Your Honor, the state, although my client is not a signed artist, the state has identified lyrics allegedly performed by my client.
Okay. All right.
Thank you.
All right, thank you. All right, Mr. Carlson, if you want to proceed at this point in time, sir.
Thank you, Your Honor. And I believe we have now copies of the PowerPoint, which Ms. Love is going to cheat us. We have the copies now for the court. Mr. Kearns, the remainder are coming, and we'll tender those into the record.
Okay. All right, sir. Thank you.
Permission to receive the podium?
Oh, go ahead, sir. Yeah. Yeah, they're coming.
Oh, okay.
They're coming. All right.
Your Honor, we're here today to cover the issue of admissibility of gang lyric evidence in the trial of this case. And the court provided a history of what some of the briefing and some of the motions were. This began essentially a year ago. I believe there were some earlier, if I remember correctly, and I know the folks who have been involved in this case will correct me if somehow I'm not completely accurate on this, but there were initially some defense motions to preclude this evidence. The state responded to those along with motion to admit, and to the court was very exact on that. Then the state delivered particular motions in order to make sure that defense would be on notice of at least some of the lyrics we plan on introducing at trial. So we take a look, Your Honor, at what exactly is the issue that's before the court in this case today. And that is YSL gang evidence admissible in a YSL gang prosecution. Because the question is not rap lyrics. The question is gang lyrics. And the question in particular, Your Honor, are YSL gang lyrics either coming as party admissions, either coming as adoptive admissions, either coming as co-conspirator admissions, or coming as declarations against interest for relevant purposes from YSL gang members and associates. So the issue here is not rap. This is not randomly the state attempting to bring in Run DMC from the 80s. This is not the state attempting to bring in some other type of lyric evidence. This is specific. These are party admissions. They happen to come in the form of lyrics, Judge. What we have from the defense here, Your Honor, are really two issues that the court needs to resolve. They have filed blanket objections. At this point, the state has not seen, or at least this assistant district attorney has not seen in the year or so this issue has been pending, any particularized objections from the defense to any singular lyric or lyric. In fact, the only lyrics that have been identified are the ones identified by the state. What we do have in this case, Your Honor, is a blanket First Amendment objection from the defense and a blanket pretrial Rule 403 objection on the basis of unfair prejudice. So ultimately, Your Honor, the issue for the court to decide legally here is whether there's a First Amendment bar to evidence of gang activity that appears through lyrics. And secondly, if the answer to that is no, whether or not Rule 403 somehow bars the evidence itself. Now, there is some talk in some of the materials from the defense about this being irrelevant. We're going to address all of that today. So now we take a look, Your Honor, at what we're going to address as we move forward here today. We're going to take a look at gang lyric evidence, First Amendment considerations, relevant purposes, controlling evidence rules, case-specific applications, and certain genre concerns. That'll come up throughout the state's presentation. So the state is going to proffer specific lyrics before you today, Judge, and it will be a smaller amount than was even in the state's notice. We're going to go through the statutes authorizing introduction and, of course, respond to the defense positions. On this, Your Honor, there are some template cases procedurally that are impactful here for us. And those, Your Honor, are up at the top, that United States v. Torres, which is cited in the PowerPoint, but I'll get it into the record. That's 433 Federal Supplement 3rd, 433 Federal Supplement 3rd, 35, 435 Federal Supplement 3rd, 526. That's the Southern District of New York case. And Your Honor, that case systematically goes through, in a racketeering context, the admissibility of co-conspirator hearsay. And that's, of course, what the bulk of the defendants here will face. It also, Your Honor, discusses the needs in order to serve notice on the defense. And actually, the state is here and stepped forward and provided lyrics to the defense in lieu of any specific objection. Now, those won't be all of the ones we're sure admitted at trial, but these are ones we wanted to bring to the attention of the court and opposing counsel this time. Also, there's United States versus White at the 2023 United States Lexus 122492 site, and United States v. Taylor, 2022 U.S. District Lexus 206008, and those are fairly recent cases. One is 2023, the other is 2022, and those cases, as well as Torres, Your Honor, discuss conditional admissibility. And that is what we are looking for here, Your Honor. This is not the time, obviously, for an ironclad ruling in terms of this will come in or this absolutely won't come in. What we're talking about here is conditional admissibility. The citations, again, I'll leave these up on the screen for opposing counsel, Judge, but again, they are coming in the copies of the PowerPoint, which I understand are en route. So Your Honor, the cases there, we have, for instance, I'm looking at the Taylor case. Rather than a pretrial hearing, the government asked the court to conditionally admit the co-conspirator hearsay statements at trial, subject to a later determination that the proved exclusion, that would be the hearsay exclusion under 801, applies. So the court is going the extra mile here, holding this hearing, putting the defendants on full notice, and we're certainly prepared to identify the areas of law that authorize admissibility here. We're also going to have throughout the PowerPoint and today, Your Honor, the extent to which the state has provided the court and opposing counsel with extensive authority on the issues pertaining to the admissibility of the gang lyric evidence. Our first lyric brief, supplemental lyric brief, those were last year filed. Second supplemental lyric brief. There's an intrinsic evidence brief that covers many of the issues here. Co-conspirator declaration motion from the state, our state's gang evidence brief, and a co-defendant other act response. Throughout, Your Honor, our presentation, we, as a courtesy to the court and opposing counsel, will reference the page numbers relative to these issues where this appears. So again, there's no question about the voluminous authority that we've presented on this, and we have not received any specific authority in return at this point, Your Honor, to refute any of that. So the state's request today is essentially going to be, Your Honor, to apply Georgia's evidence statutes as written and conditionally admit the particularized lyrics that the state is going to present today. Those will be identified in this PowerPoint, and they will be fewer than in our particularized motion. That with regard to any pending lyrics, the court issue a ruling consistent with those federal decisions we've cited and the others in our briefing, that the court will hold that it will conditionally admit those subject to, as with the briefs we've identified, as with the lyrics we've identified, subject to the state laying a proper foundation, and of course, a 403 assessment at trial. And lastly, Your Honor, we of course are going to ask the court to deny the defense's blanket motions to exclude these in toto. So we want to take a look first now, Your Honor, at the fundamentals of the law that apply here and what are the authorized purposes for the admission of gang evidence. There are three areas, and ironically, this comes out of this division, some of the academic research, likely the defense would appreciate, at least in terms of the conclusions, but the divisions are very helpful. Does the lyric evidence go to prove the corpus delicti of the crime? Is the lyric the offense in and of itself? And that's not the situation here. This is not a threat case, a true threat case. We'll get to that momentarily. And then the next two areas, does the lyric evidence provide proof of the criminal act, circumstantially or direct? And that's going to be determined by the charging statutes in this case, the racketeering statutes, the gang statutes, and any underlying offenses that we have. And then secondly, does the gang evidence, lyric evidence, demonstrate in any way the mental state of the defendants? And that, of course, Your Honor, would be informed by those same statutes. We're talking relevance here. So is somehow the lyric going to prove or demonstrate an element of one of those offenses? And that's really the issue if we're not on what's called a true threat case. And we have a chart here, Your Honor, and my colleagues are going to bring down a board with this, if I may step over to it, Your Honor.
Yes, you have permission to move out the courtroom, sir.
Thank you, Judge. And I appreciate my colleagues' assistance and the court's patience, Judge. So, Your Honor, there are two primary paths to admissibility here. We have the gang evidence, and then the question is, does the lyric form the corpus delicti? Is it the thing being prosecuted? Then that is the only time the First Amendment becomes an issue. And then if it is a true threat case, then the lyric evidence can be admitted. That is not the situation.
Well, Mr. Carlson, Ms. Love, would you do me a favor? Can you hand the media in the front row these particular documents?
Yes, Your Honor.
Because they can't see.
Yes, Your Honor.
All right, we have documents too.
They're coming.
And I would note for the record, it is.
Have they been otherwise copied as of yet?
Some of them.
Can we handle as many as we can at this point in time, madam? I'll just recess and play. Just give me a second, Mr. Steele. We'll see what we can do to help you out.
Thank you, sir.
I'll have copies for everybody, so stop looking at me like, where's mine, okay? That's the best I can do for you.
They'll be up here. This is, Ms. Love, did you give out the PowerPoint to some people?
Yes, the brief attorney have the PowerPoint. The other ones are on the web.
Who had the PowerPoint? Westmoreland, Mr. Shard, and Ms.
D. Williams.
Is that Sharp on this PowerPoint?
No.
We're handing that out. That's what she's sending out.
The additional PowerPoints are coming. 3 people have them, the additional one.
All right, can we proceed now? The other, you all will get, everybody will get copies in just a minute, okay? All right, so go ahead, Mr. Carlson.
Yes, Your Honor. So, Your Honor, again, we only get to a First Amendment concern if we have what's called a true threat case, and that is if the speech in question, lyric, constitutes a threat, and that is what's being prosecuted. Now, there are 2 which ultimately become 1 other paths to admissibility, and these are the ones we're dealing with in this case. Does the lyric represent proof of the actus reus or mens rea, the criminal act or the criminal intent of what's being charged? And that's the situation we have here. It's free from any First Amendment consideration. And as we see from this charge, these 2 areas are where the rules of evidence control. So we see, we proceed, Your Honor, to first of all, the issue of logical relevance under Rule 401. Does the lyric in this situation somehow make a fact at issue more or less likely to have occurred? That's a minimal and very liberal standard. If the answer to that is yes, we then will move forward. Well, we determine whether or not that answer is yes, Your Honor, by looking at the criminal charges in the case. And here we're going to look at what are the elements of proof? What kind of circumstantial and direct evidence is admissible in a racketeering, criminal street gang act, or any of the other offenses that we have here to include murder? And if the answer is yes, this lyric would somehow make something more or less likely to have occurred there, we go to Rule 402. And what Rule 402 says, Your Honor, is that if the evidence is logically relevant under Rule 401, it becomes presumptively admissible, and the objecting party has to find a statute to keep it out. In some cases constitutional, but obviously not this one because we're not dealing in a true threat case. So what evidence statute can the opponent come up with to say that this evidence that is going to make something more or less likely to have occurred here stay out? Now, that's what we don't have from the defense in this case, Your Honor, other than Rule 403. So what we see here in this case, Your Chief Judge Glanville, is multiple evidence rules and principles not only don't keep this evidence out, they authorize its admission. We're going to see that through the direct party admission rule at Rule 801D2A, the adoptive admission rule at 801D2B, the co-conspirator hearsay exemption from the hearsay rule, 801D2E, the rule concerning declarations against interest, 804B3. This is going to, as we'll see, constitute intrinsic evidence, tells the story of the crime. And also there are specialty rules attended to street gang act prosecutions that apply when 1615-4 is charged, and that is 1615-3, evidence of gangs, customs, and behaviors. And 1615-9, other criminal acts of gang members offered to prove the existence of the organization. And then the last chance to keep this out is the rule of legal relevance. Rule 403, again, the burden is on the objecting party, and it's a heavy burden. They have to demonstrate there's no other reason, essentially, to, quote, drag this evidence in by its heels other than to unfairly prejudice the defense, and it essentially has no probative value. That won't be the case here, Your Honor, as we'll see. And so following that path, the lyric evidence in this case for both actus reus and mens rea purposes is going to be authorized for its introduction and become admitted gang lyric evidence. So moving forward, Your Honor, to address, first of all, the defense claims that we have a constitutional First Amendment issue here. And where the First Amendment protection kicks in, and this is Counterman versus Colorado, a brand new case from the United States Supreme Court, 143 S. Court 2106, 143 Supreme Court 2106, that the First Amendment protection comes in if it's a true threats case. Again, we don't have a terroristic threats charge related to any lyric here. So the First Amendment argument is out. Same goes under Georgia law, Harrell versus State. Again, in our materials for the spelling, 297 Georgia 884.
So, Mr. Carlson, if I can interrupt you. So the defense contention that these particular lyrics are poetry, artistry, speech against the artists themselves, is that why they're not applicable under the First Amendment?
That's correct, Your Honor. That's correct. That is a weight, not admissibility issue, as the cases we'll get to demonstrate. But that is an excellent question. And again, that position circumnavigates its way around the actual issue. Whether they claim it's artistic expression or not is irrelevant in terms of a constitutional analysis. The constitutional analysis is, are they being prosecuted strictly for that expression? And the answer here is no. And their argument in favor of their position actually answers that question affirmatively for the state.
Okay, all right. Continue.
So we go to the next issue, Your Honor, and clearly the court is on top of these issues because this is our next slide. United States Supreme Court authority. The First Amendment does not prohibit the evidentiary use of speech. Here, the lyrics are being presented to prove things like the nature of YSL as a racketeering enterprise, the expectations of YSL as a criminal street gang. We've got party admissions for even the offense of murder here. This is evidentiary use. This is not pillorying any of these defendants for the lawful exercise of the First Amendment right. This is bringing this in as evidence of criminal offenses. And there's no First Amendment right for any of the offenses in the current indictment. Those aren't modes of expression, Your Honor. So this is evidence to prove the crimes. And we see United States versus Carpenter there from the Second Circuit. There is no bar to the evidentiary admission of rap lyrics where the artistic expression is not itself the proscribed conduct. And that is dealing specifically with the First Amendment 2022 case. So we move on, Your Honor, to a very insightful line here from this Eastern District of Pennsylvania. Simply put, individuals cannot immunize themselves from criminal liability by expressing their intent in a rap video. Imagine for a second, as we pointed out in our briefing, Your Honor, if someone actually said, well, had the Unabomber's manifesto been set to music, it never could have been used against him in court. And that's essentially what the argument from the defense here in this case is. And that's why we've said in our briefing, it fails reductio ad absurdum analysis, Your Honor. The importance of context, we are aware that the Johnny Cash metaphor is here, but no one's ever come up with, to this assistant district attorney's knowledge, Your Honor, proof that Johnny Cash was ever accused of murdering a man in Washoe County, Nevada. Had that happened, his lyrics would, in all likelihood, have been used against him. So there's a difference, Your Honor, between an abstract musical expression or any other kind of artistic expression that can't be linked to the charges and the behaviors accused in an indictment. So looking at that in a vacuum is exactly what should not, and then trying to conflate it with the facts in a case like this or any of the other cases where this has been done, it's just not the analysis involved. Another insightful line, Your Honor, this time from the Eastern District of New York, the defendants have to find an evidence rule to keep relevant evidence out. And there's no exception for art in the federal rules of evidence. Perhaps that's why the request to you is essentially to create a rule in this case, which is obviously not what the structure of our government allows. So we see this is not a situation where the rules of evidence can be suspended. Right here to the court's question from a moment ago, the defendant may argue he took certain creative licenses with music, but that goes to the weight of the evidence, not its admissibility. That's a jury issue, Judge. Was this true? How true was it? If it moves the needle on relevance, then it's presumptively admissible. And that's what cross-examination and opening statements and final arguments are all about. And let's take a look at the genre-specific issue, Judge. The same rules that the state is relying on to introduce the lyric evidence here has been used across the country in hate crime and hate group prosecutions to get in the material that they inundate themselves with. This United States v. Cannon is an example of that. Speech-based evidence to support a finding that the crime was motivated by racial hatred. Again, Your Honor, we are asking for the same rules to apply here as they would anywhere else. And that's not to say there's a moral equivalency between the gang lyrics in this case and hate lyrics in some other prosecution. But there is a legal equivalency, Your Honor, between the rules that apply, and the rules that apply say that this becomes admissible. So, Your Honor, there's no First Amendment bar to the use of the YSL gang lyrics as evidence of YSL crimes. That's not something that's constitutionally prescribed. And we see here over to the right of this slide in our first lyric brief, supplemental lyric brief, and second supplemental lyric brief, the extensive authority from Georgia, from federal courts and state courts all around the country that really are in unison on this. So now we go to the next issue, Your Honor, whether or not gang lyric evidence can be used to, or how, because we know it can be used to prove criminal intent or a criminal act. And we have this case from our Court of Appeals that says right there, both this court and our Supreme Court have held that a trial court does not abuse its discretion in admitting evidence when a defendant's written lyrics, when that evidence is relevant to some issue in the case. Not every issue, not all issues, some issue. Is there one element of proof that somehow this lyric evidence is going to make more or less likely have occurred? That's the test before the court, according to our Court of Appeals in Ward versus State, 339 Georgia Appeals 621, 339 Georgia Appeals 621. And quite frankly, Your Honor, we are not going to isolate it to one. So we see those two rules that now apply. Our Rule 401 liberal relevant standard set forth there in Booth versus State, and then Rule 402, the cornerstone rule of our evidence code that says all relevant evidence shall be admissible except as limited by constitutional requirements, which don't apply here, or as otherwise provided by law. Now, Your Honor, Rule 402 has been actively used by our Supreme Court to take away former common law restrictions to the introduction of relevant evidence, but also to preclude exactly what the defense is asking for here, judicially architected rules of exclusion. And that is what the defense is asking for here. Call it art, keep it out, ignore the work of the General Assembly. So we go forward, Your Honor. As we head into this now, relevance is determined by the elements of the offenses as to both actus reus and mens rea. We have these two areas now are not controlled by the Constitution. These two areas are now controlled by the rules of evidence. So we're going to look at the elements of those offenses. Mr. Floyd is here to assist us with that when it comes to the racketeering laws. And I'm going to survey this in any number of areas quickly prior to Deputy District Attorney Hilton providing us with the specifics in this case. So, Your Honor, in a Criminal Street Gang Act prosecution under the primary charging provision, that's 16-15-4A, there are four matters the state needs to prove, according to our Supreme Court. So what we need to think about now is does a lyric somehow make more or less likely one of these four matters? So does it demonstrate that an underlying offense occurred? Does it demonstrate that the group in question is a criminal street gang? Does it demonstrate that the defendant is associated with a criminal street gang? Or does it demonstrate that the defendant participated in the gang through the commission of the predicate offense? That's what the statute says. So, and remember, the group being a criminal street gang, then how large is it? What sort of behaviors does it engage in? Are those criminal in nature? And this is the diagram used in front of the Supreme Court, essentially, Judge, to demonstrate how this 1615-4A statute works. So does in this case, lyric evidence somehow show that the defendant, the person there, is associated with the gang? Well, we're going to have plenty of evidence of YSL, we're YSL. Clearly, does it demonstrate that the group's a criminal street gang? We're going to hear through these lyrics about all the crimes they commit, who their rivals are. Does it demonstrate then that the offense in this case occurred there at the lower right? Absolutely, Your Honor. There are going to be direct admissions to the criminal conduct, some of that which is charged in this indictment. Some of it, I understand, connects to overt acts. And then lastly, does it show that the defendant participated in the gang through the commission of this offense? Is this the sort of offense that YSL commits? And of course, that context is what is going to be provided by the lyrics themselves. So we move on, Your Honor. Remember, we have another case here, now 2020, from the 11th Circuit. Evidence is reminding us First Amendment prohibits introduction of a defendant's abstract beliefs when those beliefs have no bearing. Now, see the difference here, Your Honor. When it comes to admissibility, because of Rule 402, it's some relevant fact. When it comes to excluding the evidence, let's say, on First Amendment grounds, where it has no bearing on the issue to be tried, and the evidentiary use of speech to establish the elements of the crime or to prove motive, actus reus mens rea, does not violate the First Amendment. So we continue, Your Honor. We've got a reflection here from a federal court about how lyric evidence is widely admitted across the country. And as we just showed, not just in gang prosecutions, in supremacist prosecutions, in hate group prosecutions, Your Honor. And again, we're asking for the same rules to apply here. So in terms of analysis of Rule 401 and 402, we see in this slide where that has appeared in the state's briefing. Again, have not received any specific authority or argument to refute that. So now we look at actus reus, Your Honor. The relevant purposes. Somehow the lyric in question provide proof of the underlying crime occurred. That would be under the racketeering analysis, that would be under the gang analysis, or that would be also under the analysis of just what does this lyric prove? Does it constitute an admission or adoptive admission or something incriminating connected with a murder? Does it prove the existence of the enterprise of the criminal street gang? Are they talking about YSL as something that exists? If the answer to that is yes, it's relevant. We go down the line to 402, and then the question is, what statute was provided to keep it out? Does it prove the nature of the enterprise of the criminal street gang? What sort of behaviors are being described in these lyrics? Does it prove the defendant is associated? Is he talking about he's part of it or we're part of it? And lastly, does it prove participating in it? They're talking about I'm doing things for this organization. We're going to see all that here in a few moments, Your Honor. So then we take a look at additional offenses beyond just 1615-4 that are going to open up for more relevance of use of this lyric evidence, Judge. There are charges under this for the B, as in boy, violation of 1615-4, committing criminal gang activity, increase or maintain status in the gang. Well, we've got to know what the expectations of the gang are. Are those expectations expressed in the lyrics at all? We're going to see that they are in terms of violence, in terms of what should be done with rats or snitches, informants. Is there going to be proof that the gang steals or somehow maintains property? Because we've got a charge in here under 1615-4C as in Charles, obtaining property through criminal gang activity. So is it going to inform us that this is an activity of the gang? And then lastly, is somebody talking about being the boss, the leader, the capo, whatever we want to say? If so, and we're going to see that is so, there's a D, as in dog violation here, Your Honor, leadership in a criminal street gang. So if someone's saying I'm the leader of something called YSL, we're going to see it has an informed use in all of these areas. We'll get to these in a second. Then we have those specialty statutes that authorize even more evidence once 1615-4 is charged than otherwise would be under an analysis. So now we turn to just a few cases here, Judge. We've got Karsten versus State from our Supreme Court talking about how gang evidence establishes those enterprise, or in this case, criminal street gang factors. We've got to prove that YSL exists, just like the Bishop Bloods gang existed. So that is an element of proof in this case. So someone's saying, well, why is all this gang evidence relevant? Well, Your Honor, in a Street Gang Act violation charge or a racketeering charge, evidence of the existence and the nature of the organization is not only relevant, it's required. No different than evidence of a homicide is required in a murder prosecution. So for someone to say this evidence isn't relevant once those charges come is somehow taking the position that the state should not be allowed to put on evidence that's mandated by the statute. We see the association with the gang becomes admissible, and a video here, this was a video of gang activity, it was an attack actually, did those things and then also established motive. So we look at a few other cases here, Your Honor. Another video case here, this is United States v. Smith, significant probative value because it dealt with contested issues. And there's this issue contested in this case, whether they've obviously pled not guilty. So everything from actus reus to mens rea is on the table. We've got another case here, Taylor versus State from our Supreme Court, where the rap lyrics found with the defendant referenced and pertained to the crime. So that is extremely high probativity in this case, not what's necessary, but again, are we going to have link ups between evidence found during searches and what's being rapped about in this case? Absolutely. So right there, the legal controls that are here are saying that evidence is admissible. And again, proof of the nature of the gang. This is another supremacist case. This is a Texas prosecution under their gang statute that the lyrics showed the ideology of the group. If you've got a group with an ideology, that's part of its organizing principles, which we're going to see here, then of course that evidence is going to be admissible to demonstrate the group constitutes an enterprise or criminal street gang. So here we are where these issues have been briefed in detail for the court, Your Honor. Commission of the offense, the existence, the nature of the gang, affiliation with the gang, participation in the gang, and witness intimidation. And of course, we've got it linked to the areas in our briefing that it's been presented to opposing counsel in the court. Again, do not have any, that I'm aware of, any response taking actual issue with any of the case law that's in there. So now mens rea, Your Honor, mental state. Does somehow the lyric demonstrate motive related in some way to a racketeering enterprise or a gang, intent to commit any of these crimes, state of mind related to any of the offenses, or knowledge that YSL exists, knowledge of the sorts of things YSL does, knowledge of who's in YSL, knowledge of whose YSL's rivals might be. So all of this becomes proof for those purposes, but also what the state of mind is for any of the underlying offenses. Now we see here in this case from California, gang lyrics allowed because it demonstrated who the rivals were of the defendant in question, disclosed his case of state of mind, his motives, his intentions, his loyalty, and furthering the gang's activities. Again, what the state is asking for here is what has been resolutely admitted in courts around the country. Again, not genre specific, Judge. Here we have a case from North Carolina of a person who listened to skinhead songs and then tragically enacted what he was listening to in those songs, and which wound up being a murder prosecution. And we have the court saying right here that what was expressed in that music and the fact that he wanted to fill his head with this and then acted it out went to demonstrate motive in the case. Well, we're going to see a lot of murder talk, a lot of gun talk in all of this, Your Honor, and that pertains directly to the charges that are before the court and that the defendants have been indicted for. Now, this is a case admittedly under Georgia's former evidence code, Your Honor, the natural-born killer case. And it demonstrates that it does not have to be merely material created by a defendant. It's more probative if a defendant expressed these thoughts himself or adopted them himself or is part of the group that operates under these principles. But in the natural born killer prosecution, the defendant watched that movie again and again and again, and then went out and committed murders. So the district attorney was allowed to show at least one murder, to show that film to the jury so that the jury could see what was encouraging and influencing the defendant. He was filling his head full of that kind of violence. If I remember right in the opinion, he even wanted to be called the Natural. He had a nickname related to the things he idolized or watched, and that was allowed. Now, the old bent of mind term is used there, Your Honor, but this is not a 404B case, but I wanted to disclose that to the court. But we see, again, now, what are the defendants in this case? What are they taking in? That type of material we're going to see shortly. So again, on the mens rea issue, Your Honor, we've got our briefing on this in this slide. We will make it part of the record, but we see we've extensively briefed it. Again, do not have anything to challenge that from the defense. Now, there's the principle of intrinsic evidence that applies here, Judge. This lyric evidence is intrinsic. It's intrinsic to underlying crimes where it reveals the behaviors of the speaker. It's intrinsic, Your Honor, because it tells the story also with relation to the racketeering and gang charge, because it helps tell the story of this gang. So we are not talking about a situation, and I haven't seen a 404B objection or 404A objection for any of this evidence.
It's not true. My meeting that I announced earlier, November 2022, and most of my things Mr. Carlson has said has not been challenged, have been challenged directly in my opinion.
Yeah, I see a 404A objection.
Well, I stand corrected, Your Honor. I did not have any recollection of it, and I apologize to opposing counsel.
Your Honor, we also filed a 404B objection in the filing this morning, which I'm sure Mr. Carlson sounds like he hasn't seen yet.
Well, that was inadvertent, Your Honor, and certainly, but let's take a look. Do we have anything to say definitively that somehow the lyric evidence in this case is not part of the same transaction or series of transactions necessary to complete the story, inextricably intertwined, dealing with the change of events, explaining context, motive, setup of the crime, or as an integral part of the account? This is a YSL prosecution. YSL has been designated an enterprise. YSL has been designated a criminal street gang. The behaviors, expectations, proclamations of YSL members and associates, of course, represent intrinsic evidence. And of course, in gang cases, intrinsic evidence is admissible. Here in Fleming v. State, 306 Georgia 240. Gang affiliation, completed story of the crimes, enabled the state to explain the authority of the defendant in the gang. We've got a D charge here of leadership, Your Honor, and that the shooting was retaliatory. We've got what the state believes it'll prove is a retaliatory shooting of a high-ranking gang member. Of course, that's exactly what we have in this case. That's exactly what the courts call intrinsic evidence, immune from 404B. So we've got now these specialized evidence statutes, Your Honor, and 1615.3 was amended in 2009 to broaden its scope. But admissible by statute, Your Honor, are such things as common name or common identifying signs, distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Do these lyrics demonstrate what's being conveyed to the world as the behaviors of YSL? Yes. Do those have a link in the charges in this case? Yes. Admissible under 1615.3. And now do we have evidence of commission, adjudication, conviction of an offense enumerated in 1615.3, the other part of that, the part of that that defines criminal gang activity, is admissible if it's committed by any member or associate of the criminal street gang. Now, there's another part of 1615.9, Your Honor, that was deemed unconstitutional. That's not the part we're talking about here. That was a bypass of Rule 803.24, I believe. But that's not what we're talking about here. So we've got additional provisions allowing us to bring in what is clearly intrinsic evidence. So we take a look now at where this has been. And again, Your Honor, we've got this voluminous authority in our supplemental lyric brief, intrinsic evidence brief, co-defendant other act responsive 2 to 3. So we had this type of briefing in response to refute any of that, we'll let the record speak for that, Your Honor. So now let's take a look at that next section. So this material's out there, Judge, but then it makes a difference who spoke it and under what circumstance they spoke it and whether or not it's admissible. What's that additional pathway? These really, quite frankly, Your Honor, is the responsibility of the defense to provide, hey, that relevant evidence has to stay out for this reason, for that reason. This statute keeps it out. But here the state is going the extra mile to provide the court with the fact that these statutes say it comes in. Now, there are three types of admissions, and Your Honor, as we know, the court well knows, this is for the record, an admission is a classification, not a definition under the rules of evidence. So an admission means the statement came from the other side. In this case, one of the defendants. It doesn't have to admit anything. It doesn't have to be against interest in order to be introduced into evidence. And there are three types: direct, adoptive, or vicarious. They're all going to apply here, Your Honor. So a direct party admission, Chief Judge Glanville, only has two requirements. One, the statement was made by a party, and two, the statement is offered against that party. I'd submit as well, in addition to that, that it's somehow relevant to the case, but we wouldn't be talking about it if it wasn't relevant. So that's it, Your Honor. It's not a content-based assessment there. It's where it's coming from directionally. So we now look at gang membership. Of course, we've got a case here. The defendant at trial maintained he had never been part of the gang, so his gang lyric evidence showing otherwise was admissible as a party admission against him. And that's the Minifield case there from Illinois. And none of these cases are exhaustive, Your Honor. There are detailed cases, additional authority at every one of these stop points in the state's briefing over the last year. Lyrics can provide gang motivation behind the crime. Regardless, we see here from this OLGUIN case from California, regardless of whether the lyrics were written before or after the killing, they were authenticated as the work of a defendant there or a co-defendant. As such, they demonstrated membership of the gang, loyalty to it, familiarity with gang culture, inferentially his motive and intent on the day of the killing. This was a crime alleged to be gang related. Gang membership was obviously important and evidence tending to show it highly relevant. Your Honor is about to see the volume of gang identification, even in the sliver of lyrics that we're bringing before you here today. It's repeated, it is extensive, and it is persistent. Now let's take a look at adoptive admissions, Your Honor. Now the classic case of adoptive admissions in that State versus Orr, 305 Georgia 729, is essentially a loaded question comes to an individual, the person is in a position to deny it, doesn't, and then they adopt the content of that. Now there was the old Mallory rule, which I know the court is aware has been eviscerated in Georgia with the adoption of the federal rules of evidence here. And the Mallory rule said those weren't admissible in criminal cases. Orr did away with that. Actually, quite frankly, what Orr told us was the General Assembly did away with that when it adopted the federal rule. But that rule's gone, Your Honor. And Orr says we follow, of course, the federal authority on this. But there are other sorts of adoptions, Judge, and sometimes in the case law, this is called adoption by use. Forwarding an email, maintaining a document, or posting lyrics on someone's website. Defendant A posts defendant B's lyrics. Now the individual has arguably adopted the contents. And that's essentially what occurred there in the RICO case from the Fourth Circuit in 2018. It says here, and now we're back again, Judge, to what the jury issue is. There might be a lot of reasons to post lyrics, but in some circumstances, we submit to you, a YSL member, posting, forwarding, helping to create YSL lyrics. That's because they wish to express a certain view and believe the words of an artist, including a rap musician, express that view especially effectively. Whether someone has adopted the lyrics as his own statement depends on the particular facts of this case, but we're only talking conditional admissibility here, Your Honor. We're only talking that minor standard. Now, this Hankton, Your Honor, and I want to get this case cited into the record. United States versus Hankton, Hankton, 51 Fed 4th 578, 51 Fed 4th 578. It's a 2022 case from the Fifth Circuit, and we've included a link to this actual video in our briefing, Judge. It was a murder, and it was a rap video with multiple members, if memory serves correctly, from the gang in the video. And one of the defendants who was implicated in the murder in the video, just for an instant. And when the murder gets spoken about, the defendant holds up his hand in a be quiet sign, or a SHUSH sign, shush. That was enough, Your Honor, for him to have adopted the contents of the video. According to the Fifth Circuit, 2022, he participated in its creation. He's in there, and particularly at the moment the underlying crime is being discussed, he is there and making a gesture along with it. So now we deal again in this case with questions of art, with question of should the artist, who the actual rapper, have been brought in to be cross-examined prior to this being admissible. And take a look at what the Fifth Circuit says. The defendant may well be correct that the lyrics were subject to interpretation, but that interpretation was within the province of the jury to determine. That's not a basis on which to exclude pertinent evidence. And now the co-conspirator admission, Your Honor. The basic foundation here. The state is required to show a conspiracy existed. The conspiracy included the declarant and the defendant against whom the statement is offered, and the statement was made during the course and in furtherance of the conspiracy. And that's Kemp versus State at 303 Georgia 385. Now, Kemp's particularly important here because it's a gang prosecution, Your Honor. And one of the factors in Kemp is, when does the conspiracy terminate? Well, we were dealing with a gang in Kemp, Your Honor. The conspiracy continues past the point of indictment, onto the trial. The conspiratorial framework is not limited to an underlying constituent crime. It continues, Your Honor, as long as the gang continues. And another thing that Kemp stands for is any statement that's somehow going to further the interest of the gang, promoting cohesion, promoting fear, anything along those lines, gang members reporting back and forth to each other about gang activity, which we're going to see in these lyrics. That all falls under the co-conspirator exception. So when defendant A makes that statement, if it is subject to the co-conspirator exception, it's now a party admission. So defendants B, C, D, E, F, it is as if they said it. That's Rule 801 D2E. That's why it's an exemption. I apologize for misspeaking, not an exception to the hearsay rule. And the Kemp case opened that up specifically on the gang statute. And what we had in Kemp, Your Honor, was a gangster disciple homicide. One of the three gangster disciple defendants is in the detention center. He's having a conversation with an unrelated to the case gangster disciple about that murder. That unrelated gangster disciple was able to come on the witness stand, testify about what the speaking defendant said, and then that became the co-conspirator admission of the other defendants. So now, Your Honor, in enterprise gang and conspiracy cases, again, Kemp, to that point we just raised, specific acts charged. The charged murder did not end with the involvement or association with gangster disciples because, let me rephrase that. The specific acts charged, the murder, did not end the defendant's involvement or association with the gangster disciples. As long as they remain associated with the organization, then those co-conspirator hearsay admissions are coming in against them. And again, we see this principle pertains to gang cases in three areas. And this is that template case Torres again, and we're going to have all three of these type of statements, Your Honor. Does the statement, is it made in the lead up or during certain actions taken by the enterprise? Is the statement pertain to acts committed during the course of the conspiracy or somehow apprise a co-conspirator on the progress of the conspiracy? We're going to see that. And does it have to do with the group's ranking system, code, words, and history? I'm the boss. Here's who's with me. Here's what we've done in the past. Any of those three authorize the admission of the speakers, party admission, as co-conspirator hearsay against the rest. And we have this another case here, rap tracks being allowed in as conditionally admissible in that United States versus Graham case. So we see a little further declarations against interest, Your Honor. This is when there's a dispute over whether or not it constitutes co-conspirator hearsay. Is the person unavailable as a witness, someone who doesn't come in, won't come in, or it could be a non-testifying co-defendant, although usually that'll be co-conspirator hearsay. Does it expose someone to criminal or civil liability? I'm in a gang. I do gang things. I committed this offense with someone else. And are there corroborating circumstances that indicate the trustworthiness? Now, that doesn't mean it's something legal being discussed. It just says, are there surrounding circumstances there that demonstrate that the statement is what it claims to be and that it can be trusted by the court for admissibility purposes? Those apply in gang cases, as this Magnum case shows. The defendant repeated his statement about the conspiracy again and again and again and the murder to many people. Therefore, the statement, remember, of the declarant becomes admissible against everyone else if it satisfies the foundational requirements. So gang lyrics and declarations, again, we have it here. Songs helped establish that the group was a gang. Songs helped establish that the defendant or the speaker was a member of the gang and that he went looking to assault people, I believe, in a rival gang. And that's that Ramos case. So again, all of these concepts extensively briefed by the state. The record will see whether or not there was that sort of authority provided in response. So now the last issue to cover here, Your Honor, before we get to the specifics, is the issue of 24-4-403, no statutory analog to that in Georgia's former evidence code, unfair prejudice. And the first thing, Your Honor, is that the defendant's 403 motion is really untimely. We see here from this Cabot Oil, Eli versus Cabot Oil case, pretrial Rule 403 exclusions should rarely be granted. So again, our request, Your Honor, for conditional admissibility subject to us laying the proper foundation and an at-trial 403 assessment completely comports with this authority. Excluding the evidence as being more prejudicial at a pretrial stage is extreme, rarely necessary because no harm is done in admitting the evidence at that stage. And remember, it's only matters of scant or cumulative probative force dragged in by the heels just for the sake of its prejudicial effect is what gets excluded at trial by 403. Now, Your Honor, in terms of lyrics evidence, this is an article by Professor Coonan from University of Georgia Law School talking about how the burden of justifying the exclusion under 403 rests squarely on the objecting party. That burden's a heavy one because just charging it requires an all-out focus only on the problems of unfair prejudice. So remember, it is not up to the state to demonstrate that this is not 403 barred. The defense has to show that this is the rare exception that 403 applies. And again, we have here gang lyrics not outside of Rule 403. Again, is this strong evidence? Yes. Is a confession strong evidence? Yes. Is a video in an automobile accident case strong evidence? Yes. But that doesn't mean merely because it's highly probative, it's unfairly prejudicial. And even that unfair prejudice is only part of the balance. To exclude it under 403, the probative value has to be minimal. And again, these lyrics are going to be all about this particular criminal street gang. So now we look again at that high standard for the defendant. This is a rap video case, not a gang prosecution. And it talks about how the video was replete with obscenities and slurs, but it's not per se prejudicial because of that. It connected to the case there in Wilson versus State, and that's a 2023 decision from our Supreme Court. And it shows the defendants boasting about making money, just like the lyrics in this case. Boasting about being in the violent drug trade. Again, we're going to see, perhaps not today, but ultimately, those types of references. And again, demonstrating again, Your Honor, while it might be highly prejudicial, it's not illegally prejudicial. It's not excludable by 403. It had a high probative value. And it says right here, this is not a question of evidence that could inflame the passion of a jury for a reason irrelevant to the guilt or innocence of the defendant. Again, part of the defense's burden here is to demonstrate how irrelevant this evidence is to YSL and to the charges, and not going to be able to do that. Again, not genre specific, Your Honor. We have this Magleby case from the 10th Circuit, another supremacist song. The lyrics of the song were harmful to the case, but were harmful to the defendant's case, but that didn't mean they shouldn't come in. And remember, Your Honor, in most of these supremacist hate group type cases, the defendant's someone who listened to the material or possessed the material. Well, that's obviously of a lower probative value than when the person's producing it, which is what we have in this case, and passing it around to each other, and even more than that, putting it out for the whole world to hear. So public dissemination, to that point just raised, decreases that prejudice. Here we have this case, United States versus West. The defendants disseminated on social media evidence on public viewable sites, the purpose of which was to get noticed, the purpose of which was to be heard. So once again, that was factored into the 403 analysis to allow in the evidence in question. So at 403, Your Honor, again, we have extensive briefing on that, our lyrics brief and our second supplemental lyrics brief. So we see, Your Honor, we have in this case, we're not dealing with a truth threat case. The lyrics do not form the corpus delicti of the crime. In fact, the lyrics are evidence of criminal intent and of criminal action. Actus reus, mens rea. They are highly relevant in this case, as we are about to see. They go to prove the offenses in question, demonstrates elements of proof of the offenses in question, and of course, also, Your Honor, the mental states, the knowledge, the intent, the motive, the state of mind of the defendants. We're not going to see a statute that keeps them out, and we are respectfully requesting again, Your Honor, conditional introduction of these lyrics. With that, Your Honor, I'm going to turn it over to Deputy DA Hilton to talk about specifics.
All right. Madam?
Your Honor, can we take a brief comfort break? And we need to pass out some items to defense counsel.
Let's take, could everybody please be back at 5:03, please?
Yes.
Okay, all right, we'll be in recess until then.
I thank you, Deputy Ingram. All right, councils and those folks, we'll go ahead and get started at this point in time. Ms. Hilton, you ready, madam?
Yes, Your Honor.
All right, go right ahead.
Your Honor, my screen is shared. Give me 1 second. Do we have share on it? I got
You should. And do you all have a copy of that? I gave mine away.
We are having a happy brother. Yes. Here.
I was just looking for that. I think, didn't you have another handout or something like that? Yeah, I'll give you this back, Ms. Lowe. I don't. Thank you. Okay, all right, Ms. Hilton, whenever you're ready, madam.
Thank you, Your Honor. Now, Your Honor, you just heard from Executive District Attorney Carlson regarding the areas in which these statements and lyrics can be entered. And so what this portion of the hearing will do is just speak about a certain number of the statements that the state is seeking to introduce. Again, this is only a few, but we have just wanted to identify for the court those lyrics and how they are relevant in this particular case. We are going to look at the lyrics in groupings. The first group is going to be some examples of evidence of the existence of the YSL enterprise. So these are 4 examples of these types of lyrics that the state will seek to introduce in this case. So we're going to start at the top here, the first lyric. This lyric was a lyric that is posted on the Instagram page of Shannon Stillwell, that Instagram page being OG.Bull, BOOL_. Some significance about this particular video is the video was filmed on Cleveland Avenue. We believe the address is 151 Cleveland Avenue. At the time that this video was done, which is in 2019, this was an Exxon gas station. It is no longer an Exxon gas station. Also of importance in this video, Your Honor, is there's other YSL gang members inside of that video. Specifically, Shannon Stillwell is the one that's going to be rapping in the video. Then Miles Farley appears in the video. Wooney Lee appears in the video, as well as Quarmavius Nichols. And of note, Your Honor, the title of the Instagram posting is Slat Talk. And Your Honor, we believe that through our gang investigators in trial, they will say what slat is slime love all the time. That is a frequent phraseology used by the gang. And so it is of note that this particular video is entitled Slat Talk. So specifically on this board, we have this verse. I just beat a murder rap, paid my lawyer $30 for that. There's a few other lyrics in between, and me and my slimes above the law. In addition to those lyrics, there's some other notable lyrics in this particular video. Mr. Stillwell states, and I keep a stick, ain't avoiding no smoke. Which a stick, Your Honor, we believe will come out in testimony through our gang expert is a gun. He also says, I'm that slime that you always talk about. I'll wipe your nose, sit in your family space and just smile it off. While wiping your nose is another symbol that we are going to allege that the members of YSL use. Now, Your Honor, I have for the court, and I provided to defense counsel some still images of that video. May I approach?
You may, madam.
Now, I'm going to talk about some of the imagery inside of the still copies of this video. And this video was provided to defense counsel in discovery, the actual full video, but some of the significance of the video. So, Your Honor, as you see in State's Exhibit number 1, Mr. Stillwell is bending down. He is wearing a YSL chain to show his a part in the enterprise, him being associated with that enterprise. Again, Your Honor, as the state just mentioned, the background of this video is in 2019 was the Exxon Food Mart, which is on 151 Cleveland Avenue in YSL territory, which the state is alleged is one of the YSL strongholds where they sell drugs out of. A few of our cases in this particular indictment in our RICO Act, as well as some of the other counts in our indictment, we have individuals who have sold drugs out of this location at 151 Cleveland Avenue. When you look at State's Exhibit number 2, Your Honor, that is a screenshot that has Mr. Stillwell, but also in State's Exhibit number 2, to the left, you see an individual in a black shirt with some purple writing is Miles Farley, one of the other co-conspirators and co-defendants in this indictment, again, showing association with other members of the gang. On State's Exhibit number 3, Your Honor, your copies are not marked, but they should be in order.
I don't believe they're in order.
They should be. We put them in order. So the first one has Mr. Stillwell bending down with a, they're not in order?
Is this the first one?
No, that's not the first one.
So we don't have them in order.
State's Exhibit number 1. State's Exhibit number 2.
Hold on a second.
Sure.
I'm sorry, I think I can't see it.
2 or the 1?
I saw the one. Did I see the 2? Please?
I think Mr. Steele wanted me to hold on number 1. Sure.
That's 3 of them.
Number 2.
Just say one. Let me see.
Number 3. Yes. Next, Your Honor, I'm going to do it simultaneously. Will be State's Exhibit number 4. State's Exhibit number 4 has Mr. Quamavius Nichols and Mr. Stillwell in that image, again showing association with each other. State's Exhibit number 5, we can move forward on, but it's again just Mr. Stillwell with a YSL chain. And then Your Honor, State's Exhibit number 6 is Mr. Stillwell throwing up what the state will allege is one of the YSL gang signs. And then last, we have State's Exhibit number 7 with Mr. Stillwell and co-conspirator Wooney Lee in that image as well.
I don't have state 7, man. I don't have up to, I have up to state 6.
Okay, well, Your Honor, I can approach with State's Exhibit number 7. Sure.
Thank you.
You're welcome.
What's that?
Madam, I have state 6. This is state 6, right?
No, that's 7. You said you didn't have 7, Your Honor.
Hold on. Either it's mislabeled or.
It's still progressive. One again.
I'll let you look at what you gave me and then if it's the same picture. I only have through 6. Got the same one or a different one?
Okay.
Number this. That's not.
That's not, that's it, so you don't have to. You have an extra picture.
Show me one. Yeah, okay. But I have this.
Can I see your packet? That's what you put number 1 on?
Right.
That is it?
No, but I was telling you this.
Okay, but you have it. So we can move on. Okay,
You can move on and then you'll figure out what's going on.
okay. So, Your Honor, those are some of the still images from that particular video. And so some of the lyrics, I just meet a murder rap, pay my lawyer 30 for that. What we have, Your Honor, is in and around 2019, in and around that time, Mr. Jackson Stillwell is speaking of his initial charges as it relates to the shooting of Donovan Thomas. Around that time, Your Honor, those charges were initially dropped, but of course he was reindicted on that indictment, reindicted on those charges in this indictment. Then we also have, Your Honor, me and my slimes above the law. We don't walk into no court at all. Again, Jackson, Mr. Stillwell and his fellow associates who are in the video, which is Lee, Farley, Nichols, are all appearing in that video, Your Honor. They're advising that they can commit crimes without no consequences. That is what that is alluding to. Again, Your Honor, I spoke earlier about, and I keep a stick, ain't avoiding no smoke. Mr. Stillwell is charged in this indictment in count 2 of this indictment with murder, in which we are alleging and charging that Mr. Stillwell was one of the individuals who shot and killed Donovan Thomas on January 10, 2015. We are also alleging in this indictment, Your Honor, on counts 49 through 54, as well as the count 1, the RICO conspiracy, that Mr. Stillwell murdered Shamel Drinks with a gun. And then last but certainly not least, in count 64 through 65, Your Honor, which is the March 17th, 2022 apprehension of Mr. Stillwell, the state is alleging that Mr. Stillwell threw out weapons outside of his vehicle as he was being, as he was leading officers in an accelerated chase and throwing guns out of the window. Again, this being evidence of particular crimes, and I keep a stick, ain't avoiding no smoke. Additionally, Your Honor, I'm that slime that you always talk about, and I wipe your nose. Again, Mr. Stillwell is associating himself with being a slime, being a part of Young Slime Life, that gang, and I'll wipe your nose, which is one of the signs that this gang shows their affiliation with this gang and enterprise. These statements, Your Honor, as was discussed earlier, would be a party opponent admission as to Mr. Stillwell. As to all the defendants in this indictment, it would be a co-conspirator admission and declaration against interest. And to Mr. Farley, Mr. Lee, and Mr. Nichols, or Mr. Nichols, who is currently sitting at this table, it would be an adoptive admission as to him. Next, Your Honor, we have from Mr. Williams' song, which was posted on YouTube in April of 2014, the song EU. And he says, honestly, truth be told, YSL won't fold, pick his ass off from the balcony, YSL wipe a nigga nose. Again, Your Honor, that same reference of YSL wiping a nigga's nose or wiping nose, which is one of the symbols that's associated that these individuals who participate in the YSL gang, it is one of their identifiers to show their participation and allegiance into this gang. He also says YSL won't fold, pick his ass off the balcony. Again, this is a reference to YSL criminal street gang members not folding, not snitching, or cooperating with law enforcement. And there'll be another lyric that is similar in nature to this as well. And again, as the state just mentioned, the YSL Wipe a Nigga knows what that reference is, which is one of their symbols that they show their affiliation association with this gang. This statement would come in against Mr. Williams as a party admission, and then to all of the other co-conspirators as a co-conspirator admission and a declaration against interest. The third lyric in this grouping of lyrics would be from the song Really Be Slime. Now, this is a song on the Young Stoner Life, Young Thug, and this is on the Slime Language 2 album, Your Honor, which is a compilation album, which is a compilation album by Young Stoner Life, Young Thug, who was Jeffrey Williams, and Gunna, who was Sergio Kitchens, both Mr. Williams and Mr. Kitchens being co-conspirators in this indictment. And we have an individual by the name of YNW Melly, who says this as the chorus. My niggas really be slime and we committing them crimes. Hop out and shoot. And then we have B Slime, who was another, who was an individual who was not, who's an individual who was not charged in this indictment, but he says, wanna be slime, go catch you a body. Here, Your Honor, in this case, again, for count 1, RICO, my niggas really be slime and we committing them crimes. We have all of the individuals in this indictment charged in the predicate act. Each and all defendants are charged with the 191 overt acts, some of which are predicates. We also have that in count 1, Act 17, 79, and 173, which all deal with the shooting deaths of both Donovan Thomas, which is also count 2 in the indictment, Jamari Holmes, who was murdered as well, who is part of this indictment, as well as Shamel Drinks. Each of those individuals were all murdered, and it's the state's contention that when they say, wanna be slime, go catch you a body, I mean, you go out and you go murder someone. That's how you can become slime. You go murder someone and you go catch a body. And we have these 3 individuals who were murdered as a part of this indictment. When you look at this particular admission, Your Honor, again, these admissions go to show the enterprise because of how this song shows that these individuals talk about being slime and being part of YSL. Again, slime being one of the phraseologies that each of these individuals call themselves or talk about being a part of YSL. We also show that these statements would come against all of the defendants as a co-conspirator admission and a declaration against interest. It would come again, Mr. Williams, as an adoptive admission because he is the person who put this compilation CD out. So these statements would be, as to him, a adoptive admission, as well as to Mr. Sergio Kitchens, it would be an adoptive admission as to him as well. Also significant, Your Honor, with this particular case is that the front covering of this particular album, Your Honor, has some significant value. The cover of this Slime Language 2 album has a gold frame with a snake coming out of the top of the frame. The snake represents another symbol that YSL gang members use when they are speaking in text messages, when they are speaking on Instagram. They use that as one of their symbols. And so it's significant, Your Honor, because again, this gold, and I have a picture for the court, it's gold and it has these 2 snakes coming out. Mr. Williams is inside of the picture here wearing green. Again, the color that we believe our gang experts will testify to is the color that this gang uses. And so, Your Honor, we believe for those particular reasons, so the words inside of this song, as well as some of the imagery, Your Honor. Again, this will also come in, and I have a copy for the court and for opposing counsel. This is the image that I'm referring to.
All right.
So what exhibit number is that?
This is actually number 7. Yes, Your Honor. Now, Your Honor, the last song, or the last, statement within this particular category is going to be a statement from the song Slime Shit. This statement has Mr. Jeffrey Williams, Mr. Diamante Kendrick, Martinez Arnold, and Jimmy Winfrey. This was released on Apple Music on March of 2016. And the lyric is, hey, this that slime shit. Hey, YSL shit. Killing 12 shit. Fuck a jail shit. This that mob shit. YSL, this that mob life. Now, first and foremost, as it relates to the first portion of this verse, hey, this that slime shit. YSL shit. Killing 12 shit. Fuck a jail shit. Your Honor, we have a case with Christian Eppinger. That's going to be counts 32 through 39 in this indictment, in which when he was being apprehended by Officer Rogers of the Atlanta Police Department, this defendant pulls out a gun and shoots Officer Rogers multiple times, only by the grace of God that he is not dead. But that represents this mindset of this gang. This is what they do. They want to kill in 12 shit. We know that 12 is a euphemism for police and that's what our gang experts will testify to. And so this particular verse or particular portion of this statement will go to show, again, the mens rea, the state of mind of members of this gang. This, that second part, this, that slime shit, this, that mob shit. Again, referencing to slime being like a mafia family, being those who engage in a mafia type of mindset. Fuck the jail, YSL, this, that mob life. Again, disrespect to the judicial system, which we heard in that first lyric that first statement with Mr. Stillwell. There's some other relevant statements within this song. He says, 100 rounds in a Tahoe, give him surgery, no lipo. Well, normally that wouldn't seem significant. However, in the January 10th, 2015 murder of Donovan Thomas drove a Tahoe. And not only did Donovan Thomas drive a Tahoe, there are multiple rounds of shell casings laid down on the ground where he was killed in front of his barbershop. And his Tahoe was in front of the barbershop when he was murdered. And so while it may on its surface seem irrelevant, when you put it to the facts that are going to come out in this particular case, that particular verse becomes very relevant. Then another statement within this song is, fuck the police and the high speed. Your Honor, we have multiple predicate acts in this particular indictment where members of the YSL gang flee from police. We have Marquavius Huey in November 2021, who leads the police on a high-speed chase when they're trying to apprehend him for an armed robbery that he committed. We have Shannon Stillwell, not once, but twice, in 2019 and in March of 2022, where he flees from police where they're trying to stop and apprehend him. Your Honor, you have had the occasion to see one of those videos of that chase. That's the 2022 chase, but we also have another one that happened in 2019. And then we have Diamante Kendrick in October of 2015 running from police after he was getting ready to go to Trestle Tree to go shoot up the opposition gang. And Your Honor, that is significant because, again, you see multiple times where these individuals are running from the gang. So this isn't just on its surface, just fuck the police and the high speed. These are the mental state of these individuals. When police come, we run. very indicative of facts that's going to come out in this case when we go to trial. So again, Your Honor, for that particular verse, we have that these statements will go for Mr. Williams, Mr. Arnold, Mr. Winfrey. For Mr. Williams, it'll be a party admission. For Mr. Arnold, an adoptive admission. For Mr. Jimmy Winfrey, a party admission and an adoptive admission. And for all of the other co-defendants, a co-conspirator admission and declaration against interest. So that is the conclusion of category 1. Now we have category 2, which would be evidence of the nature of the YSL enterprise gang. Maybe I'll go on. So, Your Honor, under this particular grouping, these are evidence of the nature of the YSL enterprise. And so our first statement that we're going to reference is a statement in the song Take It to Trial, which is with Jeffrey Williams, Sergio Kitchens, and DeMonte Kendrick. And this is a song that was released on Apple Music in December of 2020. And so this is Mr. Kendrick speaking, "I rep my life for real, for slimes, you know I kill." Mr. Kendrick is charged in count 2 of this indictment with murder. That is the murder of Donovan Thomas. He is alleged, along with Shannon Stillwell, Demas McMullen, Justin Cobb, and Javorce Bradford, are alleged to have planned the killing of Mr. Thomas, Your Honor. And so it is the state's contention that for his slimes, which all of them we have alleged are part of this conspiracy, part of this enterprise, YSL, he will kill. And he's alleged to have done that, and we have alleged that he has done that. So again, this is not just something that's just being said in abstract, but when you couple this with the evidence that will be presented in this case, it's extremely significant. It's extremely significant. Again, this particular, as an example of the verse of showing the nature of the enterprise, again, going to the state of mind, the intent, the motive, the knowledge of the gang, as well as the enterprise, and again, some of the underlying offenses. Again, this statement would come in with Mr. Kendrick as a party admission, as to Mr. Kitchens and Mr. Williams as an adoptive admission, and as to all of the other co-conspirators and co-defendants as co-conspirator admissions and declarations against interest. The second statement, which is from a song called Dream, which is again by DeMonte Kendrick. It was released on Apple Music in April of 2015. He says, "Hey, how you doing? I'm yet got it. I got bodies on bodies." Again, talking about the fact that he has bodies on bodies, which is the state's contention, what our experts will testify to, is that he got dead bodies on bodies, not just regular bodies, but just bodies on bodies. Additionally, in this particular song, Your Honor, Mr. Kendrick says, I'm with Thugger, that's my worded. And we solid, oh so solid. If I get caught, I'm gonna say nothing. YSL, bitch, we mobbing. Again, if he gets caught, he won't say anything. That is the mindset of this gang, Your Honor. This is the mindset that if we ever get caught, we won't say anything, we won't speak, we'll keep it quiet. That's consistent with what we saw previously in another one of those lyrics, that this gang knows if they get caught, don't say nothing. Or that's at least what you should have some allegiance to. Again, going to showing the nature of the enterprise, the nature of YSL, that this is the nature of how this gang operates. This statement would be admissible against Mr. Kendrick as a party admission and an adoptive admission. As to Mr. Williams, it would be adoptive admission and a party admission. And as to all other co-conspirators, it would be a co-conspirator admission and declaration against interest. Next, we have, Your Honor, a song by he's featured on the song. So the song is actually by an artist that goes by the name of Juice WRLD, and it's featuring Mr. Williams. The song is called Bad Boy. It was released on Apple Music in January of 2021. And Mr. Williams says, I shot at his mommy, now he no longer mentioned me. Now, this would seem, again, insignificant if you're just looking at these words. However, in this case, in the height of the 2050 gang war between the YSL gang and the IF gang, we have cases in which individuals of YSL shoot at the opposition's mother's house. Mr. Rayshawn Bennett, also known as YF Manlucci. We have two incidents in January 22 of 2015 and January 26 of 2015, where his mother's home, Mr. Bennett's mother's home, was shot at. And it is alleged to have been shot at by a YSL associate. What we have, Your Honor, and the evidence is going to go out that come in, Your Honor, we believe, is that the shooting from January 26, 2015, that we have a NIBIN connection in which that gun that used to shoot at that house was found in the hands of a YSL associate. So us inferring that a YSL associate shot at his mama's house. So this is very different than this just being a verse that's just out there. We have evidence to show that this is something that happened in this case, and therefore will be relevant for the purposes of coming in here. So again, this would be coming in to show an underlying offense, to show being part of the enterprise, to show that this was a gang act that was completed. And this would come in against Mr. Williams as a party admission, and then all of the other defendants as a co-conspirator admission or declaration against interest. And then on this particular board, Your Honor, this last song on this board is a song by Mr. Wooney Lee, which is called Where You From. It was released on YouTube in August of 2020. And this is a song, Your Honor, just for context, is filmed again on Cleveland Avenue. This song was also, the video for this song was also filmed at the same Exxon gas station that we saw in the Shannon Stillwell video. Your Honor, there are other associates or members of YSL in this video, Your Honor. I have a few additional kind of screenshots from that video as well. May I approach and I'll show opposing counsel the three pictures that I'm going to be referencing during my.
You may, madam.
So first you have, Your Honor, State's Exhibit number 15, which I'm going to show to opposing counsel. So Your Honor, State's Exhibit number 15 is Mr. Lee, again, doing doing the same symbol that we allege that is a part of what the YSL gang does, which is wipe his nose. States Exhibit number 16, you're gonna have Mr. Lee in that video, also throwing up the YSL gang sign. And then last, you'll just have in States Exhibit number 17 would be another individual, Mr. Mooney Lee, actually inside in the video itself with, Miles Farley in the video along with Mr. Mooney Lee. Again, showing association of other individuals of the gang within the videos. So what does he say? He says, where are you from? I'm from Cleveland. What the evidence will show and our gang experts will say is that Cleveland is the name that blood gang members use because they don't want to say Cleveland. So they say Cleveland Avenue, and that will come in. Throw your setup, YSL. The ops hate the crew, we get in paper and we duck in cases. There's a few additional statements in between that. He says, free Lil Shannon, he the one that had them running with the cannon. Your Honor, we believe that running with that cannon, a cannon being a gun. Again, Mr. Lee acknowledging that Little Shannon had them running with that cannon. And Little Shannon Stillwell, is the person who is the shooter of the gang. Because that is who he is referencing in this particular lyric and in this particular verse. Again, this entire admission would come in, one, for state of mind, as far as the mens rea, to show, again, participation in this enterprise, to show participation within this gang. And it would come in against Mr. Lee.
Can I just see clarification? State's argument, you're saying mens rea, who's mens rea? Are they arguing it's about? Mooney Lee's words are admissible for everyone's mens rea, is that?
Yes.
Okay.
That all the defendants, it will come in against as a co-conspirator admission as well as a declaration against interest. And then if I can have the next board. So now we have Money, a song by Mr. Williams, and a song entitled Thuggin' 30, which is posted on YouTube in June of 2019. He says, money longer than the world's longest ruler. Yeah, playing with YSL, niggas gonna shoot you. Again, this is an admission spoken by Jeffrey Williams. We have several acts, Your Honor, in which YSL members are alleged to have shot at other individuals. We have, again, the murder of Donovan Thomas Jr., in which he was murdered in January of 2015. We have the shooting of Dexter Montgomery. We have the shooting of Cornelius Davis, the shooting of D'Angelo White, the shooting of Dwayne Carter, the shooting at the house and home of Denise Bell, the murder of Jamari Holmes, the shooting of Milton Howard Jr., the shooting of Officer David Rogers and Officer William Johnson, and the murder of Shamel Drinks. Again, showing that if you play with YSL, this nigga's gonna shoot you. We have evidence upon evidence upon evidence of this gang engaging in shooting, assaults, and murders of either opposition gang members or community members or law enforcement officers, Your Honor. This statement, again, would come in against Mr. Williams as a party admission, as well as all of the other defendants as either co-conspirator admission or declaration against interest. Next, we have the song the lyric from the song Mob Ties. In this particular video, Your Honor, we have several individuals who are affiliated or associated with YSL. It'll be Quantavious Greer, Wooney Lee, and Diamante Kendrick are all in the video. He says, we be on some Tupac shit, hit him up. Niggas play with Unfunk. Unfunk is Quantavious Greer. And get hog-tied. Niggas play with Unfunk, then they all died. Why would I lie? I got mob ties. And what is extremely significant is, as an ad-lib, this is not really a particular verse in the song, but as an ad-lib, Diamante Kendrick says, very quickly, knocking off your big homie, bitch. Well, why is that significant, Your Honor? The state has alleged and is alleging that this gang is responsible for the death of Donovan Thomas Jr. Why is that particular admission of that murder significant? Is because the state believes that the evidence will show that Mr. Thomas was one of the leading members of the opposition gang. The opposition gang in this case, and he would be someone who would be considered a big homie to a number of people, that being Rayshawn Bennett, who is also known as YSL Lucci. And this is an admission of knocking off your big homie, meaning of murdering him, of killing him, and that they are admitting to that in this lyric. So again, showing their knowledge of this crime, showing what they have done as a part of their enterprise, as showing one of our predicate offenses in this case. This particular admission, again, would come in against Kendrick as a party admission, as well as an adoptive admission because he's inside of the video. Mr. Wooney Lee was inside of the video as well. And then for all of the other co-defendants, it would come as a co-conspirator admission and declaration against interest. Next, we have from Mr. Williams and his song Just How It Is, which was released on Apple Music in August of 2019, that he has this statement: ooh, I done fucked the crew. Ooh, I done did the robbing. I done did the jacking. Now full rapping. I escaped every one of them licks because I was supposed to be rich. I don't care nothing about no cop. I'm telling you just how it is. And what we believe the evidence will show is that in this particular case, we have particular armed robberies, Your Honor, in which there are going to be allegations that Mr. Williams set up the robbery, put other individuals as part of that robbery, but was able to avoid being apprehended because he ran away once the other individuals involved in that case were apprehended. And so again, showing this is not just a particular lyric, but there will be evidence that he's escaped certain types of the crime that he's admitting to have done in furtherance of this enterprise and furtherance of this gang. And so, Your Honor, that would be the relevance of this particular statement in this case. Again, that would be a party admission against Mr. Williams. And then as to the other co-defendants, a co-conspirator admission and declaration against interest. Also in that same song, Your Honor, Just How It Is, Mr. Williams states, gave the lawyer close to $2 million, he handled all the killings. We don't speak about shit on wax, it's all my business. We known to kill the biggest cats of all kittens. So again, Your Honor, as it relates to this particular case, Your Honor, there is evidence where it says gave the lawyer close to $2 million, he handled all the killings. We have, and this goes back to, I think, that motion that has not been, that the court has not ruled upon, and where we talk about Brian Steele. And we talk about, in this particular instance, we know that as it relates to Quantavious Greer, Mr. Steele has handled the appeal of Quantavious Greer 2010 murder case. As it relates to Damone Blaylock, he is currently handling his murder appeal for the 2019 murder case. And as it relates to Shannon Stillwell, when he was arrested in March of 2022, he initially reached out to Mr. Steele for representation on that murder case. Now, that case did not come to, his representation did not come to fruition because we believe that this case, Mr. Williams was indicted, so Mr. Steele ended up representing Mr. Williams on this particular case.
That's not true. You can tell me that later. I mean, she just.
State has a letter. I mean, that was a month's.
Yeah,
That's just.
we talked about this before, Mr. Steele, so I'm familiar with it, so.
And Your Honor, what we believe the state's evidence will show is that Mr. Jackson, in a recorded video, when he is being, when they are getting ready to Mirandize him to see if he wants to speak, he tells the law enforcement officer, I want to speak to my lawyer. And when the law enforcement officer says, who's your lawyer? He says, Brian Steele. At that moment, the investigator leaves the room. He comes back moments later, so I don't know what happens outside of the room. But what we catch on video is that Investigator Hogan calls Mr. Steele. Mr. Steele's then placed on speakerphone. And Mr. Steele then speaks to Mr. Stillwell, tells Mr. Stillwell, don't make any statements, and I will come and see you. At that point in time, after that interaction ends, we have a jail call in which Mr. Stillwell tells his family members, Mr. Steele came to see me, but he said them folks ain't paid him his money yet. I can only tell you what Mr. Stillwell told his family members. I don't know if Mr. Steele came, but that is what Mr. Stillwell told his family members. So that is what we are referencing in this particular case. Next, in that same statement, he says, we don't speak about shit on wax. It's all my business. We know to kill the biggest cat of all kittens. Again, Your Honor, we believe that again is an admission and a reference to the killing of Donovan Thomas. And while to the average layperson, it may seem like just a fancy play on words, to the family of Donovan Thomas Jr., this is them bragging about the fact that they have murdered Mr. Donovan Thomas, who would be considered a biggest cat within that IF gang in 2015. So again, this goes to show several relevant purposes that we've already kind of just discussed very generally, and it would be admissible against Mr. Williams as a party admission and all of the other defendants as co-conspirator admissions and a declaration against interest. And then finally, Your Honor, our last category. And before we go to the last category, I want to introduce, I didn't speak about them, Your Honor, but I want to introduce several state's exhibits, 8, 9, 10, 11, 12, 13, and 14. They're going to all be screenshots from the mob ties video. After I approach, I will show defense counsel what those pictures are. But this will be just for the court to look at, but you'll see that members of the YSL gang are throwing up their gang signs, that there are other co-conspirators, Wooney Lee inside of the video, as well as Miles Farley, DeMonte Kendrick, and Durante Beebe. Your Honor, may I
You'll just give those to Ms. Weaver.
And Mr. Steele, I should show these to you so you can see what I just gave to the court. Okay, and Your Honor, the last category, and then I'll be sitting down and Mr. Floyd will be taking over the rest of the argument, is final evidence of leadership of the YSL enterprise and gang. Your Honor, in this indictment, we have charged Mr. Williams with being the leader of this gang. And so these are going to be lyrics or statements, that will reference specifically him acknowledging that he is the leader of this gang. So we have first from his song 730, which is Mr. Williams and Jimmy Winfrey. This was released on YouTube September of 2014. It says, come enroll in a YSL school, and I swear I'm the principal. And he says slime in the background. I do not care if you slime for $1 and a change. It's the principal. Again, this is Mr. Williams and Mr. Jimmy Winfrey. The defendant, as to this admission, is Mr. Williams, who is the speaker. Again, all the defendants here are charged with the conspiracy to violate RICO. This admission provides proof of the existence of the YSL enterprise, that Mr. Williams is attempting to recruit more persons to enroll in this YSL school. It also demonstrates that he's the leader of the enterprise. He's the leader of the enterprise. This would come in against Mr. Williams as a party admission, Mr. Winfrey because he's in the video as an adoptive admission, and all defendants as a co-conspirator admission. Next is his statement from his song Anybody, which it was Mr. Williams. This was released on Apple Music in April of 2018. He says, I ain't never killed anybody, but I got something to do with that body. I told him to shoot 100 rounds, ready for war like I'm Russia. I get all types of cash. I'm a general. We know that general leads armies, Your Honor. And so it is the state's contention that, again, he is referencing the fact that he's the leader of this gang. He is a general. And he also says, I never killed anybody, but I got something to do with that body. He right. We have alleged in this indictment that Mr. Williams ain't killed nobody, but he does have something to do with that body. He has, prior to the shooting death of Donovan Thomas in January of 2015, Mr. Williams is the one that rented the car that we are alleging that the other YSL members who shot and killed Mr. Thomas were in. He rented that car about 2 days before, Your Honor. Also, as it relates to the shooting, the stabbing of the stabbing of Jaden Myrick within the jail in February of 2022. We have evidence that both Jaden Myrick, who actually did stab Mr. Bennett, as well as Christian Eppinger, who was going to attempt to stab and kill Mr. Bennett, sought permission from Mr. Williams before actually doing the crime. So Jaden Myrick, in speaking to co-conspirator Damikian Garlington and Khalif Adams, was trying to get permission from Mr. Williams to execute the actual stabbing of Mr. Bennett. When Mr. Myrick was not successful, Christian Eppinger, about 2 weeks later, reached out to Antonio Sumlin, who's also a co-conspirator in this case, to seek again permission in order to effectuate the stabbing of Mr. Bennett. Thankfully, at that time, Mr. Bennett was relocated, and thus the second attempt did not occur. But again, showing that they had to get permission from him in order to execute or do any of these crimes, showing again that he is the leader. Again, this would go in for the relevant purposes that we've already discussed previously, but then also it would come in as to Mr. Williams as the party opponent admission, and then as all defendants as the co-conspirator admission and declaration against interest. Our next verse is, I was a capo in the hood way before a platform mention. Again, signifying that Mr. Williams is the head, the leader of this gang, of this high-ranking enterprise, again, for the same reasons. He's saying, I was doing this way before there was a platform mention. So this is before YSL was a record label, way before YSL was anything else but a gang, that he was the head of it in the hood, way before any platform mention. Again, this would come in for the reasons we've already stated, and then as a party admission against Mr. Williams and a co-conspirator admission against all the other defendants. And then Then we have I'm at the top with the bro, the ooh head honcho. Again, this statement came from Mr. Williams' song Who, which this was a compilation album where Mr. Williams is featured on the album, but this is his particular statement. Again, showing that he was at the head, or he is the head of this YSL gang. He is the leader and the head of this gang. And one that did not make the board, Your Honor, but was from one of his songs called F Cancer, which was released on Apple Music in January of 2016. He has a song, Got a Lot of Followers, A Perfect Leader, I'm a Boss, I Call the Shots. Again, I've already spoken about what Jaden Myrick and Christian Eppinger wanted to get approval from Mr. Williams. But then we also have, Your Honor, as it relates to Marquavius Huey, after it is believed that Marquavius Huey robbed a particular producer, we have text messages of Mr. Williams telling Marquavius Huey to take that stuff back or somebody was going to get killed. Again, showing that he can show his leadership, that people are going to do what he says, and if they don't, there's going to be a result, and probably a negative result. So, Your Honor, these are just a sampling of the lyrics in which the state would seek to introduce for those various areas and reasons. And with that, I want to turn it over to Mr. Floyd.
Mr. Floyd, before you get started, Mr. Weinstein?
5 minutes, maybe, Your Honor.
Kind of accommodate the over 50 crowd, okay?
Okay. All right. As a voting member, I appreciate it. Thank you.
Oh, we're missing Christina though.
Can't start without you.
No, we were waiting on you. Thank you. All right, Mr. Floyd, you may go ahead and begin, sir.
Thank you, Your Honor. My component of this is going to be focused on RICO. I'm going to try to minimize duplication to the greatest extent possible. As Your Honor well knows now, count one is a RICO conspiracy count. The defendants are charged with conspiring to violate both 1614-4A and 1614-4B. I'll just emphasize B for a second, because a substantive violation of that requires that a person, as relevant here, associated with an enterprise, conduct or participate in that enterprise through a pattern of racketeering activity. A conspiracy violation requires that they conspire with at least one other person to do that. Generally, this means that the state has to prove and therefore can introduce evidence that there was an enterprise. Each defendant conspired to participate or conduct in that enterprise. Those are not exactly the same things. Participate is a lower level requirement. Conduct connotes some level of control, direction, etc. And that at least one conspirator committed an overt act to effect that conspiracy. General conspiracy law applies here in the sense that a conspiracy can be inferred from circumstantial evidence. I've cited the Akintoya case here. This is a Georgia RICO case, relatively recent, and it simply makes the point that either direct or circumstantial evidence are sufficient to prove an enterprise, which means that inference, deduction from conduct, which shows a common design on the part of the persons charged to act together for the accomplishment of an unlawful purpose. It doesn't have to be a full-blown confession. It doesn't have to be expressed. And Akintoya went on to emphasize that this is not, and I know we've talked about this in earlier hearings, Your Honor, this is not the meaning of a minds necessary to form a contract. A mere tacit understanding is sufficient. It does not actually require that any words ever be spoken or there ever be any written communication, so long as the jury is persuaded. Here, of course, we have lots of words, we have lots of communications. Similar principle for an enterprise. Its existence may also be inferred from circumstantial evidence. An enterprise is just a group of individuals who are associated in fact. RICO divides its enterprise definition, beginning by listing a lot of things that are formal, legally recognized entities like corporations. And then it has this second component, less formal entities, a group of individuals associated in fact. That's what we're talking about here. I'm not going to repeat everything here to say that it also applies to the Gang Act. I'll just say the definition of a criminal street gang and the definition of an association in fact enterprise are very, very similar. And essentially everything I'm saying today is going to have application to the gang charges as well. I won't belabor that. The Georgia Gang Act is a linear descendant of RICO, crafted for a specific special application. So many of the principles are the same. As with a conspiracy, it has long been recognized that a jury can infer the existence of the enterprise on the basis of circumstantial evidence. They can draw the natural inferences that come from evidence of association. Importantly, every defendant here is a defendant in the RICO conspiracy count, which means the evidence that we're talking about is applicable to, relevant to, admissible to every single one of them. All right. We've talked a lot up to this point, and they helped establish at least one of its alleged purposes or the means and methods by which it achieved those purposes. Any one of those would have been sufficient. All of those were present there. All of those are present here. Similarly, in United States v. Wilson, an Eastern District of New York gang case, they referred there, the enterprise was called the Stapleton Crew. Rap lyrics were appropriately permitted into evidence because they helped to determine, again, first of all, whether that enterprise even existed, and secondly, whether it was engaged in racketeering activity. The court denied a motion to suppress both. So, relevant to the existence and nature of the YSL enterprise, these are things that my colleague Ms. Hilton has mentioned, so I'm not going to belabor them. I'm not going to go into as much detail. I just want to emphasize them from the RICO perspective. So, beat a murder rap, me and my slimes above the law. Again, this is Mr. Steelwell saying, me and my slimes. There are slimes. Mr. Steelwell is part of them. They function as a group. They are above the law. And in the indictment, we specifically allege, among the things, the goals and objectives of this enterprise was establishing a fearsome reputation, one that intimidated potential opponents, one that protected the gang's reputation and territory and expanded it. This is all consistent with that. YSL won't fold. Pick his ass off from the balcony. Murder. Wipe a nose. Murder. Bragging about beating, went too far. And the first one, bragging about beating a murder rap. In this case is replete with murders, attempted murders, conspiracies to commit murder. And it's YSL won't fold. It's not Mr. Williams saying I won't fold. It's him saying YSL won't fold. He's speaking for YSL. He's confirming YSL's existence. Relevant to association with and participation in the gang. Mr. Kendrick tells us, and we've looked at this language again, I'm emphasizing it from the RICO perspective. I rep my life for real. Let's just stop and look at that for a minute. He's saying, I'm telling the truth. This isn't hypothetical. This isn't performative. I rep my life for real. For slimes, you know I kill. I will kill for this gang. How you doing? I'm Yak Gotti. I got bodies on bodies. Right, Mr. Kendrick? Again, he's told you he's a slime, and now he's telling you he's got bodies on bodies. This tells you there's an enterprise. This tells you the nature of the enterprise, or at least part of the nature of the enterprise. We've discussed the I shot at his mommy comment. All right, but again, Act 41 specifically is Mr. Lucci's mother does get shot. It really happens. These are not things that exist only in some performative, creative ether. They have real world implications. People get hurt. People get killed. Mr. Williams, ooh, I done for the crew. I done did the robin. I done did the jacket. Right? We've alleged a conspiracy to violate 1614(4)(a), acquiring money and property through a pattern of racketeering activity. He's saying, I done for the crew, not for himself, the crew. I done did the robin. I done did the jacket. Confirming A, his involvement, B, the fact that it involves, quote unquote, the crew. Again, this isn't pulled out of the ether. Here's Mr. Williams displaying a YSL hand sign during a video call with Mr. Mender and Mr. Huey. At that time, Mr. Mender was in the Fulton County Jail. It was recorded on a video jail call. We're not pulling the existence of YSL out of nowhere. Violent nature of the enterprise. What I've been talking about previously was existence and to some degree nature. Now a little bit more about the nature. Specifically, there are I can't remember the total count. It is more than 20 acts, overt acts and acts of racketeering activity that are alleged in this case that involve a murder, an attempted murder, conspiracy to commit murder, an aggravated battery, an aggravated assault, or a weapons possession charge. They're replete throughout the case. In this case, on this slide, I've simply listed, Your Honor, the overt acts that also can constitute racketeering activity that are involving rival gang members. And this tells us something because we have a situation where YSL is defining itself in part by who its rivals are, by intimidation of them, by threatening them, and frankly, by killing them whenever possible. And so Mr. Thomas, Mr. Holmes, Mr. Drinks, all victims of murder, all alleged in the indictment to be associates of rival gangs. Mr. Hendricks, Mr. Saunders, Mr. Bennett, all attempted murders, all alleged in the indictment to be associates of rival gangs. Mr. Bennett, the second act concerning him, as Ms. Hilton explained earlier, there was a second conspiracy to kill him. The first he was stabbed. The second, there was a second murder effort put together. It was detected and intercepted. So he's never actually physically threatened, but the intent was to kill him. And so we see this. We see these actual acts. And then we look at language like gave the lawyer close to $2 million. He handled all the killings. Right? This is a reasonable person can look at this language and say, Mr. Williams is saying, I'm giving a lawyer $2 million. He's handling all the killings for YSL. Okay? Not just Mr. Williams, everybody. He's paying for everybody. All right. It's all mob business. We known to kill the biggest cats of all kittens. There's a group here. It's got a business. Its business is mob business. Part of that mob business is murder. A reasonable witness can look at that and fairly draw those conclusions. We heard the language about Unfunk, one of our defendants, what it means. Again, I got mob ties, using the same terminology, bragging about the death of a rival gang member. Mr. Williams, we really be slime, association with the group, we committing them crimes, the nature of the enterprise. You want to be slime, go catch you a body. Again, the nature of the enterprise. We keep switches on our Glocks, right? Turning a Glock into an automatic weapon. Fires over 1,000 rounds a minute. That's the Glock. It has a switch. It was seized from Mr. Williams' home. Again, we're not making this up. We're not pulling things out of context. Evidence of YSL's nature, violence against law enforcement. We've looked at that. We've heard the refrain, hey, this, that slime shit, YSL shit, killing 12 shit. We know that there will be testimony that 12 is a reference to law enforcement. What actually happened here? Act 163, YSL associate Christian Eppinger shoots APD officer David Rogers. Christian Eppinger, YSL associate, also shoots at APD officer William Johnson. Fortunately, Officer Johnson is not hit. This is a connection. These lyrics, these videos don't exist in some detached isolation. They are predictive of things that will happen. They are boastful of things that did happen. They are intended quite deliberately to tell the world there is a YSL, what YSL does, what YSL will do, and if you happen to be one of its rivals, what will happen to YSL. And this is, I'm nearing the end of this, Your Honor. As Ms. Hilton pointed out, we have language very specifically from Mr. Williams in which he is describing himself as a leader. Recall when I began 1614-4B, one of the substantive offenses the state's alleged the defendants conspired to violate includes conducting an enterprise, i.e. leading, directing an enterprise, right? Here's Mr. Williams saying, come enroll to the YSL school, confirming there is a YSL. I swear I'm the principal, the leader, the head person, all right? In case that seems to be nebulous or inconclusive, let's take a look at the next one. I get all kinds of cash. I get all type of cash. I'm a general. Generals lead armies. Generals don't function by themselves. They have an army. I told them to shoot 100 rounds. I told them. He tells people what to do. Those people do it. Shoot 100 rounds. That's a thing a general can do. I was a capo in the hood, okay, adopting traditional organized crime language, a capo decima, a capo regime, head of a group, of a subgroup within a larger organized crime family. I'm at the top, head honcho, got a lot of followers. Well, here we have confirmation. He's the head honcho of something. He has followers. I'm a perfect leader. I'm a boss. I call the shots. In these 5 different snippets, Mr. Williams says at least 8 different ways that he is in charge of a group of people. And the language, while sometimes somewhat euphemistic, makes it clear, read individually or collectively, that this is a group of violent people willing to engage in crime. He describes himself sometimes in a neutral tone like principal, but at other times using terms like capo, general, head honcho, shot caller. In this context, the meaning of that is clear. But it is certainly at a minimum probative. It is certainly at a minimum something reasonable jurors could look at to conclude that, in fact, Mr. Williams is the leader of an association, in fact, enterprise that engages in violent crime as part of its fundamental nature. That crime is committed against rivals, against civilians, and against law enforcement. And so the state's discussed a number of different reasons why this evidence is relevant and is admissible. I just wanted to emphasize it in the specific context of the RICO count that we have, because that count is applicable to all of the defendants. Thank you, Your Honor.
All right, sir.
Your Honor, in those guidepost cases we talked about in terms of how these progress, a few matters to consider in terms of the state's request as we close here for conditional admissibility. The Taylor case, that was the 2022 U.S. District Lexus 206008 case, again, at the start of our PowerPoint, talking about, Your Honor, the strong preference for conditional admission. In that case, rather than a pretrial hearing, but at least making sure that folks understand that matters can be conditionally admitted. We've got that White case at 2023, U.S. District 122492, discussing again that the conditional basis of the admission still leaves the door open to object at trial in the event the proponent of the evidence, that would be the state in this case, fails to lay the proper foundation. Of course, it would leave the door open for a 403 objection as well. And then lastly, the Torres case, 435 F sup 3rd 526, 435 F sup 3rd 526, dealing with co-conspirator hearsay, discussing again that the moving forward with the with conditional admissibility still leaves the door open to objections at a later point in time, but the objections that the court believed at that earlier pretrial stage were unsustainable, said that those could not be raised later. And let me read it there. Defendants are able to object to the admission of particular statements as not properly within one of these 3 categories. Those were the 3 co-conspirator hearsay categories that we went through from that case. But the court rejects their arguments regarding the specific statements discussed in the government's motion. Those will be the ones that would be that were considered at length there. Now, Your Honor, for this hearing, we do have It's States Exhibit 18, a complete print version of the PowerPoint. States Exhibit 19, the gang lyrics concept chart, that was the flow chart. And at 20, the 4 boards that were used by Deputy District Attorney Hilton and Special Assistant District Attorney Floyd for purposes of their argument. I'm going to tender these into the record at this time.
Your Honor, I'll point out that some of the defense.
Can you share your microphone?
Some of the defense guys are
Okay, well, you'll get it, but you've seen the PowerPoint and you've seen the exhibits, right?
Well,
Yes or no? Yes or no? Have you seen the PowerPoints and the exhibits? I'll make sure you get a copy. Okay, all right.
And I know Ms. Love, Deputy District Attorney Love is working on that, Your Honor.
Yeah, make sure everybody gets a copy of that.
So, Your Honor, what's the defense left with when the 403 objection fails? They're again left with an unsupportable genre-specific exclusion. And what they're asking for is essentially for one single genre of music to receive some sort of insulation from the application of the rules of evidence. And in this Commonwealth versus Knox case from Pennsylvania, that was rejected when it came to criminal charges, but the principle still applies. There's no First Amendment protection for lyric evidence, speech evidence being used as proof of a crime. And we're back to where we started because this is actus reus and mens rea territory. So this defense seeks that unsupportable conclusion, and it's actually, they're asking for the court to impose sua sponte, rather than the legislature through the process that actually would apply, a content-based rule of exclusion. In other words, if it's this kind of lyric from this kind of music, it should be out. And the legislature likely could never pass anything like that, as a McKinsey case from our Supreme Court points out. That raises actually, Your Honor, and we know the court's sensitive to this, a separation of powers issue from what they're asking of this court. They're asking for essentially a judicially crafted rule of exclusion, which is exactly what 402 doesn't allow. And that's what is told to us in terms of a court does not have the authority to rewrite statutes. That's Starr Residential versus Hernandez. And then lastly, this quote from now Justice Pinson back when he was Judge Pinson in Stockert versus Rogers, Georgia's Rule 402 chose constitutional and statutory text over, in that case, and this is definitely, we recognize not the court, judicial imagination as a touchstone of admissibility. So we do not have, Your Honor, a First Amendment concern here at all. The speech is not what's being prosecuted. The behaviors are what's being prosecuted, and the speech in form of the gang lyric is admissible against them. And we talked about reductio ad absurdum analysis, Your Honor, and in terms of the Unabomber, if somehow his manifesto was set to music, would that have made it inadmissible? If the Turner Diaries, Judge, had been a musical, would someone have seriously contended that they should not have been admitted against Timothy McVeigh? And yet the extension of the arguments we're seeing here really grabbed that. Similarly, Your Honor, the extension of the arguments would appear to say that an additional Miranda question should be asked of suspects. In other words, if you sing or rap your confession, you're aware that won't be admissible. And Your Honor, that is not the law of the state of Georgia. That is not the federal constitution law. And that is not the sort of concept that should apply in this case. Again, Your Honor, for the particularized lyrics we've admitted, we have introduced and discussed today, we ask that the court conditionally admit them. We additionally request, Your Honor, for those that we will admit that the court apply these principles and ask for those to be conditionally admitted pursuant to the case law that we have presented. And lastly, Your Honor, we respectfully request that the defense motions based on Rule 401, 403, and of course the First Amendment be denied and this evidence be treated in accord with federal and Georgia law.
All right, thank you, Mr. Carlson.
Yo, hit that like for deal Christian. Yo, for deal Christian, smash that bell for the upsy. Yo, smash it, just smash it. Hit that like for deal Christian. For deal Christian, smash that bell for the upsy. Yo, smash it, just smash it. Hit that like for deal Christian.
Your Honor, how long do you plan on going today? All right, thank you, Your Honor. Good afternoon, Your Honor.
All right, good afternoon, sir.
Doug Weinstein for Diamante Kendrick. Wow. Wow. That is a lot to respond to. How fun it is to set up straw men and knock them down. The state is saying that the defendants are asking for a special exception for a single genre of music. We are not. That is nonsense. We are asking essentially for the same thing that the state is. Use the Georgia rules, use the law, apply it in this case. But I will say this about rap music, and let's call it rap music, not gang lyrics or rap, we can call it rap lyrics. As Professor Dennis at the University of Georgia says, rap is the only fictional art form treated this way. No other musical genre and no other art is used in the same way and to the same extent. And there's so many examples of that. Look at Kevin Spacey. Kevin Spacey is accused of felony sexual assault up in Maryland in December of 2018. He's played reprehensible characters in movies, repeatedly, in TV shows. None of that is dragged in. He's brought to court in the UK. I appreciate that's not the US. His roles are not dragged in. So we hear a lot of things about what Yak Gotti rapped. Yak Gotti is not on trial here. Diamante Kendrick is on trial here. And there's a giant elephant in the room, which is that we're ignoring art. There is art here, and the art has to be separated from the real life. And I do not believe, although the state does not address that.
So wouldn't the art fall under the First Amendment?
Art does fall under the First Amendment, Your Honor.
I'm just asking this, okay? Because, I mean, you know, we're all here to, I'm here to kind of make some preliminary decisions, but
certainly.
Wouldn't it, I mean, if my art or what I am, my genre or what I am trying to assert is just happens to be criminal in nature, or maybe a statement against interest, or maybe some other type of admission, would the same rules apply?
Well, I think what you have to do and what your task is, you're fortunate enough to have this task, is to separate what is the expression of a character, an artistic character, from what the author or the lyricist is saying. Lyricists write things for characters to say. That has happened in music for years. For years. I like John Prine. John Prine, when he was in his early 20s, wrote Angel from Montgomery. I'm an old woman who comes from Montgomery, who flies from Montgomery. No one thinks John Prine is an old woman. He writes hello in there about old people. And what they're thinking, it's not the same.
But if my lyrics or my artistic expression relate to an action or my mental state, wouldn't they be subject to being admitted, or a court considering them, or a fact finder, a jury considering them for what the reasons that they're authorized to?
Yeah, I understand, but only in rap music do you say that the person, the character rapping, the persona rapping, in this case, the persona Yak Gotti rapping.
Okay, that's just my name. That's my stage name. That's the name that I go under. I'm still tied to that particular person. Like, it's still tied to your client, right? Yak Gotti is your client's nickname, right?
Yak Gotti is
or stage name.
Yak Gotti is a stage name. That's correct.
All right.
But when Yak Gotti is rapping, it's not proper to take what he's rapping and say, that is the mental state of this person. That is what he is thinking. That's a perspective of his song, of his rap. And from where he comes from, he is expressing views that come out of that community. He is making cultural references. He is speaking. Am I going too fast?
No. I need something right quick. Thank you.
He's speaking.
One second.
Sorry, I'm sorry.
Go ahead, Mr.
Ready?
Weinstein. Yeah,
Okay.
I'm ready. Go ahead.
He's speaking in the conventions of that genre of music. And in gangster rap, what do the producers, what do the record companies, and frankly, what does the audience expect? They expect these lyrics. So he provides these lyrics.
But if the lyrics fall under actus reus or mens rea, aren't they, don't I have to first look at them under 401? As Mr. Carlson made this nice linear diagram, I like that because I'm trying to follow things from A to B, C to D. But why would they not, why could not the court consider those under that particular line or lineage?
I think that's a great line to look at it. Let's start with 401 and 402. Are they relevant? And the lyrics spoken as a character are not relevant to the actions of the person who inhabits that character on stage or on the album. There's a distinction between those that the court has to draw just to even see if they're relevant under 401, Your Honor. And then once you determine if they're relevant, let's assume they are relevant. I'm not there yet. I don't agree with that, but let's assume that they are relevant. Once you're determined that they're relevant, then you've got to do the 403 analysis. And
actually 402.
402 and then 403, yes. But then the question is, I know what the state's going to want to do. Throw it out there to the jury. Let us put our competing arguments, our competing meanings before the jury and let them decide. But when you've got something that is unfairly prejudicial, which is what rap music is, what you'll hear Mr. Steele's experts testify about at some point, what you'll hear him proffer when he argues, they're unfairly prejudicial. And if you do not serve as that gatekeeper function, Your Honor, then that jury is going to take the meaning and perhaps misconstrue it or misattribute it. And that's just not proper. And
that's that. Well, it depends on one, whether it's admissible, and two, it depends on how good your advocacy is.
I agree with that, Your Honor. So let's see how I do today.
So yeah, I mean, it's for the jury, of course, to give it the weight and engage it within the confines of what they hear in this courtroom and the instructions that they get from this court. So isn't that ultimately, if admissible, what the jury's going to do? You're going to sift and weight this evidence?
But if it's unfairly prejudicial, Your Honor, it should not even
How would
come
you say
in.
it's unfairly prejudicial?
Because of the nature of the music, the violence in the music, the extreme language in the music, it is prejudicial.
Okay, but
if it was,
I'm sorry. Go ahead.
Okay.
Go ahead.
We'll get there. That's fine. And let's talk about why it's prejudicial. Part of it. In Ward v. Rock against racism, 491 U.S. 781, 810 would be the Penn site, note 7. Justice Thurgood Marshall quotes, he's quoting someone else, "New music always sounds loud to old ears." And that's what we've got here. New music always sounds loud to old ears. The state knows that. They know what this music is going to sound like to the jury. And it has always been thus so. When I was young, in my day, we listened to the Sex Pistols, offensive stuff. God Save the Queen, she's not a human being. Elvis Costello, I'll stand on your grave and tramp down the dirt. Butthole Surfers, all of it offensive. But people listen to that.
But they wrote it. I mean,
there's no other art form that is treated this way. There are other artists in other fields, country music, for example, that do not have to, when they face charges, they do not have to face having to defend the lyrics that they wrote or the songs that they sung. I would just like to briefly, and I apologize, I do not have a printout of this, but I can circulate it. It's only 4 slides, but I think it would just aid the court if I put them up rather than reading them.
Do you have them on a thumb drive or anything like that?
I can get that I can email it to you if you'd like.
No, I was gonna say you could share it on.
Can we put it up on the screen? Thank you.
All right, okay. Let's let technology do a little work for us, okay?
Absolutely, Your Honor.
All right, okay. All right, okay.
Okay. Let's just briefly, I'm not going to belabor this point with the court.
And we'll of course, you can, for the purpose of this hearing, I'll consider it as D1, okay?
Thank you, Your Honor. Okay. So let's look at some people. And by the way, when I'm bringing these up, I am doing it under a similar analysis that you would do in this case. In other words, I'm going to argue that there has to be some nexus between the crime charged and the lyrics in the case. That is what, if you look at all the cases, there has to be some nexus.
What do you think to go to access reus or mens rea?
Yeah.
First, okay.
So here, let's look at this. Johnny Cash. All right. In 1965, he faces charges in federal court. What's he done? Allegedly. Well, he pled guilty. So he smuggled 688 Dexies, 457 Equinel into the U.S. from Juarez, Mexico. He pleads guilty in federal court, but he never has to face Delia's Gone. Delia's Gone, all these songs, by the way, are written before this. They could have used Delia's Gone, okay? She was low down, trifling, cold and mean, evil, grab my submachine. Okay, next, please. Willie Nelson, famous marijuana user, loves it, advocates for it. In 2010, they found marijuana on his tour bus in Texas. 2006, 1.5 pounds of marijuana and 3 ounces of shrooms. You couldn't really speak directly about marijuana in country music in the 70s, but he alludes to it. So in his song, In a Memory, off the album Willie Nelson and Family, he says, I'm a love that you know from a song. I'm a voice on a green telephone. I'm a day that lasted so long. 1971, they did not bring this up. It was not used against him.
Are you saying he was under the influence of marijuana?
When he wrote that, Your Honor?
Or maybe some other...
well, I'm not going to say what Willie was doing then, Your Honor.
Okay, all right, okay, all right.
Next, please.
I'm with you.
2006, Glenn Campbell. Not his best look. Okay, he's charged, and by the way, there's a connection, charged with aggravated assault, drunk driving, hit and run. Here's his song, Tequila. I was at the, and I'm not going to sing it, Your Honor, so you'll have to forgive me.
Did he write this song after the Before the, okay.
Every song I present to you was written and released before the charges.
Okay, I'm with you.
All right. I'm not going to be sneaky that way. I was at the bar with my drinking team. It was me, Jack Daniels, and my honey, Jim Beam. We were kind of blitzed. Thank you, Your Honor. Would you like to perform it? Because I know that you're famous on the internet for your rap lyrics.
That's other people pirating me. Okay, so.
I know a good copyright lawyer.
All right.
But here's these drinking songs that are not brought up against him. Next, please. This is the last one I'll do. Tim McGraw and Kenny Chesney, charged with disorderly conduct, and McGraw is charged with a felony for assaulting a police officer in 2000. And I believe this is a Chesney song that was released before then. It's a great song. It's the simple things in life, like the kids at home and loving wife. I'll just jump to the end. The devil takes your hand and says, no fear, have another shot, just one more beer. Next, please. Last, this is not a song, but it's a statement of frustration from a singer and a songwriter. That's the frustration that I bet all of the defendants in this room feel. David Allan Coe wrote the most racist, offensive country music probably ever recorded. Released them on underground albums. I am a songwriter, you know, and to me, it has always bothered me that actors in the movies can say whatever they want to say, kill people, rape people, and do things that no one ever accuses them personally of being that way. But when you write a song and then all of a sudden you're being accused of something, to me, Songwriting is painting a picture, and all you have, this is important, all you have to work with is words. That's all they have to work with, words. It's stereotype stuff, and he's talking about the racist language he uses. It's stereotype stuff that you hear growing up that immediately puts a picture in your head. What Mr. Kendrick is singing about is what he grew up around. What else is he supposed to sing about? He's not going to sing Daydream Believer. He's not going to write that song. He's not going to write about puppies and rainbows and unicorns. This is what he writes about. And now it's being dragged out, and he has to sit in this court and defend. He knows he has to defend these charges, but to have to defend the lyrics that he's writing? Come on. Come on. Gosh, thank you. That's enough. You can turn it off. Anyway, I'll be happy to circulate this later.
If you'll send a copy of that to your colleagues and Ms. Weaver, please.
Absolutely, Your Honor.
That'd be fine, sir.
Okay.
It'll be D1, as I said.
Thank you. Your Honor, in instances where courts have admitted rap lyrics, it's all about the connections, as you've heard today already. Look at Wilson v. State. That is a case that the state has cited. Wilson v. State, 315 Georgia, 728. It's a 2023 case. And in that case, the Supreme Court of Georgia said, sure, you can let in this rap video. That's appropriate. But let's talk about the rap video that was admitted, which you didn't hear about. It was shot 11 days after the robbery and murder at issue in that case. And what's it show 11 days later? The defendant's flashing a gun that could have fired the bullet recovered from the victim's body, and singing about hitting his first lick, in other words, committing a robbery. So the court said, well, given the probative nature of the video and it not being unfairly prejudicial in light of its probative value, then according to Wilson, the video being admitted was proper.
What was it admitted for the purpose of?
I would have to pull up that case.
If you can tell me. If not, I'm going to pull.
I can't tell you right now, Your Honor.
Now, anyway, so.
But I believe it was admitted for evidence of guilt, but please let me get back to that. This case is different. Oh, did y'all put up the bodies on bodies line over there? There we go. Hey, how you doing? I'm Yak Gotti. I got bodies on bodies. Okay. When Yak Gotti is rapping that, first of all, he's not rapping about killing people or allegations relating to or the tragic death of Donovan Thomas. He's not rapping about that. What's he rapping about? What is this young guy rapping about? He's rapping about sleeping with a bunch of women at the same time. Or maybe not. Maybe that's not it. Maybe he's rapping about when he was a high school football star over at Grady, and he was laying people out on the field, bodies on bodies. He's not rapping about a murder that happened 11 days before the song was written or performed. He's not flashing guns capable of firing bullets found around Donovan Thomas or bragging about committing his first murder. So it's a different situation. You know what's more analogous is U.S. v. Stevenson's 550 F sub 3rd 1246 from the Middle District of Florida in 2021. The U.S. attempted to introduce 3 rap videos against the defendant charged with possession with intent to distribute marijuana. In rejecting the admission of those videos, the court said there was no evidence as to when the lyrics were written, the songs recorded, or the videos edited. And they concluded that the videos were too remote in time to have much probative value, or were even of dubious probative value in this case. Where's the evidence of when these lyrics were written and recorded with respect in time with respect to these underlying allegations. I don't see it here. I don't think it's been presented to you today, but I'll tell you, and I'm going to go through the 6 specific lyrics. I'm not going to take much time, but I'm going to go through the 6 specific lyrics that they want to introduce, or they've said they're going to introduce against Mr. Kendrick. And you'll see that they're too remote in time.
So you're saying that that reference is something, 2 other things that potentially Mr. Kendrick was involved in, playing football or getting with ladies? Is that what you're saying?
Here's what I'm saying. That unlike our United States Supreme Court that thinks they're experts in history, I think that courts are experts in law, and that they shouldn't get into the business of musicology and trying to figure out what that rap lyric wrote when Mr. Kendrick wrote it or performed it.
Okay, well, let's go back to Wilson.
Sure.
Wilson, the dope video that's referenced in there, it references the murder weapon. It connects the murder weapon and implicates one of the defendants in the
absolutely
close in time. So I don't know what this particular thing is going to be tied to, but one of the state's theories is, as mentioned by the state, is that bodies on bodies is that he's been involved with some homicides.
Okay, so I don't know about some homicides, but he's accused of one in here. But the bodies on bodies, let's see when that was released. I'm going to look to that real quick. So I have it here. 2013. That was from Dream, released in 2013. And there's a distinction, by the way, between when something is written, when it's recorded, when it's released. But it's released in 2013. When is the Donovan Thomas murder? 2015. 2 years later. So what does bodies on bodies have to do with the murder of Donovan Thomas? Nothing. Nothing. Why is it here? It's here because it's prejudicial. The state knows this. That's why it's here. That's why rap music is introduced. That's why no other genre is introduced, because rap music is inherently prejudicial. I don't want a special exception for it. I just want you to do the 403 analysis, Your Honor.
So you're saying it doesn't have any linkage? Is that what you're saying?
0. If I could say less than 0, I would. No linkage.
Yeah, sure. Before I move on with that, hold on 1 second. I thought he released Dream. Is that what you're saying this song comes from?
Yes.
And that was
well, that's what the state says it's from, yes.
I think that was released April 17, 2015. That's what I show on the state's page 43 of state's 18.
I pulled this 2013 from the state's particularized motion.
So I think it's released on Apple Music April 17th of 2015. When was Mr. Thomas?
Recorded 2013. Recorded 2013.
But it was released April the 17th of 2015.
When did
the homicide occur?
January 2015. But if it was recorded in 2013, how in 2013, recorded, correct? How when recorded in 2013 did Mr. Kendrick know that Donovan Thomas was going to be murdered in January of 2015? Did he record it, keep it in his back pocket, and wait for the murder to release it? I think that's absurd.
Okay, all right.
You can take.
All right, well, that's one.
Oh, you're on? Oh, I'll go through them all.
That's one. Well,
I got time.
Yeah.
Let's do it. All right. I'll get there in just a moment, though, Your Honor. I'm not going to go State versus Skinner up through State v. Skinner again. It's been beaten to death. But that's the New Jersey Supreme Court case that we reference in our briefs, where they basically throw out the rap lyrics, identifying with Bob Marley, and et cetera. But again, on the unfair prejudice, let's look at I'm going to give you a quote from Old Chief v. U.S., 519 U.S. 172, Penn site 180. As the Supreme Court has held, the term unfair prejudice as to a criminal defendant speaks to the capacity of some concededly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offense charged. That is exactly the risk, that is the danger of admitting these rap lyrics in this case. And look at Rule 404B. Introducing these rap lyrics, I think the clear intent is to show the character of Mr. Kendrick, and that Mr. Kendrick has a propensity to commit the crimes alleged in the indictment. Look at this evil rapper and listen to his words. They're terrible, horrible. Listen to what he says. What a piece of crap character he is. Who else would sing these songs? Who else would rap this music? Heaven forbid our kids hear that. That's not appropriate use. It's not appropriate use. I'm going to leave the state's other arguments right here to Mr. Steele. But I do want to go over the particular lyrics.
The rest of your lyrics.
Yeah, I'm going to go over the lyrics right now.
Let's talk about your lyrics.
Let's talk about lyrics. Let's go. Okay, I don't know if, we'll just go one by one to make sure I hit them all. We've already talked about bodies on bodies. Okay. But again, what is the probative value of something recorded in 2013 to something that happened in 2015? It's got none. And I will not concede that Yak Gotti and Diamante Kendrick are the same person, just as I would not concede that Ian McKellen is Iago. You know, it's not the same situation. This is a character that he portrays on screen, in videos, in concert, but that's not Diamante Kendrick. Bodies on Bodies has multiple meanings. A convention of rap music, as I've been learning, is the importance of double and triple meaning. Finding double, triple, quadruple meaning is it's a critical skill to the lyricist in rap. And that's what you've got with things like Bodies on Bodies, multiple meanings. Let's assume, go ahead, assume Bodies on Bodies means dead bodies in the streets. Assume it means that. Whatever. 2013, Mr. Kendrick doesn't have any accusation that there are bodies on bodies there. And it's a convention. It's what his audience is looking for and demands in gangster rap. But it has multiple meanings. No proximity between the time of the recording of that and the unfortunate death of Mr. Thomas. If you let it in, there's a high risk that the jury is going to misinterpret that. And it will unfairly prejudice Mr. Kendrick.
Okay.
All right, next lyric.
On to the next.
I've only got 5 more, Your Honor.
Okay, all right, that's fine.
Next lyric, running from 12, then I jumped through the fences. Again, it's sung by Yak Gotti, his alter ego, you could argue, but it's his stage performance. It's his name on stage. And again, we've got ambiguous, multiple meanings. What is 12? Running from 12. Is it running around his neighborhood at the age of 12? He had a friend named 12 when he was younger. Is it running with his friend named 12? Or is it the police? Or is it all three? Or is it, as good artists do, is it up to the listener to decide what it means? unfairly prejudicial. Lyric. I rep my life for real, for slimes, you know I kill. Take it to trial. Again, I'm going to argue that that's a lyric sung by Yak Gotti, the character, and not Mr. Kendrick. But regardless, I kill. Now I know I have said I killed it. I pray that when I walk out of here today and someone says, Doug, how'd you do today? I'm like, I killed it. I probably won't say that, but you never know. I kill refers to doing a great job when you're rapping in the studio. I kill refers to making money for the label. Multiple meanings. But the problem is, which one is the jury going to take? Next lyric. Excuse my language. Fuck the police, fuck them in a high speed from Slime Shit, March of 2016. Again, a lyric sung by Yak Gotti. It's a reference. It is a call out, Your Honor, to NWA with their famous song, Fuck the Police. It is social commentary. NWA sang it as social commentary. The character Yak Gotti sings it as social commentary. It's common. It speaks to so much in that community that I'm fortunate enough to not be able to really relate to, but what they deal with on a daily basis. But what is the jury, try as they might, and I know they're going to try hard, going to say when they hear fuck the police? One more, two more. Knocking off your big homie bitch, Mob Ties, April of 2020. Again, that has minimal value. And if you watch the video, and I'm sorry, I don't have it to play here today. If you watch the video, when Yak Gotti says, knocking off your big homie bitch, it is a call and response. Someone else says it, and then he repeats it. It's a long tradition in music. I mean, you can go back to Cab Calloway. You can go back. It was imported from Africa. Repeating things is a common trope, a common musical issue. And Cab Calloway, Michael Jackson, Missy Elliott, they all do it. They all repeat things. It doesn't mean he adopts them. He's in the video in a call and response situation. Last, YSL, wipe a nigga nose. Yak Gotti is in the video. He does not sing that. He is just in the video. And appearing in a video and nothing more should not be adoption of a lyric.
Well, do you have a choice to be in the video?
Well, do you?
I guess that's the question.
I mean, we all have jobs.
I guess that's a question that the jury will have to kind of ponder, right? I mean, it's not like somebody's filming and they walk up and they catch you in it where they got to get a release. I mean, but to play it, but or to put you in the video, but if he's standing behind or is one of the background people in that particular video or that song, isn't that something that the jury is going to have to sift out?
I do not think you can go to look at what Diamante Kendrick is thinking or what he's adopting based on what someone else is saying in the rap music video that he's in. Yeah, he's there voluntarily. He's not chained there, but that doesn't mean that he adopts that.
Okay.
And I'm just going to go back to this, Your Honor. It is only rap music. And you have to ask, that has to defend this. It's only rap musicians that have to come into court. And don't tell me, anyone else, that it's because only rap musicians get in trouble with the law. That is not the case.
Not relevant for each case has to be taken on its own individual merit.
Exactly. And so when you see all these other cases cited where rap music is admitted, All that I ask you to do is make an independent assessment for this case on a lyric by lyric basis, whether those lyrics are appropriate to be admitted or whether they should be excluded under 403. That's all I ask the court, Your Honor.
All right, sir.
Okay, thank you.
All right, Mr. Steele?
Your Honor, I was going to go next. That's okay.
Okay, all right. Mr. Short?
Oh, I apologize. Your Honor.
We'll take 5 minutes. Everybody take 5 minutes. We'll come back, okay?
Thank you.
All right. Is everybody back at this point in time?
Yes, sir.
Okay, all right. Thank you, sir. All right, Mr. Carlson, I'm giving you a little bit to think about, just in your concluding remarks or in addressing Mr. Steele's arguments.
Just a little evening homework, Your Honor.
Yes, sir.
May I proceed?
You may proceed, sir.
Your Honor, in terms of commonality in that position, there are going to be 2 points to make. And the first is, what isn't common? Well, what isn't common around these dimensions is YSL. We're not seeing the term YSL appear all over the country in all sorts of different venues and in all sorts of different rap songs, gang rap songs. What we're seeing, Judge, in this case and what's before this court in the instant proceeding is whether or not the specific lyrics the case is presented and the ones that will present at trial pertain and relate to evidence relevant to mens rea and actus reus components of these charges. So it was interesting, and even looking at it, oh, this is said by a lot of people, this is mentioned all the time. YSL isn't mentioned all the time across the country, but it is mentioned a lot in terms of forceful declarations of this gang's strength, this gang's behavior by these defendants, who now through their lawyers are attempting to mask that all and shield it from the application of the rules of evidence by claiming somehow it's art or common. And that gets to the next point, Your Honor. This didn't only apply to Mr. Steele's and doesn't only apply to Mr. Steele's point saying that this is somehow common. There were a legion of alternative explanations given this evening. Well, that's jury material, Judge. Is this art? Was I a aspiring rapper? I didn't really mean it. Those factors, Your Honor, are factors to be decided by the jury. Does this lyric, does the content of this lyric inform us something about whether or not this group constitutes an enterprise under Georgia law? whether or not it constitutes a criminal street gang under Georgia law, whether or not it demonstrates association with either on the part of the defendant, whether it demonstrates the nature of either one, whether it goes to whether or not this individual committed one of the underlying offenses in this case, or whether he was just joking, or whether he just likes to pretend. Those are jury issues, Your Honor. They're not authorizations under Rule 403, much less the First Amendment, to exclude the evidence. And that gets to a point, Your Honor, about the First Amendment. We heard, and I recognize this is a large case, and I recognize there's a lot of paperwork, and I recognize that there has been stress and an incredible number of unique demands on every person, court personnel, lawyers alike involved in this case. But we heard it was only today when we received this case law and Carpenter gets singled out. Well, I'm looking at the state's first lyric brief, Your Honor. According to the stamp I have here, filed December 1st, 2022. Page 3. Relevant lyrics are admissible and do not offend the First Amendment. You know what case gets cited on page 5? Or in there? Carpenter on page 4. Now, it's a block cite from Carpenter. It's not cherry picking from Carpenter. And again, Your Honor, this is what we were told was only seen today. So Carpenter's there on page 4, which circles back to the state's initial argument about volumes of material have been produced by the state on this issue, and the record will speak to whether or not there's been an equivalent supply of authority the other direction. But I'll read directly from the block cite from Carpenter. Carpenter argues that his rap lyrics and music video were improperly admitted at trial in violation of Federal Rule of Evidence 403, as well as that the First Amendment protects his rap lyric as a form of artistic expression. The case, Your Honor, footnoted there at footnote 5 on page 4, again, December 1, 2022. And of all the allegations faced by the state today, being able to move back in time wasn't one of them. The Carpenter covers both issues. And it says here that it pertains back to the other Carpenter case, the earlier one, the one at 372 Fed Sup 3rd 74. Well, we have, again, go through the 403 and First Amendment. First, they address the 403 in Carpenter. Rap lyrics are properly admitted where they are relevant and their probative value is not substantially outweighed by the danger of unfair prejudice. And then there are multiple, then there's another federal case cited for that. And a district court can thus admit them after conducting 403 balancing. Cite to another federal case. Next sentence. The First Amendment is no bar to the evidentiary admission of rap lyrics, whereas here the artistic expression is not itself the prescribed conduct. So I could continue reading, Your Honor, but I recognize the court's reviewed the briefing in this case. That is right there. Over a year old, and somehow, and it's that this and other authority in this area was characterized as only appearing today. Now, Your Honor, that lets us know where we should go in terms of the First Amendment analysis here. The court performs that First Amendment analysis when it examines what use the lyric is being proposed for. That gets us back to the chart, Your Honor. Does the lyric form the corpus delicti of the crime? Is the speech what is being prosecuted? That's not the case here. And the cases we cited dealt with threats. A threat can be prosecuted for those words. But in this case, the speech is evidence of the crime rather than being the crime itself. Might go to mens rea, might go to actus reus, might go to both. And it might apply to building a racketeering enterprise. It might apply to building a gang enterprise. It might apply to association, to either, both. And again, it might prove one of the underlying crimes. So that First Amendment analysis that opposing counsel has been asking you to perform is exactly what the state has recommended. Look at the use, make the determination. But there's nothing here that takes us into the area of the speech being the prescribed conduct. Now going to the court's some of the court's other issues. The foundations for, and again, opposing counsel, one of the lawyers here, and I don't want to name names, it's actually admissions are under 801D2. 801D1 it deals with something different. The factors that lead to the introduction of an admission, a party admission or declaration against interest are well known. And who authored it is not one of the foundational factors. It might influence something like a 403 analysis, but in and of itself, it's not one of the listed factors there. But let's just take that argument lock, stock, and barrel for a second, Judge. And let's say somebody else wrote it. It was extreme. It was violent. It promoted the gang. And I, a YSL gang member, said it. All right. Now it's an adoptive admission. Just like in the RICO case, Judge. We talked, what we had earlier today, where the gang lyrics were posted by someone else who apparently changed them some, then put them up on his own site. So again, at best, that authorship argument takes us to an adoptive admission, which is going to be admissible again. And for those who are co-conspirators, admissible as if they had said it through the co-conspirator exception. And another factor, Your Honor, when it comes to First Amendment analysis, there was a string of cases that were gone through by the defense. Well, this isn't a First Amendment case and it's in the PowerPoint. And this isn't a First Amendment case and it's in the PowerPoint. We were down, I believe, to page 18 there, well past when the state was discussing First Amendment implications, and we were into actus reus, mens rea, and the various applications of the evidence rule. So those cases weren't presented in the First Amendment context. But yet that was, and again, recognize, Your Honor, there's been a lot of moving parts on this case, but I wanted to clarify that for the record. So we now look at the propensity issue, Your Honor. The introduction of what will wind up to be an incriminating statement in the form of an admission of one type or another, or declaration against interest, that is somehow relevant to a matter at issue in this case is not propensity evidence. We're not saying he did something bad before and therefore he is bad now. That's the forbidden interest under forbidden inference under Rule 404. That's not what this is. It's, we have things like me and my slimes above the law demonstrates that that YSL exists and there's a certain ethos there. That's a governing principle, Your Honor, that demonstrates that they're associated in fact in some way. So again, that's not to say that someone who's in a gang who thinks he's above law, that in and of itself, we're saying he did something bad and he did it again. That's just not a factor there. And even so, then the defense should have gone to every one of them and made an objection under 404 and challenged us to bring that into evidence under 418 or 404B. And that's not where we are here. We are on a constitutional and pretrial 403 challenge to this evidence.
I apologize. The state did not give notice under 404B. The state did not give notice under 418. That is their burden. It's not my burden to object for them. They blew those statutes. They can't do 404B or 418.
And it's nice that Mr. Carlson popping now, but he should know that it missed all these deadlines already.
May I be heard, Your Honor? Yes. Hey, no notice needed for intrinsic evidence. We've demonstrated how this is all intrinsic.
Excuse me. That's not 404B or 418. Just said 404B and 418. Intrinsic act, you don't need any of it. That's not what Mr. Carlson just said.
That's our point, Your Honor. They never made an objection that this was, they didn't bring the issue to you, Your Honor.
What Mr. Carlson is saying is going back. The state of Georgia cannot rely on 404B or 418. They blew the statute. They're supposed to do it prior to trial and prior to the hearing. A sufficient time. They did neither. To say now it's intrinsic, that is not what Mr. Carlson said a moment ago. So that's why I'm checking.
And they also blew their deadlines as far as identifying the lyrics that they tended to use. And then they're at the same time saying, well, we didn't object to these specific lyrics early enough, when they never told us until, what was it, November 6th?
Well,
this week?
May I be heard, Your Honor? Yes. All right, Your Honor. They're making my point. What I said was, this is not propensity evidence. That's why we wouldn't have had to notice it that direction. Does it form intrinsic evidence? Of course it does. However, nothing would have stopped the defense if they believed any lyric out there in the indictment or anywhere else should come through another route to file the appropriate objection. So, Judge, this isn't being offered for a propensity purpose. So, what we heard from the defense actually agrees with the state. We went to pains to demonstrate how it's intrinsic evidence. And again, for those guidepost cases we noticed, it's up to the objecting party to make a determination what they don't want in, especially when the evidence is relevant. That's Rule 402. So to say that somehow the state ought to And again, these cases talk about that being overly burdensome on the government. Go out and search and find certain matters that it believes it's going to bring in, it believes somehow would be objectionable, identify it, put it out there before the defense, who's actually the one who should be making the objection to it, is really the opposite of where much of that material goes. However, my colleagues on this case actually did go through and go that extra mile and provide opposing counsel and the court with a list, and then provided detailed information on how all of this integrates in the case through Deputy District Attorney Hilton today. So, Your Honor, in terms also of the Rodriguez issues, and I will point out for the court that the triangle diagram, as far as how 1615-4A operates, that was in Your Honor's materials in the PowerPoint, was designed by Mr. Floyd specifically for the argument in Rodriguez versus State. And the most compelling part of Rodriguez versus State is that the First Amendment does not protect association aimed at criminal activity. So, Your Honor, we go through those areas. We now get to 704B. And
what page is the triangle on, just so I can read
Judge, let me my PowerPoint is printed off a little differently, Judge. Oh, I might be able to find it. 28 is what I have, Judge.
It's going to be slide 28, Your Honor.
I see it. Thank you, counsels. I see it.
And again, Your Honor, the First Amendment issues in that first brief go page 3, 4, 5, and Carpenter in there. And incidentally, Judge, on page 5 after Carpenter, there is a block site with multiple cases discussing introduction of rap music evidence, as it called in there, in cases, and again, discussing its admissibility. So no surprises there, and actuality case law provided. Now let's talk about 704B, Your Honor. 704B does not prevent an expert witness from explaining what gang symbiology means, what might in the gang content certain lyrics mean. It doesn't prevent that at all. What 704B expressly forbids is experts invading the province of the jury by stating the state of mind of a criminal defendant if that state of mind is an element of the crime in which they're accused. In other words, it's a much different question is, well, within the context of YSL, what does I've got bodies on bodies mean, according to your experience as a gang expert, to, well, did the defendant act with criminal intent when he committed murder, in your experience? That's the forbidden inference in 704B. And even then, there are limitations. For instance, 704B does not prevent an expert from drawing conclusions about intent so long as the expert does not profess to know a defendant's criminal intent. So we see also, Chief Judge Glanville, on the issue of, if the court could provide me notice here, the expert witnesses, if I may have one moment, Judge. Expert witnesses providing information along those lines. I'm going to read now just quickly from United States versus Smith. Apologies for bending forward, Your Honor. 919 Fed 3rd 825, 919 Fed 3rd 825. That's 4th Circuit 2019. And again, talking about an agent testifying about coded terms among drug users drug dealers as an expert. Now, there's another case here from the 9th Circuit where there were some problems with the way the prosecution qualified the expert, but that's different than the content. That's United States versus Holguin, Holguin, 51 Fed 4th 841. 51 Fed 4th 841. That is a 9th Circuit case for 2022. Again, talking about experts giving the meaning of gang terminology. So, once again, Your Honor, the position that's somehow barred by 704B is just a misreading of 704B, which is sometimes called the Hinckley rule, related to the person involved in the attempted assassination of President Reagan. That's the period of time in which 704B came into being. So, Judge, now we take a look at several other issues that were raised. Let's just look a few times. Where is Delilah when it comes to, or Delia, when it comes to Johnny Cash? We didn't hear one thing from the defense that Johnny Cash was accused of killing that person. We don't know if there was even a murder. And in none of those cases where we had those supposed comparisons, did we have any mention of any motion from the state, motion for the defense, or ruling from the court on any of those issues. So again, those positions were of no moment. At best, they're alternative explanations, perhaps fodder for final argument, but not admissibility issues. The same goes, Your Honor, for some of the other areas that were covered. When we heard things like, this is all just fantasy. Your Honor, someone could look at that indictment and see one thing for sure, that's not fantasy. People are dead, murdered, and a gang exists. Those aren't fantasies. This terminology here, again and again and again, that Deputy District Attorney Hiltness and Special Assistant District Attorney Floyd went through, demonstrating the interconnections between these proclamations of violence and defiance and the crimes in this case. That's not fantasy, Your Honor. That is tragically real. And if the position is going to be taken at some point that somehow this is all just a form of artwork, again, as the cases have informed us again and again and again, that's jury material, not exclusionary statute material. So several other points, Your Honor. As to this, it was interesting, when we were speaking about Mr. Kendrick, the "for slimes I know I kill" line did not seem to be as much of a feature of the argument. That's definitive, that's forceful. But in terms of the song Dream, my colleagues have told me that the 2013 was a hypothetical. I'm looking to my left to make sure I'm correct on that. It was a typographical error. But regardless, and it's actually that 2015 date, I believe, is the correct one that the court read, and that would be in our more current materials. That was repaired. But that gets to this date with regard to 403, Your Honor, and when did something happen? You know, all of that discussion really seemed to bypass that we've got a racketeering and gang case here. And this criminal organization has endured. So statements that are going to relate to some factor that's going to build a gang count or build an enterprise count, per the decision of the Supreme Court in Kemp when it comes to the co-conspirator hearsay exception, they're not timed out because of some constituent crime, because they go to support the case of evidence leading to proof of the organization's existence, its nature, association with it, whether this crime represents participation in the organization. So that's not going to be part of the 403 analysis in the way that was conveyed, particularly in light of the other counts that are there. So in specific, the enterprise and gang counts. So this whole issue of threats, we're getting back a little bit into the court's First Amendment inquiry. YSL threatening to murder witnesses. YSL talking about, which is certainly threatening, murdering police in language that will be decoded in case. That's threatening. But it's not a threat that's being prosecuted for the words itself. It's proof of what YSL is, how it exists, and yes, the motives and states of mind that people who are going to associate with it, and whether or not that type of motive and that state of mind is going to make it more likely that they will associate with this criminal street gang, also known as racketeering enterprise. So it's, again, not a case where that threat itself or that threatening conduct is what's being prosecuted per se, as in a true threat case. The fact that they threaten people is demonstrative of the nature of the organization. Think about it, Your Honor, in a comparative circumstance of something like an admission by conduct. Somebody might flee the scene of running away from the murder. That's going to demonstrate consciousness of guilt of the murder, but they're not being charged with running away from the murder. The evidence still comes in to demonstrate the underlying offense. So, Your Honor, I want to take one more matter on. And again, I want to stress that point. The threats are proof of the crime here. The threatening conduct and misconduct is proof of the crime here. The threat does not constitute the crime here. Those aren't the charges. And Judge, there was a lot of talk about no other type of expression getting prosecuted this way. And I want to direct the court to our first supplemental lyric brief, which I believe was filed in late 2022 or early 2023. And I'm going to take the court to page 2 of that brief, where there is a block cite from the federal court of case from the Fifth Circuit of the United States versus Cannon, 750 Fed 3rd 492. 750 Fed 3rd 492. That's a 2014 case from the Fifth Circuit dealing with a hate crime prosecution. Convictions were affirmed. Again, Wisconsin versus Mitchell, major Supreme Court case, gets quoted once more. You've seen it, Your Honor. The Supreme Court has made clear that the First Amendment does not prohibit the evidentiary use of speech to establish the elements of a crime or to prove motive or intent. Then the court goes on. Moreover, our sister circuits have considered this issue, have all allowed speech-based evidence to support a finding that a crime was motivated by racial hatred. And there they cite a case that was in our materials, United States versus Magleby, Magleby, 241 Fed 3rd 1306, 10th Circuit 2001. Evidence that the defendant listened to CD with racist lyrics was relevant to establishing that the defendant targeted the victims because of their race. So again, Your Honor, as we've seen, and we haven't drawn a moral equivalency between the YSL rap, gang lyrics, and evidence of racist lyrics in hate crimes cases. But as we said before, there's a legal equivalency there in terms of the rules of admissibility. So once again, Your Honor, the gang lyric evidence in this case is proof of actus reus and mens rea, not only of the underlying offenses, but of the racketeering and gang charges. The state is offering these for the evidentiary purposes, and those evidentiary purposes alone. So we will reiterate, Your Honor, our respectful request that the court grant our motion for conditional admissibility and introduction of the lyrics we have set forth today under the controlling rules, the ones that we will bring to the court as the trial proceeds, and to deny the defense's motion. Thank you.
All right, counsels. I'm going to take the matter under advisement overnight. It's almost 9 o'clock. It's been well argued, well briefed. And what I'll do is counsels, we're supposed to start tomorrow morning at 9:30 with your firearms and other particular individuals that indicated to me tomorrow. What I'll do is I'll take the first part when we all come at 9:30, and I'll issue my ruling, and I'll tell whoever the prevailing party is to prepare a suitable order. So if you all could come back tomorrow morning for 9:30, I'll have a decision at that point in time, okay? All right, so State, Ms. Hilton and Ms. Love, are you all otherwise prepared for the firearms examiners, Mr. Barini, and microanalysis of the gun residue, the latent print examiner for tomorrow?
Yes, I see my investigator coming up.
Okay, all right. Well, I'll take those up as soon as we finish this. I will make this ruling, and then I'll cover as well. I have taken a look at the jail call between the three individuals to finish ruling upon that issue in terms of residual hearsay. Ms. Love, I was not, as much as I tried, I was not able to until later today. I got our tech guy to load the evidence viewer on my computer. So until I have a look at that, I'll go ahead and I'll continue to defer that issue. But I've read the transcripts of both witness A and B. I'd like to take a look at just finish taking a look at that. And then Ms. Hilton, I know we need to complete the other extra argument on 418. So I'm, depending upon where we are tomorrow, but my goal will be for us to make a ruling on this issue. So Mr. Carlson, if I could ask you and Mr. Floyd to come back in the morning, that would be definitely appreciative. And I'll make that ruling in first, and then I'll release it to you, and we can go on to some other things we have, okay? 9:30.
Yes, sir.
All right.
Your Honor, tomorrow is ruling on this lyrics issue and the blatant and print.
Can everybody please be quiet? All right. You didn't hear what I said, Mr. Steele?
I did. I got confused. Are we doing the residual? I know it's Mr. Matthews, but residual hearsay, and then I heard you say something about 418. That's what I heard.
No, I was stating that I listened to the tape, the jail call. So I know I need to rule on them as of yet, as of they're outstanding. I also need to rule on the witness A and witness B. In terms of whether or not they fall within 801 D2E and 1 issues. Those are the two. I need to look at I need to look at the tapes themselves. I wasn't able to get the viewer installed until today. The state's proprietary evidence reviewer. I have read the transcripts, so I still need to complete those. And then the 418, I have to complete the other acts. Ms. Hilton needs to complete the argument. Okay?
That's tomorrow, though. That's what I'm asking.
I don't know if it's going to be tomorrow or not. Okay. It just depends.
Okay.
I'm just telling you it's outstanding. I may pull the trigger on those tomorrow, but I know they're outstanding, and I just need to make a ruling on those.
Okay. Thank you, sir.
All right.
Your Honor, we haven't heard argument on the residual for the court.
On what?
We have not heard, the court has not heard argument as to the residual hearsay for the court to be able to make the ruling on that. The court has heard the jail call, but the court has not heard argument from both sides on that issue.
You got 15 minutes tomorrow if I decide to rule it. So you need to be prepared, okay?
Thank you, Your Honor.
All right. All right. We're in recess. See you all in the morning, okay?
Thank you, sir.
Okay.
Yo, hit that like for deal Christian. Yo, for deal Christian, smash that bell for the upsy. Yo, smash it, just smash it. Hit that like for deal Christian. For deal.
So here, let's look at this. Johnny Cash. All right. In 1965, he faces charges in federal court. What's he done? Allegedly. Well, he pled guilty. So he smuggled 688 Dexys, 457 Equinel into the U.S. from Juarez, Mexico. He pleads guilty in federal court, but he never has to face Delia's Gone. Delia's Gone, all these songs, by the way, are written before this. They could have used Delia's Gone, okay? She was low down, trifling, cold and mean, evil, grab my submachine. Your Honor, how long do you plan on going today?
I'll finish.
All right, thank you, Your Honor. Good afternoon, Your Honor.
All right, good afternoon, sir.
Doug Weinstein for Diamante Kendrick. Wow. Wow. That is a lot to respond to. How fun it is to set up straw men and knock them down. The state is saying that the defendants are asking for a special exception for a single genre of music. We are not. That is nonsense. We are asking essentially for the same thing that the state is. Use the Georgia rules, use the law, apply it in this case. But I will say this about rap music, and let's call it rap music, not gang lyrics. Or rap, you can call it rap lyrics. As Professor Dennis at the University of Georgia says, Rap is the only fictional art form treated this way. No other musical genre and no other art is used in the same way and to the same extent. And there's so many examples of that. Look at Kevin Spacey. Kevin Spacey is accused of felony sexual assault up in Maryland in December of 2018. He's played reprehensible characters in movies, repeatedly, in TV shows. None of that is dragged in. He's brought to court in the UK. I appreciate that's not the US. His roles are not dragged in. So we hear a lot of things about what Yak Gotti rapped. Yak Gotti is not on trial here. Diamante Kendrick is on trial here. And there's a giant elephant in the room, which is that we're ignoring art. There is art here, and the art has to be separated from the real life. And I do not believe, although the state does not address that.
But wouldn't the art fall under the First Amendment?
Art does fall under the First Amendment, Your Honor.
I'm just asking this, okay? Because, I mean, you know, we're all here to, I'm here to kind of make some preliminary decisions, but
certainly.
Wouldn't it, I mean, if my art or what I am, my genre or what I am trying to assert is just happens to be criminal in nature, or maybe a statement against interest, or maybe some other type of admission, would the same rules apply?
Well, I think what you have to do and what your task is, you're fortunate enough to have this task, is to separate what is the expression of a character, an artistic character, from what the author or the lyricist is saying. Lyricists write things for characters to say. That has happened in music for years. For years. I like John Prine. John Prine, when he was in his early 20s, wrote Angel from Montgomery. I'm an old woman who comes from Montgomery, who flies from Montgomery. No one thinks John Prine is an old woman. He writes hello in there about old people. But what they're thinking, it's not the same.
But if my lyrics or my artistic expression relate to an action or my mental state, wouldn't they be subject to being admitted, or a court considering them, or a fact finder, a jury considering them for what the reasons that they're authorized to?
Yeah, I understand, but only in rap music do you say that the person, the character rapping, the persona rapping, in this case, the persona Yak Gotti rapping.
Okay, that's just my name. That's my stage name. That's the name that I go under. I'm still tied to that particular person. Like, it's still tied to your client, right? Yak Gotti is your client's nickname, right?
Yak Gotti is
or stage name.
Yak Gotti is a stage name.
Okay.
That's correct.
All right.
But when Yak Gotti is rapping, it's not proper to take what he's rapping and say, that is the mental state of this person. That is what he is thinking. That's a perspective of his song, of his rap. And from where he comes from, he is expressing views that come out of that community. He is making cultural references. He is speaking. Am I going too fast?
No. I need something right quick. Thank you.
He's speaking.
1 second.
Sorry, I'm sorry.
Go ahead, Mr.
Ready?
Weinstein. Yeah,
Okay.
I'm ready. Go ahead.
He's speaking in the conventions of that genre of music. And in gangster rap, what do the producers, what do the record companies, and frankly, what does the audience expect? They expect these lyrics. So he provides these lyrics.
But if the lyrics fall under actus reus or mens rea, don't I have to first look at them under 401? As Mr. Carlson made this nice linear diagram, I like that because I'm trying to follow things from A to B, C to D. But why would they not, why could not the court consider those under that particular line or lineage?
I think that's a great line to look at it. Let's start with 401 and 402. Are they relevant? And the lyrics spoken as a character are not relevant to the actions of the person who inhabits that character on stage or on the album. There's a distinction between those that the court has to draw just to even see if they're relevant under 401, Your Honor. And then once you determine if they're relevant, let's assume they are relevant. I'm not there yet. I don't agree with that, but let's assume that they are relevant. Once you're determined that they're relevant, then you've got to do the 403 analysis. And
Well, actually 402.
402 and then 403, yes. But then the question is, I know what the state's going to want to do. Throw it out there to the jury. Let us put our competing arguments, our competing meanings before the jury and let them decide. But when you've got something that is unfairly prejudicial, which is what rap music is, what you'll hear Mr. Steele's experts testify about at some point, what you'll hear him proffer when he argues, they're unfairly prejudicial. And if you do not serve as that gatekeeper function, Your Honor, then that jury is going to take the meaning and perhaps misconstrue it or misattribute it. And that's just not proper. And
That's that. Well, it depends on one, whether it's admissible, and two, it depends on how good your advocacy is.
I agree with that, Your Honor. So let's see how I do today.
So yeah, I mean, it's for the jury, of course, to give it the weight and engage it within the confines of what they hear in this courtroom and the instructions that they get from this court. So isn't that ultimately, if admissible, what the jury's going to do? You're going to sift and weight this evidence?
But if it's unfairly prejudicial, Your Honor, it should not even
How would
come
you say
in.
it's unfairly prejudicial?
Because of the nature of the music, the violence in the music, the extreme language in the music, it is prejudicial.
Okay, but
If it was,
okay, I'm sorry. Go ahead.
okay,
Go ahead.
we'll get there. That's fine. And let's talk about why it's prejudicial. Part of it. In Ward v. Rock against racism, 491 U.S. 781, 810 would be the Penn site, note 7. Justice Thurgood Marshall quotes, he's quoting someone else, "New music always sounds loud to old ears." And that's what we've got here. New music always sounds loud to old ears. The state knows that. They know what this music is going to sound like to the jury. And it has always been thus so. When I was young, in my day, we listened to the Sex Pistols, offensive stuff. God Save the Queen, she's not a human being. Elvis Costello, I'll stand on your grave and tramp down the dirt. Butthole Surfers, all of it offensive. But people listen to that.
But they wrote it. I mean,
there's no other art form that is treated this way. There are other artists in other fields, country music, for example, that do not have to, when they face charges, they do not have to face having to defend the lyrics that they wrote or the songs that they sung. I would just like to briefly, and I apologize, I do not have a printout of this, but I can circulate it. It's only 4 slides, but I think it would just aid the court if I put them up rather than reading them.
Do you have them on a thumb drive or anything like that?
I can get that. I can email it to you if you'd like.
No, I was going to say you could share it on.
I can can we put it up on the screen? Thank you.
All right. Okay. Let's let technology do a little work for us. Okay.
Absolutely, Your Honor.
All right. Okay. All right. Okay.
Okay. Just briefly, I'm not going to belabor this point with the court.
And we'll of course, you can, for the purpose of this hearing, I'll consider it as D1, okay?
Thank you, Your Honor. Okay. So let's look at some people. And by the way, when I'm bringing these up, I am doing it under a similar analysis that you would do in this case. In other words, I'm going to argue that there has to be some nexus between the crime charged and the lyrics in the case. That is what, if you look at all the cases, there has to be some nexus.
What do you have to go to access reus or mens rea?
Yeah.
First. Okay.
So here, let's look at this. Johnny Cash. All right. In 1965, he faces charges in federal court. What's he done? Allegedly. Well, he pled guilty. So he smuggled 688 Dexies, 457 Equinel into the U.S. from Juarez, Mexico. He pleads guilty in federal court, but he never has to face Delia's Gone. Delia's Gone, all these songs, by the way, are written before this. They could have used Delia's Gone, okay? She was low down, trifling, cold and mean, evil, grab my submachine. Okay, next, please. Willie Nelson, famous marijuana user, loves it, advocates for it. In 2010, they found marijuana on his tour bus in Texas. 2006, 1.5 pounds of marijuana and 3 ounces of shrooms. You couldn't really speak directly about marijuana in country music in the 70s, but he alludes to it. So in his song, In a Memory, off the album Willie Nelson and Family, he says, I'm a love that you know from a song. I'm a voice on a green telephone. I'm a day that lasted so long. 1971, they did not bring this up. It was not used against him.
You're saying he was under the influence of marijuana?
When he wrote that, Your Honor?
Or maybe some other...
well, I'm not going to say what Willie was doing then, Your Honor.
Okay, all right.
Next, please.
I'm with you.
2006, Glenn Campbell, not his best look. Okay, he's charged, and by the way, there's a connection, charged with aggravated assault, drunk driving, hit and run. Here's his song, Tequila. I was at the, and I'm not going to sing it, Your Honor, so you'll have to forgive me.
Did he write this song after the Before the, okay.
Every song I present to you was written and released before the charges.
Okay, I'm with you.
All right. I'm not going to be sneaky that way. I was at the bar with my drinking team. It was me, Jack Daniels, and my honey, Jim Beam. We were kind of blitzed. Thank you, Your Honor. Would you like to perform it? Because I know that you're famous on the internet for your rap lyrics.
That's other people pirating me. Okay, so.
I know a good copyright lawyer.
All right.
But here's these drinking songs that are not brought up against him. Next, please. This is the last one I'll do. Tim McGraw and Kenny Chesney, charged with disorderly conduct, and McGraw is charged with a felony for assaulting a police officer in 2000. And I believe this is a Chesney song that was released before then. It's a great song. It's the simple things in life, like the kids at home and loving wife. I'll just jump to the end. The devil takes your hand and says, no fear, have another shot, just one more beer. Next, please. Last, this is not a song, but it's a statement of frustration from a singer and a songwriter. That's the frustration that I bet all of the defendants in this room feel. David Allan Coe wrote the most racist, offensive country music probably ever recorded. Released them on underground albums. I am a songwriter, you know, and to me, it has always bothered me that actors in the movies can say whatever they want to say, kill people, rape people, and do things that no one ever accuses them personally of being that way. But when you write a song and then all of a sudden you're being accused of something, to me, songwriting is painting a picture, and all you have, this is important, all you have to work with is words. That's all they have to work with, words. It's stereotype stuff, and he's talking about the racist language he uses. It's stereotype stuff that you hear growing up that immediately puts a picture in your head. What Mr. Kendrick is singing about is what he grew up around. What else is he supposed to sing about? He's not going to sing Daydream Believer. He's not going to write that song. He's not going to write about puppies and rainbows and unicorns. This is what he writes about. And now it's being dragged out, and he has to sit in this court and defend. He knows he has to defend these charges, but to have to defend the lyrics that he's writing? Come on. Come on. Gosh, thank you. That's enough. You can turn it off. Anyway, I'll be happy to circulate this later.
If you'll send a copy of that to your colleagues and Ms. Weaver, please.
Absolutely, Your Honor.
That'd be fine, sir.
Okay.
It'll be D1, as I said.
Thank you. Your Honor, in instances where courts have admitted rap lyrics, it's all about the connections. as you've heard today already. Look at Wilson v. State. That is a case that the state has cited. Wilson v. State, 315 Georgia, 728. It's a 2023 case. And in that case, the Supreme Court of Georgia said, sure, you can let in this rap video. That's appropriate. But let's talk about the rap video that was admitted, which you didn't hear about. It was shot 11 days after the robbery and murder at issue in that case. And what's it show 11 days later? The defendant's flashing a gun that could have fired the bullet recovered from the victim's body and singing about hitting his first lick. In other words, committing a robbery. So the court said, well, given the probative nature of the video and it not being unfairly prejudicial in light of its probative value, then according to Wilson, the video being admitted was proper.
What was it admitted for the purpose of?
I would have to pull up that case.
If you can tell me. If not, I'm going to pull.
I can't tell you right now, Your Honor.
Now anyway, so.
But I believe it was admitted for evidence of guilt, but please let me get back to that. This case is different. Oh, did y'all put up the bodies on bodies line over there? There we go. Hey, how you doing? I'm Yak Gotti. I got bodies on bodies. Okay. When Yak Gotti is rapping that, first of all, he's not rapping about killing people or allegations relating to the tragic death of Donovan Thomas. He's not rapping about that. What's he rapping about? What is this young guy rapping about? He's rapping about sleeping with a bunch of women at the same time. Or maybe not. Maybe that's not it. Maybe he's rapping about when he was a high school football star over at Grady. And he was laying people out on the field, bodies on bodies. He's not rapping about a murder that happened 11 days before the song was written or performed. He's not flashing guns capable of firing bullets found around Donovan Thomas or bragging about committing his first murder. So it's a different situation. You know what's more analogous is U.S. v. Stevenson's 550 F sub 3rd 1246 from the Middle District of Florida in 2021. The U.S. attempted to introduce 3 rap videos against the defendant charged with possession with intent to distribute marijuana. In rejecting the admission of those videos, the court said there was no evidence as to when the lyrics were written, the songs recorded, or the videos edited. And they concluded that the videos were too remote in time to have much probative value, or were even of dubious probative value in this case. Where's the evidence of when these lyrics were written and recorded with respect, in time, with respect to these underlying allegations? I don't see it here. I don't think it's been presented to you today, but I'll tell you, and I'm going to go through the 6 specific lyrics. I'm not going to take much time, but I'm going to go through the 6 specific lyrics that they want to introduce, or they've said they're going to introduce against Mr. Kendrick. And you'll see that they're too remote in time.
So you're saying that reference is something, 2 other things that potentially Mr. Kendrick was involved in, playing football or getting with ladies? Is that what you're saying?
Here's what I'm saying. That unlike our United States Supreme Court that thinks they're experts in history, I think that courts are experts in law and that they shouldn't get into the business of musicology and trying to figure out what that rap lyric wrote when Mr. Kendrick wrote it or performed it.
Okay, let's go back to Wilson. Wilson, the dope video that's referenced in there, it references the murder weapon. It connects the murder weapon and implicates one of the defendants in the
Absolutely
close in time. So I don't know what this particular thing is going to be tied to, but one of the state's theories is, as mentioned by the state, is that bodies on bodies is that he's been involved with some homicides.
Okay, so I don't know about some homicides, but he's accused of one in here. But the bodies on bodies, let's see when that was released. I'm going to look to that real quick. So I have it here. 2013. That was from Dream, released in 2013. And there's a distinction, by the way, between when something is written, when it's recorded, when it's released. But it's released in 2013. When is the Donovan Thomas murder? 2015. 2 years later. So what does bodies on bodies have to do with the murder of Donovan Thomas? Nothing. Nothing. Why is it here? It's here because it's prejudicial. The state knows this. That's why it's here. That's why rap music is introduced. That's why no other genre is introduced, because rap music is inherently prejudicial. I don't want a special exception for it. I just want you to do the 403 analysis, Your Honor.
So you're saying it doesn't have any linkage? Is that what you're saying?
Zero. If I could say less than zero, I would. No linkage.
Yeah, sure. And before I move on with that, hold on 1 second. I thought he released Dream. Is that what you're saying this song comes from?
Yes.
And that was
well, that's what the state says it's from, yes.
I thought that was released April 17, 2015. That's what I show on the state's page 43 of state's 18.
I pulled this 2013 from the state's particularized motion.
So I think it's released on Apple Music April 17th of 2015. When was Mr.
Oh, recorded 2013. Recorded 2013.
But it was released April the 17th of 2015. When did the homicide occur?
January 2015. But if it was recorded in 2013, how in 2013, recorded, correct? How when recorded in 2013 did Mr. Kendrick know that Donovan Thomas was going to be murdered in January of 2015? Did he record it, keep it in his back pocket, and wait for the murder to release it? I think that's absurd.
Okay, all right.
You can take...
All right, well, that's one.
Oh, you're on? Oh, I'll go through them all.
That's one. Well,
I got time.
Okay.
Let's do it. All right. I'll get there in just a moment, though, Your Honor. I'm not going to go State versus Skinner, up through State v. Skinner again. It's been beaten to death. But that's the New Jersey Supreme Court case that we reference in our briefs, where they basically throw out the rap lyrics, identifying with Bob Marley, et cetera. But again, on the unfair prejudice, let's look at I'm going to give you a quote from Old Chief v. U.S., 519 U.S. 172, Penn site 180. As the Supreme Court has held, the term unfair prejudice as to a criminal defendant speaks to the capacity of some concededly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offense charged. That is exactly the risk, that is the danger of admitting these rap lyrics in this case. And look at Rule 404B. Introducing these rap lyrics, I think the clear intent is to show the character of Mr. Kendrick, and that Mr. Kendrick has a propensity to commit the crimes alleged in the indictment. Look at this evil rapper and listen to his words. They're terrible, horrible. Listen to what he says. What a piece of crap character he is. Who else would sing these songs? Who else would rap this music? Heaven forbid our kids hear that. That's not appropriate use. It's not appropriate use. I'm going to leave the state's other arguments right here to Mr. Steele, but I do want to go over the particular lyrics.
The rest of your lyrics.
Yeah, I'm going to go over the lyrics right now.
Let's talk about your lyrics.
Let's talk about lyrics. Let's go. Okay, back. I don't know. We'll just go one by one to make sure I hit them all. We've already talked about bodies on bodies.
Okay.
Okay, but again, what is the probative value of something recorded in 2013 to something that happened in 2015? It's got none. And I will not concede that Yak Gotti and Diamante Kendrick are the same person, just as I would not concede that Ian McKellen is Iago. You know, it's not the same situation. This is a character that he portrays on screen, in videos, in concert, but that's not Diamante Kendrick. Bodies on Bodies has multiple meanings. A convention of rap music, as I've been learning, is the importance of double and triple meaning. Finding double, triple, quadruple meaning is it's a critical skill to the lyricist in rap. And that's what you've got with things like Bodies on Bodies, multiple meanings. Let's assume, go ahead, assume Bodies on Bodies means dead bodies in the streets. Assume it means that. Whatever, 2013, Mr. Kendrick doesn't have any accusation that there are bodies on bodies there. And it's a convention, it's what his audience is looking for and demands in gangster rap. But it has multiple meanings. No proximity between the time of the recording of that and the unfortunate death of Mr. Thomas. If you let it in, there's a high risk that the jury is going to misinterpret that. And it will unfairly prejudice Mr. Kendrick.
Okay.
All right, next lyric.
On to the next.
I've only got 5 more, Your Honor.
Okay, all right, that's fine.
Next lyric, running from 12, then I jump through the fences. Again, it's sung by Yak Gotti, his alter ego, you could argue, but it's his stage performance. It's his name on stage. And again, we've got ambiguous, multiple meanings. What is 12? Running from 12. Is it running around his neighborhood at the age of 12? He had a friend named 12 when he was younger. Is it running with his friend named 12? Or is it the police? Or is it all 3? Or is it, as good artists do, is it up to the listener to decide what it means? Unfairly prejudicial. Lyric, I rep my life for real, for slimes, you know I kill. Take it to trial. Again, I'm going to argue that that's a lyric sung by Yak Gotti, the character, and not Mr. Kendrick. But regardless, I kill. Now I know I have said I killed it. I pray that when I walk out of here today and someone says, Doug, how'd you do today? I'm like, I killed it. I probably won't say that, but you never know. I kill refers to doing a great job when you're rapping in the studio. I kill refers to making money for the label. Multiple meanings. But the problem is, which one is the jury going to take? Next lyric. Excuse my language. Fuck the police, fuck them in a high speed from Slime Shit, March of 2016. Again, a lyric sung by Yak Gotti. It's a reference. It is a call out, Your Honor, to NWA with their famous song, Fuck the Police. It is social commentary. NWA sang it as social commentary. The character Yak Gotti sings it as social commentary. It's common. It speaks to so much in that community that I'm fortunate enough to not be able to really relate to, but what they deal with on a daily basis. But what is the jury, try as they might, and I know they're going to try hard, going to say when they hear fuck the police? One more, 2 more. Knocking off your big homie bitch, Mob Ties, April of 2020. Again, that has minimal value. And if you watch the video, and I'm sorry, I don't have it to play here today. If you watch the video, when Yak Gotti says, knocking off your big homie bitch, it is a call and response. Someone else says it, and then he repeats it. It's a long tradition in music. I mean, you can go back to Cab Calloway. You can go back. It was imported from Africa. Repeating things is a common trope, a common musical issue. And Cab Calloway, Michael Jackson, Missy Elliott, they all do it. They all repeat things. It doesn't mean he adopts them. He's in the video in a call and response situation. Last, YSL, wipe a nigga nose. Yak Gotti is in the video. He does not sing that. He is just in the video. And appearing in a video and nothing more should not be adoption of a lyric.
Well, do you have a choice to be in the video?
Well, do you?
I guess that's a question.
I mean, we all have jobs.
I guess that's a question that the jury will have to kind of ponder, right? I mean, it's not like somebody's filming and they walk up and they catch you in it where they got to get a release. I mean, but to play it, but or to put you in the video, but if he's standing behind or is one of the background people in that particular video or that song, isn't that something the jury is going to have to sift out?
I do not think you can go to look at what Diamante Kendrick is thinking or what he's adopting based on what someone else is saying in the rap music video that he's in. Yeah, he's there voluntarily. He's not chained there, but that doesn't mean that he adopts that.
Okay.
And I'm just going to go back to this, Your Honor. It is only rap music, and you have to ask, that has to defend this. It's only rap musicians that have to come into court. And don't tell me, anyone else, that it's because only rap musicians get in trouble with the law. That is not the case.
Not relevant for each case has to be taken on its own individual merit.
Exactly. And so when you see all these other cases cited where rap music is admitted, all that I ask you to do is make an independent assessment for this case on a lyric by lyric basis, whether those lyrics are appropriate to be admitted or whether they should be excluded under 403. That's all I ask the court, Your Honor. Okay, thank you.
All right, Mr. Steele? Okay, all right, Mr. Short? We'll take 5 minutes. Everybody should take 5 minutes. We'll come back, okay?
Hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for the upsy. Smash it, just smash it. Hit that like for deal with Christian.
Good morning, all. Okay, let me go ahead and like I said, when we recessed last night, courts had an opportunity to ponder the issues that were presented yesterday in terms of the admission of lyrics or the exclusion thereof. So to that extent, the court has considered the state's motion in limine to admit evidence of lyrics, the state's supplemental motion in limine to admit evidence of lyrics at trial, the state's amended particularized motion in limine to admit evidence of lyrics at trial, the opposition to the state's second supplemental and motion in limine to admit evidence of lyrics at trial filed by and on behalf of Mr. Kendrick and argued by Mr. Weinstein, as well as Jeffrey Williams' motion in limine number 2, 1, and 2 to motion to strike, as well as Mr. Shart's oral motion, and the court will also consider it for any other lyrics that may be sought to be admissible in the trial of this matter. Specifically, I have considered the arguments of the state as well as the arguments of the defense. I'll kind of go through those in just a second. The state has argued that this particular gang lyrics or evidence is admissible for several reasons. One, to show actus reus or mens rea, or other offenses under 16-14-4, 16-15-4, or 24-8-801D2 alpha, 28-8-801D2 bravo, 24-8-801D2 echo, and 24-8-804 B3, specifically, as well as 16-15-3, 16-15-9 for those particular relevant purposes. The court is well aware that there are several gatekeeping functions that the court must perform in determining logical relevance under 401, presumptive admissibility under 402, and legal relevance under 403. The defense has argued that use of these particular, the admission and use of lyrics, poetry, or artistry against Mr. Williams or any of the other named defendants as appropriate in this upcoming trial would be a constitutional violation, abuse of discretion, too prejudicial and unconstitutional based on the provisions of the U.S. Constitution as well as the Georgia Constitution, and that moreover, using these lyrics, poetry, artistry, speech against Mr. Williams and others would be racist and discriminatory because the jury would be poisoned, prejudiced by these lyrics, poetry, artistry, speech as the same as unlawful character assassination. The defense has asked me to exclude or these particular lyrics, poetry, words, speech, or artistry from the indictment and exclusion from testimony and evidence pursuant to 24-4-401, 24-4-402, 25-4-403, and 24-4-404A, as well as the constitutional provisions as set forth in the Georgia and U.S. constitutions. Mr. Williams, as well as others, have asked this court to further suppress any video, photographs, posts, or images that deal with these particular lyrics, words, speech, poetry, artistry, to be excluded from trial as well in total, and that these videos are protected speech as articulated by the same aforementioned provisions of the Georgia as well as U.S. Constitution. And as I mentioned, these arguments, the court's going to apply as to all parties, not just the ones that argued yesterday, Mr. Steele, Mr. Sharp, and Mr. Weinstein. The court also, in considering this particular ruling, considered under the provisions of 24-1-104, which is the conditional admissibility or screening determination that this court may make. And I'll cite from our code, preliminary questions concerning the qualifications of a person to be a witness, the existence of a privilege, or the admissibility of evidence shall be determined by the court subject to the revisions of the subsection B of this, and that's on relevancy, depends on the fulfillment of a condition of fact. Court shall admit it upon or subject to the introduction of evidence sufficient to support a finding fulfillment of the condition. So if I have to look at A before I can get to B, but it also mentions that subject to the revisions of subsection B of this code section, in making this determination, the court shall not be bound by the rules of evidence, except those as respect to privileges. Preliminary questions shall be resolved by preponderance of the evidence standard. And then B covers the relevancy of a condition of fact so in this particular circumstance, the court's just making a preliminary admissibility determination. Of course, anything that the court may rule upon at this point in time will be subject to a complete foundation being met and may be subject to other additional objections. But the court has considered, in terms of 104, states 1 through 20, as well as defendants 1 through 4. Mr. Weinstein, thank you. We got the PowerPoint you presented yesterday. We also have D2, D3, which is, I believe, the drive, and D4 presented by Mr. Steele, and D4, which was the chart that Mr. Steele circulated for the courts and parties' consideration. So I've considered that universe of conditionally admissible evidence for my consideration on the ruling, on this particular ruling. The court has also further considered in making this ruling the commonality of specific lyrics as they relate to the issues of mens rea and actus reus. Also, the court has also considered that depending upon the proof presented in this case, and that YSL, its and testimony that may be relevant of the gang's organization and or strength would be relevant. The court has also considered that these particular statements are being offered to show the elements of the offenses and not the threat or conduct is not being prosecuted, but these particular lyrics can be associated with different things that the court mentioned that the state has proffered in States 19. As it pertains to the First Amendment assertions raised by Mr. Steele and Mr. Weinstein and Mr. Sharp under the First Amendment, the court has in fact considered Carpenter among other cases that were cited for the court's consideration yesterday, and that these lyrics, that rap lyrics are relevant, and they must, that the court must conduct a 403 balancing test, which it shall. In terms of the First Amendment analysis that Mr. Steele suggested I needed to conduct, I do have to conduct that, and I have conducted that in looking at the use of the statement, or is it being admitted for a proper purpose. I know that Mr. Steele argued very eloquently yesterday about it being character or improper character, propensity. It's not being admitted for improper character, as that would fall under the court certainly screened under certain other evidence standards. And the propensity argument that was made yesterday, this, as mentioned by the state, this evidence is not being admitted saying that Mr. Williams and any others did these things before, so they do them again. So I'm dissuaded as to the propensity argument. As it pertains to the issue of mental state, argued under 27-7-404B, expert witnesses, if qualified, may draw conclusions about intent as long as they don't state that this is the defendant's intent. So to Mr. Matthews, and your continued argument about that, as long, and Mr. Steele as well, as long as those experts do not cross that particular line, those particular things would be relevant. I've also considered United States versus Smith at 918 F3rd 825, that assuming a foundation can be laid, certainly, and if it's within this can of expert testimony, that certain terms or technology or terms and or symbols or signs may be appropriate and relevant, giving meaning to gang determination. And then, so for those particular reasons set forth therein, the court is going to admit for the limited purpose thus far, the state's request to apply the evidence statute is written. I'm going to conditionally admit particularized lyrics, and those lyrics are found within States 18. There's 17 sets of lyrics. They're from pages 41 through 49 of States 18, 41 through 41 through 49 of States 18. Submitted for the court's consideration yesterday. Those specific statements, the court will admit I'll conditionally admit those pending lyrics, depending upon or subject to a foundation that is properly laid by the state or the proponent that seeks to admit that evidence. And to that extent, I have also considered the Taylor, White, Torres, and the Commonwealth versus Knox cases, and I find this to be the conditional admission of these particular lyrics are proper. I would just ask the state, or just remind the state, if any other lyrics are sought to be admitted, that I'd have to go through this same analysis. And if you would do so prior to us putting a jury in the box, that would certainly be helpful. And I'm going to deny the defense's motions at this point in time as to the reasons that they have alleged. And I'll note that there'll be a continuing objection as to those. Mr. Carlson, could you?
All right. Thank you so very much, everybody, for tapping in with me on today. Just wanted to, as we're getting ready for hopefully what looks like it might very well be the last week of YSL. There's a rumor going around, maybe like the last 5 days. Let's call it the last 5 days of YSL. So I wanted yesterday to go over the opening statements. Lots of you all got a lot from those opening statements, so definitely check out that video. Let me make sure the link is in the chat as well. But then also today, I just want to go over, I don't know why, the rap lyrics one really bothers me. It really does, because I don't think it's being used properly. And there were some good arguments in there. I just dropped the link to the opening statements, the whole montage that we watched yesterday. It's in the chat now. And there definitely are some good arguments, I think, on both sides. I think there's some good arguments on both sides. But the problem, in my opinion, is kind of like the Johnny Cochran rule. If the glove don't fit, you must acquit. If the crime doesn't match the rhyme, you must acquit. Okay? So if you're talking about somebody who's being accused of running over gerbils, right? But they rap about throwing rocks at pigeons, those don't go together. And that's kind of like with the Johnny Cash argument. I think the Johnny Cash argument is bad for everybody. I'm sorry. He was caught smuggling drugs. What he did with Jolene is completely a non-issue. But some of those other ones, like the guy that was talking about getting drunk and he had a drunk driving accident. Okay. The guys they're talking about at the bar, and then they had a disorderly conduct. I think you can make that case. But really, in my opinion, the reason why they wanted so much to get these rap lyrics in is because it helps bolster the very flimsy, very looking for Waldo case of RICO. What I mean by that is they were able to cobble together a lot of bad deeds, overt acts, and such like that from the rap lyrics and from the social media posts. If Judge Glanville was a little bit more strict on that, this case would have went in a whole different way, an entirely different way. But, what do you think? Down in the comments, let me know what you think. I appreciate you all tapping in. Thank you so much for your support of the channel. Thank you so much to everybody who's liked the videos, who's commented on the videos, watched the videos. All those things go very far to help support this channel, and I really do appreciate you. Thank you to everybody who's dropped the super chats in the last couple of months. Let's just say it up front. You guys are the real MVPs. You guys and gals are the real MVPs. Gifting memberships and sharing these videos out, all of that stuff. Thank you so very, very much. I really do appreciate it. It does not go over my head that this is the best live chat because of you. So I want to say thank you again. Thank you so much, Raynette. I do want to hear what you think about that book, Rap on Trial. I would love to hear. Mo Justice is supposed to be reading it as well. If you want to, I'd love to hear your thoughts. If you want to come on camera, we can do a little book review of it. I'd love to hear what you think about the book. And do you agree with me that the book doesn't support both of them? You could tell the prosecution and the defense both read that book, but I don't know if they understood fully what the gentleman was trying to convey, which I don't think is it. And sadly, it's all over the place. This is not the first time, not the second time, not the 2 millionth time that rap lyrics have been used, and dare I say abused like this. So I really want to hear what you think about it, Raynette. So definitely let me know if you finish it, if you want to talk about it. I'd love to hear your thoughts. Back to my point. Thank you again, everybody. I really appreciate all that you all do to make this channel effective, make this channel the best live chat on the planet. It's because of y'all. So thank you again. I appreciate it. Enjoy your Sunday afternoon. Enjoy your Lord's Day with your family and friends. If you're somewhere abroad and you're already in Monday or whatever like that, happy Monday. I'll see you guys real soon. And until then, everybody, grace and peace.